Yes.
Pardon to mention, my lord, one contempt matter. It was on a list.
Urgency, sir. What do you contempt urgency?
My
or fresh na after notice na kor.
fresh matter by
notice जाइए ना जाइए
जाई ना
fresh लिखी दे
fresh लिख दी
और yes
supplemental list phase 2
item number 5, my lord.
phase 2 item 4 to
5
to 13
5, my lord. You lots may call this matter after vacation. I have to file.
Mr. Ashok Das for the petitioner.
Yes, ma'am. I have to file the limitation petition.
The matter was presented before this court.
Yes.
On 25/2022 and for the last more than 4 years, 4 years and 4 months, nothing has happened. As far as it was it remained defective. On 1/5/2026, defects were directed to be removed. And the matter was listed before the Deputy Registrar Lojima. On 11/5, the matter was listed before this bench, and as stamp reporting was not done, stamp reporting was directed to be done. The stamp report points that there is a delay of 7 days. The IA has not been filed, condoning the delay. The learned counsel for the petitioner. So, the matter being in the list for fresh admission is mentioned by the learned counsel for the petitioner, seeking adjournment. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing 13/7/2026. Copy of this order shall be forwarded to the learned judge, Family Court, Barampur, Punjab, to be kept in the records of criminal proceeding number 331 of 2018, disposed of by judgment dated 11/10/2021. Yes.
Item 6. Item 6.
So, what's your name, sir?
Vilenka. 2 weeks after.
The matter being in the list for fresh admission is mentioned by the learned counsel for the petitioner, seeking adjournment. Earlier, the matter was heard at some length on 29/4/2026. The provisions were noted, and the learned counsel had adjournment to address on the provisions of law, to grant further opportunity to the petitioner. List for fresh admission in the week commencing 13/7/2026.
11, my lord.
Yes, 11.
I am talking of party.
Yes.
After vacation, maybe we shall file
So, Mr.
counter in this case.
Let it come. Let it come after this.
We shall file counter.
Fresh as
No, fresh as but it is.
Mr. Somnath Mishra for the petitioner, Mr. N.D. Tripathi for the opposite party, along with the standing counsel Amarendra Prasad Ray. The learned counsel for the parties mentioned the matter at the beginning of the day's proceeding. Stop. The learned counsel referred to the order dated 24/3/2026. Stop. The adjournment is sought for on behalf of the opposite party to file counter. Stop. The matter shall be listed for admission in the week commencing 20/7/2026.
phase 3 14 to 18
Since the interim order is in the nature of a continuing order, no need clear continuing order. Okay.
And if necessary, I will be filing a rejoinder after getting the.
Of course. Yes. এটা পূর্ব কাউন্টারটা পড়বে तापर से ऐड करिवे काउंटर बी फाइल बाय केबे को रखिले 20 केबे से 29/6 ठीक अछि काउंटर बी फाइल बाय 30/6/2024 upon serving copy thereof on the learned counsel for the petitioner stuff. The petitioner shall have the liberty to file rejoinder if so advised in response to the counter. तापरे adjournment देखा लिखिबो. Yes.
Page 3, 14 to 18.
Yes.
Page 4, 19 to 24.
Minutes, item 22,
Yes.
your lordship remember this is that OCA matter, election matter.
Yes.
A lot of senior counsels are appearing there, my lords, against a lot of parties. Only I've only one limited prayer, my lords. Your lordship may give me a date in the first week of July, and in the meantime, my lords, can we have a my lords noting that the peremptorily it should be fixed for hearing, because there was already an order.
Completed. Let the pleadings be completed. I think I don't know whether I have passed that order.
Yeah, your lordship has passed that order that counter should be given by the end of April last week. They never gave.
You are saying that the pleadings are not complete.
No. Pleadings, my lord, they have filed a maintainability application. 2 maintainability applications have been filed.
And counter has not been filed.
No, counter is not necessary. These are basically legal issues they have raised in the as the issue of maintainability of the writ petition. So it's a legal issue.
Okay.
So I'll answer the point of law.
22 रे लिखिबे the matter being listed for orders is mentioned by the petitioner. Appearance जहाँ से share होइबो ହେଲା mentioned by the learned advocate on record Mr. Kejriwal.
Well, it is there in the court.
The senior advocate along with Mr.
Kejriwal.
Actually,
Abhishek Kejriwal.
so I could remember A, but sometime I thought that Arvind.
No, my difficulty is the structured attempts to only delay the writ petition, it will become infractious. We are for election. Whichever way your lordship decides, my lords, we have absolutely no issues.
But in High Court's 2026 matter, if it is delayed, sir, it can be. You see how many.
The difficulty is this, man.
No, absolutely. Your point is well taken.
The difficulty is this, but there's a election will take some time.
Prabhu Prasanna Behra for 1 and 8. Gautam Mukherjee, senior advocate along with Amlan Mishra. Jaha pachare je affidavit appearance lekhi. Marik babu. Mane appearance ta ei debe avtara. Bulbal karibe. The matter being in the list, matter having been listed for orders is mentioned by the learned senior counsel. Sorry, mentioned the lekhle by Mr. Abhishek Kejriwal for advocate on record. It is submitted by the learned senior counsel that the matter requires urgent hearing upon completion of pleadings. Stop. It is submitted that preliminary objection regarding maintainability has been filed.
Mallards.
Preliminary objections regarding maintainability of the writ application has been filed by all. Now,
only 2 applications have been filed, but that all encompassing.
By OP6.
Mr. Mukherjee has filed and Mr. Pal has filed. Jaripal is with Mr. Ashok Mohanty. He's been led by Mr. Ashok Mohanty.
But now
Thila bodhe lekhithile apna sir.
Order ta apna physical copy diyantu. Ei order ta match karuni.
Your lordship had noted down the dates.
Yes.
Noted down. So it's a legal objection. So I can also I can also choose not to file a reply. It's a legal issue. I can reply.
My brief is not updated.
Mallards.
Digital copy has some. और आपण केते समय नौचंती भी दवा पे पढवा पे केते समय ने फाइल ता दे परिबे Firistin pore last order was Firistin.
It was
हाँ से लिखी ना आंती है अच्छा सर so I mean there is a defect in typing.
Mallards.
Appearance would have been लिखी ना आंती order टा लिखी जल्दी सेटा mistake.
It happens.
Yeah, you too. Preliminary objection regarding maintainability. Preliminary order छाड़ देले. Again कौन? Again डाकनी है. Preliminary objection regarding maintainability has been filed on behalf of the OP number 5 and OP number 6. Stop.
Copies have been served.
Copy has been served.
My lords.
Copy has been served. 6 में 3 या 7 फाइल करना है objection. तो आपण को जन से धीरे-धीरे फाइल करियो.
That is the structured attempt, my lords. Your lordship knows it. I need not. So I am only that let it be heard. Which is your lordship.
So, Sir Mr. Kejriwal, stop. Council, senior counsel submits that he shall address in response to the. He shall make his submissions in response to the objections. Preliminary objections.
Since it's primarily an issue of law, legally.
And the matter may be listed, fixing a date. Stop. Accordingly, the matter shall be listed for orders. For orders in the week commencing. Available?
No, sir. I'll be first week of July. I'm there. I'm coming in last week. हाँ sir.
6 week commencing 6
7 को डेट दे देले भी हम सर 7
डेट तले गोटी डिफिकल्टी होची सर जोडा डिलिस्ट हे गला बाय चांस बिकॉज़ ऑफ
सर
सब जगह लिस्ट करी कि एक्चुअली माने नाही बिकॉज़ ऑलरेडी देखे ना खाली ओडे लिस्ट करियाटा अट्रैक्टिव लागे बेले बेले व्हाट इट इज
माय लॉर्ड्स
so at least they are able to adjust it.
My lords.
Once there is judicial order listing section and
my only anxiety is let there be a notice that it should be heard. That's all.
yes.
It should be heard finally.
We commencing 6
Should be heard finally that noting may be there, my lord. So that only some observation so that they are also put on
on the
alert.
state date efforts shall be made for hearing of the matter at least on the preliminary objection.
On maintenance of the my lord.
The parties shall complete their pleadings and exchange the same by
My lord, in the vacation.
by consume to by A के साथ
Again.
29 कर दो रिओपनिंग पर अच्छी ठीक है
तो आगुरु सर आपन ऑर्डर थिला they were to complete their pleadings by 24th बोले ऑर्डर थिला 24th April ऑर्डर थिला
लाइन ऐड कर देबे प्रोडक्ट सीनियर एडवोकेट टोटल सबमिशन लिख ले he refers to the earlier order dated 30
ना 30 दिन पूर्व ऑर्डर था
30 नहीं है 24 पे
30 दिन
हाँ
हाँ 30 दिन अच्छी है सर
and submitted there is already a direction
मैंने
the direction to complete the pleadings by 24/4/2026
24th
it is yet to be achieved by the parties है ना तापर जो लिखले pleadings complete है एटा तार संगरे रह उठले जोकी रखले कोटे जगह रखले appearance देखो appearance आपनकर अच्छी एक्चुअली को स्वभाव has been missed प्रभु प्रसन्न बेरा 1 and 8 Mr. Jadip Pal along with
Mr. Ashok Mahanti
the senior counsel UP5
Lalat Sindhu Samantra is also there Mr. Lalat
Abhijit Patnaik UP2
no Abhijit Patnaik instead of Abhijit Patnaik I think Pamiratha was appearing Pamiratha senior advocate
Abhijit along with or Abhijit has been disabled
no Pamiratha is appearing along
S. Mahanti, J. Mahanti. If my lords kindly see the first page of the brief. Setre upare noting ta achi, my lords.
she is appearing with her junior for BCCI
Amiratha along with
Miss Pamiratha along with S.
senior
Mahanti,
advocate along with
S. Mahanti.
for UP2 the DP Nanda senior advocate along with A. Acharya for UP3
My lords.
OP3
L. Samantaray senior advocate
or OP7
A. Samantaray and Mukesh Mahananda for OP7 brief paper देखिए somehow এটা ଆପଣ ଅର୍ଡରରେ ଲେଖିଲେ କିନ୍ତୁ ରାଜେଶ କରିଛନ୍ତି ସେ ଅର୍ଡର ଲେଖିଛନ୍ତି appearance ଲେଖିଲେ yes
obliged my lords deeply obliged
Obliged to lordship.
yes please call next
Page 5,
ପୂଜା କୋଉ ପେଜ ରେ ଅଛନ୍ତି 5 ରେ ଅଛନ୍ତି 4 ରେ
page 5, 25 to 32.
31 minus ଆଜ୍ଞା
Lordship sent it under the amnesty scheme. The instruction has not come.
Let it come after vacation.
31, so Mr. Somnath Mishra for the petitioner, Mr. Lady Tripathi. Along with the standing counsel, Mr. Amarendra Prasad for the opposite party. The matter being in the list for matter having been listed for hearing out of the heading for admission is mentioned by the learned counsel for the parties. The learned counsel appearing for on behalf of the standing counsel submits that. Upon Wakalatnama file Koriparna.
Aji file kar
Submits that he has filed his Wakalatnama today in the registry. Stuff the Wakalatnama shall be taken on record. Names of the learned standing counsel and learned associates shall be mentioned in the cause as well as the case 3. It is further submitted by Mr. Tripathi, learned counsel, that instructions are sought for from the opposite party and matter may be adjourned. Awaiting the instructions. Stop. Accordingly, the matter shall be listed for admission in the week commencing
27.
27 26.
Item 32.
Next item 32, my lords.
Yes,
There I have filed two applications regarding that amnesty scheme.
yes.
Your lordship may dispose of the writ application saying will avail.
Amnesty application I need to copy mate de.
Dita de deji order.
Order reference to to disposal he gala.
Disposal ro deji.
First matter ta dispose he no. Ta pare soda dispose.
Na dita
I ta kete sir?
I voted 6/4/36 of 2026.
Seitre annex achi.
Again, ମୁଁ ଦଉଛି ଦେଖି
Ne copy rakhen.
ଆଚ୍ଛା ସେଥିରେ annex ଅଛି ସେ
I eta mu mane scheme ta notice ta ja.
ହଁ ଅଛି ସେଥିରେ. And another is
IA 6436 of 2026 along with WPC number 31574 of 2025. Eta order re lekha habo. Appearance rakhibe 32 Mr. Somnath Mishra for the petitioner, Mr. Amarendra Prasad Ray and Mr. ND Tripathi, learned Amarendra Prasad Ray standing up and Mr. ND Tripathi, advocate. Amarendra Prasad Ray, advocate, standing counsel, and Mr. ND Tripathi, advocate for the opposite party. The matter being in the list is mentioned by the learned counsel for the parties. It is submitted by Mr. Mishra, learned counsel, that the order lecture, IA, that IA has been filed enclosing copy of the office letter dated 27/10/2025 regarding the subject, copy amnesty scheme 2025 up to regarding the tini dhadiyas. The said letter indicating the amnesty scheme is scanned and reproduced here. Stuff. Tapare order ta reference to order ta defe. Discussion.
ଦିଟା matter ଥିଲା.
Second matter ta bhi
Same party, same.
Second matter re same ki acha. Second ta lekhibe appearance saman rahila. Tapare IA 6435 of 2026 and WPC 11732 of 20.
Item 30.
30 sir. Yes.
ଏଇଟା ହବ after vacation. And the petition.
Both side ଅଛନ୍ତି. କାଲି ଜଣେ କହିଲେ ମୁଁ ମାନେ ଇନଫର୍ମ କରିଛନ୍ତି ବୋଲି ସେ ଆସିକି ମେଣ୍ଟାଲ କୋର୍ଟ ସରିଲା ପରେ ଦିଟା ବେଳେ ଇନ୍ ପର୍ସନ ତାଙ୍କ ଓକିଲ ଯେ ମତେ ଇନଫର୍ମ କରିନାହାନ୍ତି ଆଡଜର୍ନମେଣ୍ଟ ନେଲେ
ମୁଁ ଇନଫର୍ମ କରିନି
କରିବେ ନା ମ୍ୟାଟରରେ when there is a TRPC which is stay order ଥିବ please inform.
available.
I have to pass an order that rejecting your prayer that I have to do the test order. 30 date କରନ୍ତୁ.
ମୁଁ intimate କରିଦେବି.
ସେ ଯଦି ଆସିବେ ଦେଖିବା
ନା ମୁଁ ତତେ intimate କରିଦେବି.
ଇନଫର୍ମ ନହେଲେ ଆଟଲିଷ୍ଟ 3ଟା 3:30 ବେଳେ ଆସିବେ। ଆଜି ତ ଫୁଲ ଡେ ଅଛି, କାଲି ଥିଲା ମାନେ ସ୍ପେଶାଲ ବେଞ୍ଚ ଥିଲା, ଆଜି ତ ଅଛି।
ମୁଁ ତ ଏବେ intimate କରିଦଉଛି।
ୟେସ୍ 30 ଡେ
27
27
26 33 to 37
Item 36, my lord. Notice issued and notice is sufficient, but noting that there is none appears from the side of the opposite party. Your lordship, I have some difficulties. Your lordship may take the matter after vacation, immediate reopening.
No, not that. So since they are not appearing, what can be done?
Since I have
You
some
are-
past.
Yes. So that Sarada Das is there.
Yes, my.
36 ଟା adjourn କରିଦିଅ
Okay.
ଦେଖନ୍ତୁ କଣ ସେ କଣ stay ଅଛି
Interim
What period?
adjournment ଅଛି till beyond date of
36 ଦେଖନ୍ତୁ ଶାରଦା ଦାସ ଆପଣ ଡକେଇ ଦିଅନ୍ତୁ କିଏ ଆସିବ ନେକ୍ସଟ ଡିକ୍ଟେସନ କେନ ଡାକ ଶାରଦା ଦାସ ଫର ଦ ପିଟିସନର ଆଗରୁ ଯୋଉ ସୁମନ୍ତ ଭୂୟାଁ କୃଷ୍ଣ ସମସ୍ତେ ଆପଣଙ୍କ
they are our associates, my lord. But your lordship, Mr. J.K. Panda name may be deleted because the brief has been transferred to me.
ଜେକେ ପଣ୍ଡାଙ୍କର ଆସୋସିଏଟ କିଏ ନା କେହି ନାହାନ୍ତି
So I have no knowledge for J.K. Panda.
ମାନେ ଆପଣ ସମସ୍ତେ starting with ଶାରଦା ଦାସ all are your
No, Shikhetra Mishra, Sumanta Bhaiya and Krishna Baba, they are my associates.
ଲେଖି ଦିଅନ୍ତୁ ତାହେଲେ ସେଟା କଣ ସେ ଜାଣିପାରିବେ ଲେଖି ଦିଅନ୍ତୁ ବେଶୀ ଜାଣିବେ କେମିତି କରିପାରିବେ The matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the petitioner. Stop. She submits that the postal tracking report indicates the postal article has been delivered upon opposite party on 11/5/2026. Stop. The office note the office note by the registry further indicates that no counsel has yet appeared on behalf of the opposite party. Stop. Awaiting appearance of the opposite party. ଆପଣଙ୍କର ସେ କୋଉ ମ୍ୟାଟର appear କରୁଛନ୍ତି ସେ କୋର୍ଟ ଥ୍ରୁରେ ନଉନାହାନ୍ତି
Again?
ଅପୋଜିଟ ପାର୍ଟି ଯୋଉ ପ୍ରୋସିଡିଂ ରେ appear କରୁଛନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟ ରେ TRPC ରେ ସେ କୋର୍ଟ ଥ୍ରୁରେ କାଇଁ ନେଲେନି ନା ବୁଝି ପାରୁନାହାନ୍ତି
No, your
So, no.
lordship directed me to file.
ଲର୍ଡସିପ ଡାଇରେକ୍ସନ ଦିଅନ୍ତିନି ଆପଣ ଯେତେବେଳେ ପ୍ରେୟାର କରନ୍ତି ଆପଣ ନୋଟିସ ନିଅନ୍ତୁ କୋର୍ଟ ନେଭର ଡାଇରେକ୍ଟସ ଏନି
No,
you have to pray for a issuance of notice ନେବେ ନୋଟିସ କୋର୍ଟ ଥ୍ରୁରେ ପେଣ୍ଡିଂ ଯୋଉଟା ଅଛି ଯୋଉଠି ପ୍ରୋସିଡିଂ ଏନି ଆଇଡିଆ ବୁଝିଛନ୍ତି ସେଥିରେ ସେ appear କରୁଛନ୍ତି ନା ନାଇଁ
that Lord
Period.
family court Koraput ସେଠି appear କରୁଛନ୍ତି.
ସବମିଟେଡ କଣ ଲେଖିছে ଆପଣ ସେଟା କାଟନ୍ତୁ ଆବେଟିଂ ଟା କାଟନ୍ତୁ ନା ପୂର୍ବଟା କଣ ଲେଖିছে Yes. The learned counsel shall submits that she may be permitted to take notice through the court as the opposite party is appearing before the learned judge family court in CP number 83 of 2025. Stop. Leave granted. The petitioner shall file requisites for issuance of notice through the issuance of notice again to the opposite party through the office of the learned judge family court Koraput. ଆପଣ କେତେ ଦିନ ଫାଇଲ କରିବେ requisites be filed within
Within a
3 working
period of 3 days. ma'am.
within a period of 3 working days. Notices shall be issued again along with copy of this order to be served through the office of the learned judge family court Koraput on the opposite party as well as his learned counsel in CP number 83 of 2025. The proof of service shall be forwarded to the registry of this court to be kept on the records of this brief. Stop. Para. As an interim measure, is directed the matters, the CP number 83 of 2025 shall be adjourned. Beyond, ଆପଣ କେବେ ଡେଟ୍ କରୁଛନ୍ତି ଏଇଟା କିଛି କରିନାହାନ୍ତି କେବେ କରିବେ shall be adjourned beyond 27/7/2026 to a date as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. The matter shall be listed for admission in the week commencing 27/7/2026.
Next one.
Yes.
Page 7, 38 to 41.
Lord, item number 39 and 40.
Yes.
Notice was issued, but nobody is appearing for the employee. There's those matter mallards of that Mother Earth, your lordship, and as of cases,
Gratuity,
payment of gratuity.
Yeah.
So I'll let it come.
Employee ପାଇଁ ଆସୁନାହାନ୍ତି
Employee ki ଆସିନାହାନ୍ତି. After vacation,
39 ଲେଖନ୍ତୁ Mr. Somnath Mishra for the petition. ହେଲା? Page 7, 39. Somnath Mishra for the petitioner. 39 sir, Mr. D.N. Lenka, AG. D.N. Lenka advocate, additional government advocate for OP number 1. Gratuity का ପାଇଁ किए?
4 ପାଇଁ କେହି ନାହାନ୍ତି. Gratuity authority ପାଇଁ ସେ ଅଛନ୍ତି.
2, 3 ପାଇଁ Mr. Lenka.
Yes. And they have filed a counter.
Lenka, Mr. 1, 2 and 3. OP 4, none. The matter being matter is listed for hearing under the heading for admission. Stop. Is mentioned by the learned counsel for the petitioner, indicating that the OP number 4 is yet to appear. Notice sufficient है
Again.
Yet to appear. Stop. Perusal of the office note indicates that perusal of the office note date पकेदेवे date होची 5/7/5/2026 आपण जो एमटीआर लिखुचंती 5/7 टा हबन हमर कोन एटा देखो यूएस सिस्टम ना हमरो 2026 तापर रहला 5 तापर रहला 7 मुडा के तो 5/7 अपन चाली मे मास चल से क्लॉक टा चेंज करो 7/5/2026 indicates AD of from the OP number 4 has been received. However, no counsel has yet appeared on behalf of OP number 4. So, awaiting appearance of OP number 4, the matter shall be listed for admission in the week commencing 27/7/2026. So, Mishra, say payment area kichi korantu.
Again, I have already instructed. 50,000 at least they will be paying by the reopening. That I have told my lords.
ଗୋଟେ ବ୍ୟାଚ୍ ଅଫ୍ କେସ୍ ଅଛି ସବୁଗୁଡାକ
ସେମାନେ ସବୁ
ଗୁଡାକରେ 50 ଦବା ପାଇଁ କୁହାଯାଇଥିଲା
ସବୁଗୁଡାକ ଟ୍ୟାଗ୍ ହେଇଗଲେ ନେକ୍ସଟ ଡେଟ୍ କୁ ବାଟ
ଲିଷ୍ଟ ଆପଣ ଯଦି ଦେବେ
Sir, I would ଆସିବ 18 ତାରିଖ ମୁଁ ସେଇଦିନ ଦେଇଦେବି. Your lordship has fixed another 12 matters to come in week commencing 18th.
Okay.
So I will on that day.
40 ରେ ବି ସେମିତି appear କରୁନା
Sir, 40 ରେ ବି କେହି appear କରୁନାହାନ୍ତି in spite of valid service.
40 ରେ ସେ ମୋଡ
Same.
40 ଆପଣ ଡେଟ୍ ଟା ଚେକ୍ କରିପାରିବେ ଛୋଟ ଛୋଟ ଆକାରରେ ଲେଖା ହେଇ ଦେଖାଇ ଗୋଟା ଏନଲାର୍ଜ କରିଦଉଛି 200%. इतने जो ऑफिस नोट डेट होगी এটা লিখিবে 8/5/2026 সেম সেই পার্টিজ একা অଛନ୍ତି খালি ওপি 4 पे आते 40 ରେ ऑफिस नोट डेटेड 8/5/2026 awaiting appearance 41 Mr. Mishra
41, my lord, counter has to be filed by the ESA corporation. Nobody is there for.
Mr. Tripathi ପଳେଇଲେ
Tipati ଏତେ ନାହାନ୍ତି ଏଥିରେ ସାର୍ ଆଉ ଜଣେ କିଏ ନୂଆ ଆଡଭୋକେଟ appear କରୁଛନ୍ତି.
ଆଚ୍ଛା
Sheikh କଣ ଗୋଟେ
We took notice, but it has been
Group
entered
plan,
to
group
some-
एक ग्रुप लाल हां से
ସିଏ କରୁଛନ୍ତି.
ସେ ଗୋଟେ ମ୍ୟାଟର ରେ ସେ ବ୍ୟାଙ୍କ ପାଇଁ ସେ ଆଡଜର୍ନମେଣ୍ଟ ନେଇକି ସେଟା କାଲି କି ଅଛି
ଆସୁ ଛୁଟି ପରେ ଆସୁ.
I'll pass order or simply it will be
ହଁ ସିମ୍ପଲି କର
done.
କିଛି ଦରକାର ନାହିଁ ସେଥିରେ.
पोस्टिंग कर दियो 41 ଟା डेट कर दियो
Week commencing 27.
पूरा 27 दिन कर और आउट रे तो रख 27 तक ऑलरेडी 27 को हेलानी 20 15 टा खंड मैटर 15 टा मिस्टर लेखा करे 12 टा 12 4 16 20 टा मैटर
Item 1,
হিয়ারিং পরে actually ଆପଣ ସେ ରେକର୍ଡ ରେ ସେଟା ରହିବ।
ଏଠି ସାର୍ ଦେଖନ୍ତୁ ଏଇଟା ମୁଁ ସାର୍ଟିଫିକେଟ କପି ଆଣିକି ଓଇ ପାଠିରେ ଏଇଟା କହିଛି ଦେଖନ୍ତୁ ପିନ୍ କୋଡ୍ ଦି ଅଫିସ ନମ୍ବର 1 ସାଇନ୍ ଏଇଟା ଗୋଟେ ଟାଇପ କପି ମୁଁ ଏଭିଡେନ୍ସ କ୍ରସ କରବା ଲାଗି
ଆଜ୍ଞା ଶୁଣନ୍ତୁ ମୋର ଆପଣ ରିଆର୍ଗ୍ୟୁ କଲେ କିଛି ଲାଭ ନାହିଁ କାହିଁକିନା ମୋର ଏକ୍ଜାକ୍ଟଲି ମନେ ଅଛି।
ସାର୍ ଏଇଟା ଶୁଣନ୍ତୁ
ଆପଣଙ୍କର ଆପଣ କନସେନ୍ଟ୍ରେଟ୍ ଅନ୍ ୟୁର ପ୍ରିଡିଙ୍ଗସ୍ ଆଣ୍ଡ ୟୁର ଏଭିଡେନ୍ସ।
ସାର୍ ସାର୍ ଏଇଟା
ଆପଣ ଏଭିଡେନ୍ସ ଟା ସେଦିନ ପଢିଥିଲେ?
ଏଇଟା ପଢିନଥିଲି ସାର୍ ଏଇଟା
ଆରେ ଆପଣ ତ କାଗଜଟା ଧରିଛନ୍ତି ଆପଣ ତ ଏଭିଡେନ୍ସ ଅଛି ବ୍ରିଫ ରେ।
ନାଇଁ ସାର୍
ଆପଣ ଯଦି ରିଆର୍ଗ୍ୟୁ କରିବେ ସେ ଜିନିଷଟା ହବନି।
ଆଗକୁ ଏଇ ଯୋଉ ଏଭିଡେନ୍ସ ଦେଇକି ଏଟା ତଳରେ ଉପରେ ମନା କରୁଛି ତଳେ ଏଡମିଟ କରିଛି ସାର୍ ତଳ ପଠେଇ ଛାଡି ଦେଇଛନ୍ତି ସେ ଅର୍ଡରରେ ସାର୍ଟିଫିକେଟ କହି ମାଗିଛି ସାର୍
ସେଇଟା ନୁହଁ। ଆପଣ ଯେମିତି ଆପଣଙ୍କ କେସ୍ ଭୁଲି ଯାଉଛନ୍ତି ମୁଁ ସେମିତି ମୋ କେସ୍ ମନେ ରଖୁଛି।
ନାଇଁ ଭୁଲୁନି
ଡିଫରେନ୍ସ ହେଲା ଆପଣ ଗୋଟେ କେସ୍ ଭୁଲି ଯାଉଛନ୍ତି ଆପଣ ଗୋଟେ ଆର୍ଗୁମେଣ୍ଟ କଲେ ସେଠି ଗୋଟେ ଡକୁମେଣ୍ଟ ପ୍ରଡ୍ୟୁସ କଲେ ଆପଣ ଗୋଟେ ଡକୁମେଣ୍ଟ ପ୍ରଡ୍ୟୁସ କଲେ ଯେ ସି ହାଜ ସେଡ୍ ଦ୍ୟାଟ୍ ଆଇ ଭଲେଣ୍ଟାରିଲି ୟୁ ମଷ୍ଟ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ when you are proving conduct ଆପଣ କହିଥିଲି ଆପଣ ଯେତେବେଳେ କଣ୍ଡକ୍ଟ ପ୍ରୁଭ କରୁଛନ୍ତି ସେତେବେଳେ ଡକୁମେଣ୍ଟ ଦେବେନି ଡକୁମେଣ୍ଟ କ୍ୟାନଟ ବି ପ୍ରୁଭ ବାଇ କଣ୍ଡକ୍ଟ। ଆପଣ କହିଲେ ଯେ ସେ ଆଜ୍ଞା ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ମୁଁ ଶୁଣିକି ମନେ ରଖି ତାର ଉତ୍ତରଟା ଦଉଛି। ଆମେ ସମୟ ନଷ୍ଟ କରୁଛେ। ଆପଣ have you adduced any evidence? Did you anyone depose before the trial court regarding voluntary desertion or you produced a document?
The petitioner with the OP with the petitioner that himself told already in
ଆଜ୍ଞା ସେଟା himself herself କହିଲେ ଲାଭ ନାହିଁ। ଆପଣ ଗୋଟେ ଡକୁମେଣ୍ଟ ପ୍ରଡ୍ୟୁସ କଲେ ଡକୁମେଣ୍ଟର ଆପଣ ଡକୁମେଣ୍ଟର ଏକ୍ଜିକ୍ୟୁସନ ପ୍ରୁଭ କରିନାହାନ୍ତି।
ସେଇଟା ଲୋକ କହୁଛି ସାର୍ ସେଟା ସେଇ ସେକ୍ସନ ସେ ବହି ବି ଆଣି ଜାଣିଛି ସାର୍ ଏଭିଡେନ୍ସ ବି ନାହିଁ because when the petitioner himself with the author of the document himself say I have written it and I have signed it as Sujata
ଆପଣଙ୍କର ଶୁଣନ୍ତୁ ପ୍ରୋବ୍ଲେମ ଅଛି ସେଇଟା ଆପଣ ଯେତେବେଳେ ଗୋଟେ ଡେଜର୍ସନ ଟାକୁ ଡକୁମେଣ୍ଟରେ ପ୍ରୁଭ କରିବେ ୟୁ ରନ୍ ଦ ରିସ୍କ। ଆପଣ ସେଟାକୁ ଆପଣ ଭଲେଣ୍ଟାରୀ ଡେଜର୍ସନ ଟା ଡକୁମେଣ୍ଟରେ କେହି ପର୍ଯ୍ୟନ୍ତ ପ୍ରୁଭ କରିନାହାନ୍ତି। ଆପଣ କଣ ଏକୁଟିଆ କେସ୍ କରୁଛନ୍ତି ଆଉ କେହି କରୁନାହାନ୍ତି? ସେ ସାର୍ଟିଫାଇଡ କପି ନାହିଁ ଡିସମିସ୍ଡ ଆପଣ ଯାହା ଦବା କଥା ଦିଅନ୍ତୁ ଡିସମିସ୍ ମୁଁ ଆଜ୍ଞା ଏମିତି ଇନଷ୍ଟଲମେଣ୍ଟରେ କେସ୍ କରେନି। ଆପଣଙ୍କର ରାଉଣ୍ଡ ରବିନ୍ ତାପରେ କ୍ୱାର୍ଟର ଫାଇନାଲ ସେମିଫାଇନାଲ ଫାଇନାଲ ନୁହଁ ଆଜ୍ଞା। ସାର୍ ଆଇ ହାର୍ଡ ୟୁ ଫର 40 minutes ଆପଣ ମୋ କଥା ଟିକେ ଶୁଣନ୍ତୁ। Have I not heard you for 40 minutes? So I have recorded that. I cannot give. ଆଜ୍ଞା ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ଆଡଭାଣ୍ଟେଜ ଅଛି ଆପଣ ସବୁଦିନ ନୂଆ କଥା କହିବେ। ମୋର ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ମୁଁ ଥରେ ଗୋଟେ ଅର୍ଡର ରେକର୍ଡ କଲା ପରେ ଚେଞ୍ଜ କରିପାରିବେନି। ଆପଣ ଅର୍ଡରଟା ପଢିଛନ୍ତି କି? ସାର୍ ଗୋଟେ କାଢିଦେଲେ ଅର୍ଡରଟା କିଛି ପଢିବେନି କିଛି ନାହିଁ କେସ୍ କରିବାରେ ଇଣ୍ଟରେଷ୍ଟ ନାହିଁ ଗୋଟେ ଡକୁମେଣ୍ଟଟାକୁ ପ୍ରୁଭ କଲେନି ଏଠି ଆସି କହୁଛନ୍ତି ଯେ ମୁଁ ପ୍ରଡ୍ୟୁସ କରିବି।
ନିଜେ ପ୍ରୁଭ କରି ସାର୍ ନିଜେ କରି
ଆଜ୍ଞା ଆପଣ ତ ପଢିବେନି ଜଜମେଣ୍ଟଟା ଆପଣଙ୍କର କାହିଁକି ହାରିଗଲେ କେସ୍ ଜାଣିନାହାନ୍ତି।
ସେଇଟା ସେ ଛାଡି
ଶୁଣନ୍ତୁ ସେଠି କେସ୍ ଲରେ ସେଟାକୁ ହୁଏନି ଏଟା ବେସିକ ଫାଷ୍ଟ ପ୍ରିନ୍ସିପଲ୍ସ।
ମୁଁ ନିଜେ
ଆପଣ ୟୁ ରାନ୍ ଦ ରିସ୍କ ଅଫ ଆପଣଙ୍କର ଫୋର୍ସ ଫ୍ରଡ ଡ୍ୟୁରେସ ବହୁତ ଜିନିଷ ଅଛି ଡକୁମେଣ୍ଟରେ। ମୁଁ ଆପଣଙ୍କୁ ଆଜି ଗୋଟେ ମିଷ୍ଟର ପଣ୍ଡା ସେ ଆପଣଙ୍କୁ ଧମକେଇବେ ସେ ବହୁତ ଭଲ ଲୋକ ଆପଣ ଡରିଗଲେ ମିଷ୍ଟର ପଣ୍ଡାକୁ ଲେଖିଦେବେ ଯେ ଶୁଣିବେନି ତ ୟୁ ହାଭ୍ ଏ ଡେଭଲପଡ ହ୍ୟାବିଟ ଅଫ ନଟ୍ ଲିସନିଂ ଟୁ ଏନିଥିଙ୍ଗ ନା ନିଜେ ପଢିବେ ନା ଜଜ କହିଲେ କିଛି ଶୁଣିବେ। ଆପଣ ଗୋଟେ ଆନେକ୍ସର ଏ ଆଉ ବି ଯୋଉଟା ପ୍ରୁଭ କଲେ ୟୁ କୁଡ୍ ନଟ୍ ପ୍ରୁଭ ଦୋଜ ଡକୁମେଣ୍ଟ ଦ୍ୟାଟ୍ ଇଜ ଦ ଫାଇଣ୍ଡିଂ। ରିଭିଜନରେ ସ୍କୋପ ହେଲା ହାଇକୋର୍ଟ କ୍ୟାନଟ ରିଭିଜନରେ କୋଉ ଡିସିଜନ ପଢିଛନ୍ତି? Cannot be. This is the problem when you do not read. ଆପଣଙ୍କୁ reference ବି ଦେଲି Para 20 Justice Misra has said, Honorable Chief Justice Misra in Supreme Court has said earlier principle High Court cannot have a different opinion because it thinks that it is correct. Once you fail in that, who advised you to prove that document before file that document before the 125? ଆପଣ ଆଜି ଲେଖିଦେବେ ଏଇଠି ଯେ ମୁଁ ଓକିଲ ନୁହଁ ମିଷ୍ଟର ପଣ୍ଡା ଧମକେଇଲେ ଆପଣଙ୍କୁ ଏପଟେ ଆପଣ ଏକ୍ସାମ୍ପଲ ଦଉଛି ଲେଖିଦେଲେ ତାପରେ ସେ କୋର୍ଟରେ ସେଟା ମିଷ୍ଟର ପଣ୍ଡା ମିଷ୍ଟର ବାରିକ ପ୍ରଧାନ ପ୍ରଡ୍ୟୁସ କଲେ ହେଲା ପ୍ରଧାନ ପ୍ରଡ୍ୟୁସ କରି କହିଲେ ମିଷ୍ଟର ଦାସ ଇଜ ନଟ୍ ଏ ଲୟର କୋର୍ଟ ଦେଇଦବ It is as nonsensical as it could be. ଆପଣଙ୍କୁ ଏଇ ସବୁ ଫାଣ୍ଟାଷ୍ଟିକ ଆଇଡିଆ କିଏ ଦେଲା ଯେ ୱାଇଫ ଯଦି କାଗଜରେ ଲେଖି ଦଉଛି ମୁଁ ନିଜେ ପଳଉଛି ତାହେଲେ ସେଟା ପ୍ରୁଭ୍ ହେଇଗଲା ଭଲେଣ୍ଟାରୀ ଡିଜର୍ସନ ର କିଛି ଡେଭଲପ ସମ୍ ହ୍ୟାବିଟ ଅଫ at least some semblance of reading.
My lord, I have also reduced in my evidence.
କିଛି ଆପଣ ଦେଇନାହାନ୍ତି ସେଟା ଛାଡ଼ନ୍ତୁ ଆଜ୍ଞା ସେଇଟା ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ କଣ ହେଲା କହିଲେ ଆପଣ ଭାବିଲେ ଯେ ମୁଁ ବର୍ତ୍ତମାନ ବାଇବେଲ ଗସ୍ପେଲ ଟ୍ରୁଥ ଆନେକ୍ସରେ ବି ଲେଖିଦେଲା ମୁଁ ସେଟା ଆପଣ ପଚାରୁଛି ପରା ଆପଣ ବର୍ତ୍ତମାନ ଲେଖି ଦିଅନ୍ତୁ କାଗଜରେ ମୁଁ ଓକିଲ ନୁହଁ କାହିଁକିନା ମିଷ୍ଟର ପଣ୍ଡା ଧମକେଇଲେ ମିଷ୍ଟର ପଣ୍ଡା ଡୋଣ୍ଟ ମାଇଣ୍ଡ ମୁଁ ଆପଣଙ୍କୁ କିଛି କହୁଛି
Before witness that has been written in the annexure, that is
କୋଉ ୱିଟନେସ୍ ପଢୁନାହାନ୍ତି ଏବେ ଆଜ୍ଞା ଶୁଣନ୍ତୁ ଆପଣ ସିନା ପଢିଲେନି ମୁଁ ଯୋଉ 40 ମିନିଟ୍ ଆପଣଙ୍କ ପାଖରେ 12:45 ଗୋଟେ 20 ଯାଏ
sir, exhibit B ରେ ପରା ଥାନାରେ ଲେଖା ହେଇଛି
ଆଜ୍ଞା ଥାନାରେ ଯୋଉ ଆପଣ ଯାହାକୁ ରିଲାଏ କରିବେ ଯାହା ଷ୍ଟେଟମେଣ୍ଟ ଥାନାରେ ସେ ଥାନା ବାବୁକୁ ଡାକିବେ
ଥାନା ବାବୁ
ଶୁଣନ୍ତୁ ଆପଣ ଏଭିଡେନ୍ସ ଆକ୍ଟରେ ସେକ୍ସନ 4 ପଢିଲେ
ଥାନା ବାବୁ କିଛି
ଆପଣଙ୍କ ରେଲିଭାନ୍ସି ଆଡମିସିବିଲିଟି
ଥାନା ବାବୁ
ଫେରେ ଗପିଲେ ଆପଣ ଥାନା ବାବୁଙ୍କୁ ଡାକିବେ ପ୍ରୁଭ୍ କରିବା ପାଇଁ ଯେ ସେ ଭଲେଣ୍ଟାରୀ ଡିଜର୍ସନ ପାଇଁ
ଥାନା ବାବୁ କିଛି
what nonsense you are arguing sir
ସାର୍ ମୁଁ କହିବା କହୁନି ସାର୍ ଥାନା ବାବୁ କିଛି କହିନି ସେମାନେ ଭୋଟ ପଡିକି ନିଜେ ଲେଖି
ଯୋଉ ଥାନାରେ ସେଟା ଦେଲେ ସେଟା ପ୍ରୁଭ୍ କେମିତି ହୁଏ ସେଟା ଡିସିଜନ ଉପରେ ବାଇଣ୍ଡିଂ
ମୁଁ ତ
କଣ ଆଜ୍ଞା ଆପଣ ମୁଁ ଆଜ୍ଞା କେବେ ଟ୍ରାଏଲ ସେତେ କରିନି ବହୁତ କମ କରିଛି କିଛି ଆର୍ବିଟ୍ରେସନ କରିଛି ବହୁତ କମ କରିଛି
ନିଜେ ମୋର ଏଭିଡେନ୍ସରେ କହିଛି
ଆପଣ you spoiled your own case by adducing two papers ଗୋଟେ କହିଲେ ଯେ ଥାନାରେ ଡିକ୍ଲାରେସନ ଦେଇଥିଲେ ଥାନାରେ ଆଜ୍ଞା ତ ସେକ୍ସନ 27 are inadmissible evidence any statement before a police officer is it admissible
ପୋଲିସ ଅଫିସର ନିଜେ ଲେଖା
କାହିଁକି ସେଟା ଦେଇଥିଲେ କାହିଁକି ଆପଣ ସେଟା ଆଡ୍ୟୁସ କରୁଥିଲେ ସେଟା ଥାନା ବାବୁ ଯୋଉଟା ସେଟା ଗସ୍ପେଲ ଟ୍ରୁଥ କନଷ୍ଟିଟ୍ୟୁସନ ଅଫ ଇଣ୍ଡିଆ ନା କଣ
ଥାନା ବାବୁ ସାକ୍ଷୀ କର ନାହିଁ ସାର୍
ଥାନାରେ ଯୋଉଟା ଆପଣ ଦିଆହେଲା ସେଟା ଅମୁକ ଥାନାରେ ଦିଆହେଇଥିଲା ରିପୋର୍ଟ ଦିଆହେଇଥିଲା ସେ ଦିଆହେଇଥିଲା ସେଗୁଡାକ କାହିଁ ସେଗୁଡା ପ୍ରଡ୍ୟୁସ କରୁଥିଲେ ପ୍ରୁଭ୍ କରିବା ପାଇଁ ଡେଜର୍ସନ ସେମିତି ପ୍ରୁଭ୍ କରାଯାଏ କେବେ ହେଇଥିଲା ଆପଣ ଆଜ୍ଞା 55 ମସିହାରୁ ହିନ୍ଦୁ ମ୍ୟାରେଜ ଆକ୍ଟ ହେଲାଣି
ମୁଁ ସେଥିପାଇଁ ଥାନା ବାବୁ ସମନ କରିନି କି ତାକୁ ଡାକିନି ସାର୍ ତାଙ୍କ ନିଜେ
ଆପଣ ଆଗରୁ ଆଡ୍ୟୁସ କଲା ପୂର୍ବରୁ ଭାବିବାର ଥିଲା ଯେ ସେଟାକୁ ପ୍ରୁଭ୍ କରିବାକୁ ହେଲେ ସ୍କ୍ରାଇବକୁ ଡାକିବାକୁ ପଡିବ ଆପଣଙ୍କର ସବୁବେଳେ କାହିଁକି ଆର୍ଟିଷ୍ଟିଂ ୱିଟନେସ୍ ଥାନ୍ତି ସେ କହନ୍ତି ଯେ ଫ୍ରି କନସେଣ୍ଟରେ ସେଟା କରାହେଇଛି ସେଥିପାଇଁ ଆପଣ ଏକ୍ସାମ୍ପଲ ଦେଲେ ମିଷ୍ଟର ପଣ୍ଡାଙ୍କୁ ଆପଣ ଡରନ୍ତି ସେ କହିଲେ ବର୍ତ୍ତମାନ ଲେଖନ୍ତୁ ମୋ ଓକିଲ ନୁହଁ ହେଇଯିବ ସେଟା ସମ୍ବାର ନାହିଁ ଆଜ୍ଞା ଆପଣ ତ ସଫିସିଏଣ୍ଟ ଆଜ୍ଞା ମୁଁ ଆପଣଙ୍କର ଆଜ୍ଞା 24 ମସିହାର ମୁଁ ରିଭିଜନ ଗୋଟେ ଦିନ ହିୟରିଂ କରିବି 45 ମିନିଟ୍ ତା ପରଦିନ ଆଉ ଥରେ ଆଜି ଗଲାଣି ଫେରେ ଦେଖନ୍ତୁ 10 ମିନିଟ୍
କଣ୍ଟାକ୍ଟ କରିପାରିନି ତାକୁ ସାର୍
କଣ୍ଟାକ୍ଟ କଲେ ନ କଲେ ଇଜ ନଟ୍ ଇମ୍ପୋର୍ଟାଣ୍ଟ ସାର୍ ସାର୍ ଆପଣ ଯେମିତି କ୍ଲାଏଣ୍ଟ ସାର୍ କଣ୍ଟାକ୍ଟ କରିପାରୁନାହାନ୍ତି ଆଇ କ୍ୟାନଟ୍ ହାଭ୍ ଦ୍ୟାଟ୍ ଇନ୍ ମୋର କଣ୍ଟାକ୍ଟ ନାହିଁ ଜଜମେଣ୍ଟ ସାର୍ ଆଜ୍ଞା ମ୍ୟାଟେରିଆଲ ଅନ୍ ରେକର୍ଡ ହ୍ୟାଭ୍ ଟୁ ରିଡ୍ I have it. Withdraw kar dismiss as withdraw. Dismissed.
291.
So whatever. The matter was presented before this court. There has to be some semblance of reading and some reading of law, some reading of facts in any case. And ଆପଣଙ୍କର ଯଦି ସହଜ ଆଜି ଆର୍ଗୁମେଣ୍ଟ କଲେ କାଲି କହିଲେ ମୁଁ ୱିଥଡ୍ର କରିଦେବି ପରଦିନ କହିଲେ ମୁଁ କଣ୍ଟାକ୍ଟ କରିପାରୁନି can the court do that because the lawyer cannot contact the client so that is adjourned what is this sir how can I direct that ଆପଣ contact କଲେ ନ କଲେ the matter was presented before this court on 26/6/2004 ତାପରେ 12(5) ଅର୍ଡର ପାରାଗ୍ରାଫ 234 ରିପିଟ୍ ହେଇଗଲା appearance ଲେଖିବେ Mr. Ashwini Kumar Das for the petitioner, Mr. Rajendra Kumar Pradhan for the opposite party. Execution ଟା କେବେ କର?
Execution ଟା
25 ର ସୁପ୍ରିମ କୋର୍ଟ has stringent in the 6 ମାସର ଅଧିକା ଏକ୍ଜିକ୍ୟୁସନ ପେଣ୍ଡିଂ ରହି ପାରିବନି ଆପଣ ମତେ ଆଇଡିଆ ଦଉଛନ୍ତି ଯେ ମୁଁ ତାକୁ ଷ୍ଟେ କରିବି କୋଉ ডিসিশন ରେ କହିଲେ ସୁପ୍ରିମ କୋର୍ଟ ଲାର୍ଜର ବେଞ୍ଚ ডিসিশন it has been circulated two decisions हाँ After hearing the learned counsel for the petitioner at length on bar 5-20-26, the following order was passed. 5-6 तापर कोट करिए 5-6 7 8 9 10 टू 10 टू 12 कर 5 टू 12 कोट है ना 12 Today, the matter having been listed, memo दियंतु memo dated एते उता कित तारीख memo of date is filed by the learned counsel for the memo having been today the matter is listed marked as to be mentioned. Memo of date is filed by the learned counsel for the petitioner, which states thus: the memo shall be taken on record, scanned copy be updated. On being asked, it is submitted by the learned counsel for the opposite party that execution filed by the petitioner, the opposite party, wife and child. Wife is pending since
25.
Execution case 1 of 2025 arising out of CRP number 142 of 2019 is pending before the learned judge family court Hon'Ble. Stop. The learned counsel are apprised of the judgment rendered by the Honorable Apex Court in Rahul Shah versus Jines and Periamal. In Rahul Shah, detailed directions have been issued by exercising jurisdiction under Article 141 and 142 of the Constitution of India, which are as follows. That देखिए ना पेस्ट करें अपन. But in view of the above discussions, as well as the view of the memo filed today, the matter is dismissed. The revision application is dismissed.
Item 2,
Item 2.
2 ରୁ 3 रे आपण 2 ରୁ 3 रे करियो प्रोजेक्ट प्रोपोनेंट को पार्टी करिसंती
अच्छे मैन
को ऑर्डर है सर
इंडिया पार्टी
एटा चांदीपुर पे एक्विजिशन
आगे
हेई परियो मेडिएशन करंतु कोन
Lordship, in fact, this Honorable Court is directed on the last occasion, 16/2026, that if mediation is possible. But in fact,
because what my understanding is that even it is taken up before by the Honorable Apex Court, because in these kind of matters you have to have a policy of resolving. Of course, you can't be compelled. That's not the objective. But if it can be, because they are admittedly they are the land users for the interim test range at Chandipur, they have lost their property. Yes, and quantum, if it is not that large and the quantum is reasonable,
it is different for the Kisams also.
It's some whatever. Apno gote kichi kari parile, so they will be going there. Apno paku jibe.
Let me take a proposal and accordingly I submit.
Okay. Mr. M.K. Ponda appearance has Sobuda kare Mr. Ponda. Alga. Gote matter, sir. I'm sorry, I thought batch matter. Mr. Manoj Kumar Ponda, along with Mr. Niranjan Ponda 1, along with Mr. M.K. Ponda for the petitioner. Mr. P.K. Mohanty, appearance ठीक अच्छी 16-3 में खाली निरंजन पंडा नाट ऐड करते थे निरंजन पंडा along with Mr. M.K. Ponda. Opposite party 1 hele P.K. Mohanty, 2 hele Satya Sindhu Kashyap, senior panel counsel. The learned senior panel counsel, referring to the order dated 16-3-2026, submits that he needs to obtain further instruction regarding matter to be settled by mediation in the special mediation drive 2.0 mediation for the lesser stop. Awaiting such instruction, the matter shall be listed in the week commencing, listed under the same heading in the week commencing
On 3.
on 3 now for the time
26.
on 3
Positive instruction on. Data data and the positive instruction on.
I'll stick for that whether it is
तो कहले स्पार्क होची आपनकर मेडिसिन को पठेले से कोजन जे हमें आगे पॉलिसी हमें केमति दबु
Positive instruction আনলে
Certainly, I'll.
চেষ্টা করছেন হো
Let's say if I am for the respondent number 8A to 8F, all the LRs of the deceased respondent number 8.
এই যে 61 রে
Yes, your lords.
do not find it.
One of
ভিতরে নেই নেই এটা আলাদা কমেন্টস সে আপনাদের দুই তিন
sorry, lordship.
তিন
I have a
yes.
sheet of number.
I am on 3 my lord.
Item 3,
Three, Mr.
My lord, here your lordship is directed for my lord mediation on the last date. And that
Yes.
is paid, my lord. Here the question is, my lord, it is at the final stage and the matter is pending for last 10 years before this honorable court. The question was, my lord, with regard to the entitlement of the present respondent number 1 and 2, my lord, they
Yes.
made a dispute that we are not their sisters. And the matter was, my lord, by this honorable court directed to be referred to the land acquisition officer. Land acquisition officer finally found that these are disputed questions, referred to the my lord, the competent civil court for its adjudication. And the adjudication was, my lord, completed. And it was held that, and in fact, in their evidence also, they had admitted that we are their sisters. Despite that, my lord, and the order being passed, the matter is pending till now. They have disputed our status as their own sisters. And that was, my lord, denied by the learned trial court that what they are saying. And when the finally the order was passed, and it is now.
You are saying that the dispute is so contentious, mediation is not possible.
Mediation is not
But
possible.
only
Your
possibility
lordship also directed.
Mr. Nanda,
lordship
the
also-
objective here is that since the two parties are claiming to be legal heirs and they are related,
Yes,
at least to the extent some will sacrifice and some will gain.
all should gain.
Those who will gain also, not to the extent they want.
Not
They
to
will
the
gain
extent.
less.
Yes,
They will gain less. I may change the vocabulary. They will gain less and you will lose less. So in that context, the mediation. But if you say that it is not possible, then
it's and your lordship directed also, man, in the last occasion, and the
Yes.
report is also come, man.
yes.
There is a report also. Your lordship may fix it and finally decide, man. And here also it is more than 10 years.
Not possible mediation.
My lord had referred, mediation report has come. I am not privy to that.
Your
But
lordship
what
is
I have learnt is
Report ଆସିଯାଇଛି
again
yes, man.
flag 1 and 2, my lord.
8-5 କୁ ଯାଇଥିଲା
Again.
ଆଚ୍ଛା ଏଟା ନନ୍ ଷ୍ଟାର୍ଟର ହେଇ ରହିଗଲା ଏଟା mediation ଆଜ୍ଞା there is a concept of non starter in the sense when the parties do not appear or
Because the ladies, man, they said that what will we do there? Our brothers are not accepting their own sisters, and they are denying our right to the property of our father. So what is the point of going there? If they admit anything, then the question of more or less comes.
ଆପଣ ଯଦି encourage କରିବେ ଯିବା ପାଇଁ I think it will be achieved.
They are not agreeable.
What my
But-
lord has said,
My humble submission, man, they are not at all agreeable, man. The brothers have been my lord,
what
denying
my
their
lord just
right and-
said is exactly the same. Some party may lose a share and some party may gain something.
Less,
No, nothing,
less,
nothing.
less, less gain, less loss.
I'm sorry, my lord. That is exactly
So
what.
change it. That will be more appealing.
My lord, they my lord, denied completely that we are the.
No. That is not obviously. I mean, that is an extreme stand, Mister.
Yes, man. Yes, man.
Complete denial is extreme stand. Acceptance is also an extreme stand.
And in the trial, my lord, the very same persons who denied our status have admitted in their
tried a
Even Mr. Nanda before Mahabharata, mediation was tried.
and you also did the right thing by asking the parties to go there and try to find out a solution.
And here the better part is that it is not between the brothers; it is between brothers and the group of sisters.
Sisters, man. Two sisters.
So that gives more hope.
And in the evidence also, your lordship will be
ଆପଣ
kind
ଯଦି
enough to-
ଏଠି ସେ ଯୁଦ୍ଧ ତ ଏବେ ନାହିଁ ବିନା କଣ କୁହାଯିବ ବିନା ମାମଲାରେ ଦେବୀ ନାହିଁ ସୁଚାଗ୍ରେ ମେଦିନୀ ସେମିତି ତ
Armistice.
Your lordship have been always encouraging this mode of settlement out
No,
of.
this is the policy now. This is
Yes,
being encouraged by the
yes,
Supreme Court. In fact,
yes.
you would have marked that even, at the level of Supreme Court, they are talking to the union
Yes.
because union has and state they are saying that in revenue, land acquisition compensation, we cannot negotiate. We can't mediate. They want a legalistic determination.
Yes, man.
So they
And
need
here-
to have a policy. But
And
here it is apportionment between brothers and sisters.
And here, no, they are not giving anything, my lord. They are saying that we are not sisters. Although in that examination in chief and cross-examination in the trial court, they have admitted that now we are their sisters. They themselves have admitted in the trial court that evidence copy is there. You will also will see the LCR. Nothing is there to be decided also. Somehow it's a.
So, have you gone through the report?
That report is, my lord, it's a report submitted to your lordship only.
Okay. I'll provide all of you the copy because it seems a detailed report. Because it is written very small letters and it's detailed. So why it is non-starter, you just examine. Okay.
My humble prayer will be, my lord.
No, only you go through it. I'll be posting it to the next week so that at least you have the benefit of going through that.
Yes.
The matter is listed for all of the headings. You referral to the special mediation day. Purata likhibe. No chare refer hitla.
Again, no chare.
Pursuant to the order dated 9/4/2026, on no chari kodiye chabisi, the following direction was issued. Paste kar this. Thereafter, the matter was taken up for mediation before the DLSA Sundargarh. By a letter dated 4/5/2026, addressed to the registry of this court, the lauded Secretary DLSA had sought for had intimated that the matter was posted to 8/5/2026 for mediation. Stop. Into bracket likhiye flag 1. Flag 1. Next to the brief marked as flag 1. Thereafter, by letter dated 11/5/2026, report has been submitted by the learned DLSA to the registry, which indicates that the case has been disposed of as non-starter. DMC case number 441 of 2026 as non-starter. Registry shall provide a copy of the order dated, the letter dated 11/5/2026 to the lauded counsel for the petitioner as well as all the appearing parties. So, the matter shall be listed under the same heading on 19.
My lord, may see the age of the respondents, man. Kindly, man. See the age of the people. Age of respondent 1 and 2.
Yes,
now
yes.
they are more than 80.
Mr. R.K. Mohanty, senior advocate, along with A. Mohanty for the appellate. G.N. Sahoo, Mr. Ajay Nanda, A.K. Nanda, along with Mr. G.N. Sahoo for the R1 and 2. Mr. Prem Kumar Mohanty, additional standing counsel to state JFC. Mr. A.P. Bose, along with Mrs. D. Sahoo for R8. R8 approximately.
All the LRs of the 8 years.
8 8 कितने से
8A to 8F.
R8 लिखिए R8 small a ना capital A.
Small a, let's say.
8 small a dash 8F. Copy पठेवा पे आज बंदोबस्त करो तो काले copy लिखले नहीं. We provided by Ministry shall provide copies to the lauded counsel for the appearing parties. All the counsel for the appearing parties. Like 15/5/2026 कर दियो तो. Tagore, इटा prioritize up. Secondary कर देबे এটা কেটে না দুইটা আছে দুইটা ম্যাটারে भी
1 and 2 of 2016
हां ঠিক আছে তাহলে মিসেকি গোটা অর্ডার করি এক বি করি কি সেখানে গোটা এটা কেন appearing party সমান আছে
Yes, sir.
yes or conflict of sir yes Mr. Nanda, they will provide you copy by tomorrow.
Well,
Yes please.
Grateful.
Yes
Grateful.
Under the same heading.
Item 4.
Here I have a grievance. But they were not appearing previous 2 dates, I think.
Another case, copy notes of 6203 of 25.
Notice copy not solved कहले केमथि हो?
Not,
They are lingering the matter and harassing.
no. Honestly speaking,
Copy upon you could not serve at the court against allegation.
16/4/2000
Court judge notice governing
address left.
से wipe पेली जहाँ कोई पेली.
receive कर आपण सर नहीं आई एम सॉरी आपण को मैटर अपियर करछन 18941 ना 6230
18,947 से I'm the petition.
अच्छा आपण ना सर
SK महापात्र.
ओ अच्छा से आपण पावर आसीनी
एथरे opposite party.
एथरे opposite party. 6203.
से
पिके रथ डी दास इसके महापात्र आपण अछन
आगे.
सेकंड मैटर आपण ना नाही कहीं
second matter रे
प्रज्ञा सर जे प्रधान प्रज्ञा सरिता मान
सेटा हले
नोटिस जाईची सॉरी अच्छा बुझिली ना आई गॉट इट यस
हमर जाईची नोटिस 16/4/2025 रे रिक्विजिट्स फाइल हेची.
यस मिस्टर मिश्रा आपण सेकंड मैटर टा मेंशन कर आर्ग्यू करछु
हां फर्स्ट
आपण
मैटर
सर सेकंड मैटर रे जाउछंती कॉपी
फर्स्ट
करवा
मैटर टा एंट्री मेंटेनेंस अवार्ड हला दीटा रीट फाइल हला
Enhancement.
गोटे रीट डिस्पोज ऑफ हेगला आउटे रीट एथि अछि.
चल आई एम टेकिंग अप द सेकंड मैटर लिखंतु WPC 6203 of 2025 Mr. Samir Misra senior advocate along with Mr.
राकेश
Raut for the petitioner. Stop. The office note indicates that notice and admission and IA matter issued to the sole opposite party returned unserved with postal report. Address left. Stop. Sri SK Mahapatra, learned advocate, appears and submits that he has instructions to appear on behalf of the opposite party. वकालतनामा कितने दिन फाइल कर देले वकालतनामा फाइल करबे फिर के हो
खाली गोटे पद कहबी
फाइल करबे
एक केस
he submits that he has instruction to appear and file the duly executed वकालतनामा by the OP within 3 working days. Stop. The copy returned unserved shall be received by the learned counsel for the opposite party. से copy टी रख दिया गया not है unserved copy returned unserved pursuant to the notices issued by order dated dash shall be received by the learned counsel Mr. Mahapatra sorry Mr. Mahapatra copy पाइछन दिया पड़ Mr. Mahapatra yes
भाई बा
आपण से गोटे लाइन कहवा कथा आगे अनसर्व तेणु मते दे दियंतु बा एनीवे बा एक्स्ट्रा कॉपी आपण अनसर्व कहलेनी बोली जिंसटा कंफ्यूजन है
सेठी गोटे हमें दरखास्त दाखल कलु जे ए 5टा डॉक्यूमेंट कॉल फॉर हो बिकॉज़ सेठी विथ रिगार्ड टू एलिमनी एस्टैब्लिश करिया पे कॉल फॉर हो लर्नेट
ता गोटे चांस दियंतु आपण मंडे करिवे
हां मु खाली गोटे
18,941 एक्चुअली फाइल टा गुड मिसप्लेस से चैम्बर हम चैम्बर मिसप्लेस
पॉइंट pra एतिकी
आजिकल मिसप्लेस सिस्टम नै सेत में पर एबे कर देला
आज्ञा से एनहांसमेंट हबो कि नै केस सरी के आर्गुमेंट में पोस्टिंग हेलानी सेथरे हम गोटे दरखास्त देलु 6टा आइटम आनिया पे पिटिशन लर्नेट कोर्ट बिलो सेड जज फैमिली कोर्ट सेड नो आई शुड फर्स्ट कॉल द वाइफ फॉर क्रॉस एग्जामिनेशन फॉर हुम माय फ्रेंड इज अपीयरिंग ता परे मैं पिटिशनडा कंसीडर करिवि despite direction of the judge family court and despite our petition also से यदि appear करना है तब available वारंटी शो करने से appear करना है से appear कले नहीं then we filed a petition for issuance of available warrant से petition टा close कर argument पे पके देले आ मो petition दियो consider कलेनी petition नीचे लाने judge family court कहले जे तांको जेरा परे consider हबो बोली एतिक होच सो सेथरे असिस्ट करिया को हाउ माय फ्रेंड विल आ एटा तो एविडेंस एटा
केबे करी आपण कोन करिवे नो
फैमिली कोर्ट रे केबे अपीयर करिवे कोंतु
आपनकर क्लाइंट केबे अपीयर करिवे सेटा आफ्टर वेकेशन नो केबे अपीयर करे डेट दोन
फैमिली कोर्ट रे केबे अपीयर करिवे
सरला आ कि सुनंतु ए जो मैटर गुडा को the legislative sorry the judicial policy is that matters which involves trial it should not be kept pending आपनको धरंतु मेटा आपनको छुट्टी परे सुनिबी बहुत शुणिली 2 घंटा 3 घंटा कि 5 घंटा शुणिबी आई कैन नॉट पास एनी बेटर ऑर्डर देन दिस आपण अपियर करिवे साक्षी देबे कया कथा कहबे बा क्रॉस एग्जामिनेशन हो जा हो तापर सरला
से ऑर्डर को चैलेंज करना जो डायरेक्शन है साक्षी दवा हाजर हुंतु से ऑर्डर को कोड चैलेंज करना
केमती करी आगे ताकर सूटटा ताकर
नहीं मोर गोटे प्रोसीडिंग ताकर गोटे प्रोसीडिंग
ताको सूट रे कलेनी
नहीं दीटा को अच्छे
ए जदी एनालिसिस क्लोरिंग होची ताको सूट रे जदी पिटिशन देबे म अपियर करबे गला से सूट आपण कोन लीगल एडवाइस
ये जाने कि अपियर करना जस्ट टू हरास
court's power is enormous but at times court considers leniently जने लोग जने सूट रे अपियर करबेनी साक्षी देबेनी ताल डिसमिस हेजिवो
से फर्दर क्रॉस एग्जामिनेशन पे डाकिचनी केना से देखिबे जे ए पिटिशन जो देइछु ता रिलेवेंस कोन होउची ता से आसुना
बोलतो सर कोन भाबंतु जे मोडे हियरिंग करी साथ दोची डोंट बी एंग्शियस फ्रॉम योर फेस यू आर लुकिंग एंग्शियस डोंट डू दैट माने विषयटा को आपण निजे ग्रहण करी भाबंतु दिस मैटर आई टेक इट अपन by that you take instruction आपण को दिन अपियर करिवे फाइल दैट एफिडेविट चलला
सी इज रिजाइडिंग एट बैंगलोर
से बैंगलोर रे होंतु कि कोनो जगह सी मे बी ट्रैवलिंग टू मून बाय द एयरक्राफ्ट से कांसेप्ट इंस्ट्रक्शन केमते आनिबे आपण सेमती बैंगलोर रे रहिले एफिडेविट अपियर करिवेनी से कांसेप्ट कोन डेवलप हेलानी
केबे आसीबारी
सेटा सीपीसी रे ओडे प्रोविजन दरकार जे बैंगलोर रे रहिबो ओडिसा रे अपियर करिवनी आपण व्हाट इज द डिफरेंस बिटवीन लॉयर एंड ए पर्सन स्टेइंग इन बैंगलोर डजंट रीड एंड अंडरस्टैंड लॉ आपण एटा कोर्ट रे कहया यू आर एट ए डिफरेंट लेवल आपण तो कहबे तो आपण बैंगलोर रे रहंतु दुबई रे रहंतु कि बर्तन आपण एयर स्पेस बंद अछि डू नो दैट वन कोर्ट वाज आर्ग्यूड एयर स्पेस वाज इज क्लोज्ड शी cannot travel from UK पानी ता दियो
इट इज बिकॉज़ ऑफ कोल्ड इट अफेक्शन किछ होबनी सजो
कागज ग्लास रे पानी आपण या सीटा कले हो सेटा भुवनेश्वर कोर्ट रिजेक्ट कर देल बिकॉज़ कोर्ट हैज दैट पावर दैट इज हाउ यू मस्ट अंडरस्टैंड दैट यू आर एट ए मच हायर लेवल आपण बैंगलोर रे रहिले आपण केबे देबे ये एटा कोटा कथा आपण अछि कहबे म बैंगलोर रे रहछु साखी
माय लॉर्ड वांटेड जे नेक्स्ट ट्यूसडे रे से कोहंतु केबे हाजर हेबे आउ तो किछि आपण करनांती व्हाई माय फ्रेंड शुड हैव एप्रिहेंशन
मु तो से कहली त एप्रिहेंशन आपण
इंस्ट्रक्शन नेबे
सुनंतु से कहि दे मु अमको दिन आसीबी
हां क्या
कहले से तो मिस्टर
आणि इवन से कोहंतु छुट्टी परे भी हाजर हेबे बोली मोर किछि ग्रीवांस नै
आई हैव गिवन इन ए हिंट
आज्ञा
सेटा मु यदि छुट्टी परे कहले काले ऑब्जेक्शन हो बोली मु अपन हिंट भी देली कारण बर्तन आज भी एटा चलीबो छुट्टी परे कि
कोन सी डेट रे हाजर होई गले सॉरी
जो दिन कहि करंतु से केस कंप्लीट करंतु बिकॉज़ दिस स्ट्रेटजी आपण तो कंडक्ट करचंती कि सेठी कंडक्ट करनांती परहाज द स्ट्रेटजी डेवलप्ड इज दैट अपियर करिवाने देखिबा कोडा आइती दैट डजंट हेल्प नेवर हेल्प्स ए पर्सन हु इज फाइलिंग ए सूट एंड हु इज ए डिपेंडेंट आपण जदी करिवेनी व्हेन द वेरी सिंपल प्रोविजन इज देयर इन सीपीसी व्हेन द पिटिशनर अपियर डिफेंडेंट डज नॉट अपियर फॉलो करिवो कोर्ट
केबे अपियर करिम कहि दिम
आपण बुझंतु मंगलवार वकालतनामा नियंतु बी कूल एंड वकालतनामा फाइल करंतु पर ऑनलाइन वकालतनामा किंते फाइल होछ आपण त पछले कहि देबे कंप्यूटर जाउछंती ऑनलाइन वकालतनामा फाइल करंतु आपण से झुले के रखबे आगे हम गले बेंगलुरु वकालतनामा देबी यू आर ए लॉयर दैट इज नॉट ए प्ली आपण मना करेगा सेंती केस हे परिबन कॉस्ट हे जो डरेबे Yes, कौन लिखले? मिस्टर महापात्र
32758
महापात्र आपण सर में नहीं कॉपी एठु नहीं लाइफ अछि पुराडा देखि चेक करि देते जहाँ अछि कॉपी रे सबुडा के कॉपी नहीं दे देबे मिस्टर राउत से कॉपीटा चेक करंतु सब अनेक्शन नथले दे देबे हैला
से इंटरिम अरेंजमेंट था गोटे थिला एडजर्नमेंट पिटिशन फाइल कले से डेफर हो बोली खाली सेटा थिले टिके डिसकंटिन्यूटी हबन
सेटा से जानि छंती सेत पे तो से बेंगलुरु आसुना
ने मोर इंटरेस्ट होची सरी जुवा पई जहां भी हबो जहां भाग्य तांगर थिबो
the copy is received in court countersent by the received in the court by the learned counsel, countersent by the court master. That's 6203 lecture. ঠিক আছে। The matter shall be listed for fresh admission in the week on 19/5/2024. By the said date, the learned counsel shall obtain wakilatnama as well as instruction as to when the opposite party shall appear to depose before the learned judge, family court Bhubaneswar in CP number.
ନାଇଁ ଏଠି କଟକକୁ ପଳେଇ ଆସିଛି your lordship.
Sorry,
Transfer at the behest of wife.
Katak to depose in the depose oblique give or evidence in the pending applications, pending CP number 288 of 2017 as well as so and so. পুরোটা লিখে পড়ো। When a prayer being made before the learned court in season of CP number 288 of 2017, the matter shall be adjourned after vacation. ଆପଣ ବି ଚାହୁଁଛନ୍ତି Mr. Mahapatra? After vacation?
ନାଇଁ ନାଇଁ ଖାଲି 18 ଯାଏଁ ରହୁ ତାପରେ 18 ଆପଣ ଡିସାଇଡ୍ କଲା ପରେ ଯାହା କରିବେ।
ଏଟା ଅଛି ଅଲରେଡି 21/5, so ଏଠି ଯାଏ ଅସୁବିଧା ନାହିଁ।
ଆଜ୍ଞା ନାଇଁ ମୁଁ ଏ କଣ୍ଟିନ୍ୟୁଟି କାଲି ଡିସକଣ୍ଟିନ୍ୟୁ ହେଇଯିବ।
ନା 21 ଯାଏଁ ଅଛି ଅଲରେଡି। The adjournment is beyond 21, so no difficulty. ତାହେଲେ 18 ରେ ଆସୁ ଆଉ କିଛି ଫର୍ଦର ଲେଖ କରୁଛନ୍ତି। 18 ଦିନ କନସିଡର କରିବେ।
ଆଜ୍ଞା obliged।
ଆପଣ ତାଙ୍କୁ ଆଜ୍ଞା କୁହନ୍ତୁ ସେମିତି ଯୋଉ ପର୍ସନାଲ ମ୍ୟାଟରରେ ତାକୁ ଲିଙ୍ଗର କଲେ ତା ନିଜର ବି କିଛି ମାନେ ଲାଭ ନାହିଁ, because she herself is the protagonist.
Both are highly educated, well placed. ଯାହା ହବାର ଥିବ ହେଇଯିବ decide.
No, I mean this legal process becomes difficult. I find it difficult to handle legal process.
ଆଜ୍ଞା
କିନ୍ତୁ କରିବା ପାଇଁ ବହୁତ ଆଗଭର ହେଇ କରନ୍ତୁ।
obliged।
ତାପରେ ନେକ୍ସଟ ମ୍ୟାଟରରେ ଲେଖିବେ 18941 of 2019, Mr. S.K. Mahapatra for the petitioner, Mr. Samir Kumar, Mr. Senior Counsel, along with Mr. Raut for the opposite party. The matter is listed along with WPC number 6203 of 2025. In view of the order passed in the said WPC, it shall be listed along with the WPC 6203 of 2025 for fresh admission on 19. Yes, please.
Item 7.
Carry lecture is listed for under the heading mediation. 7, Miss Das, yes.
Your Lordship, on the previous occasion,
Yes.
the court had asked to provide for case laws for transfer, Your Lordship. But
Yes. Court rely করছেন কোন?
Your Lordship.
Any Supreme Court decision?
Yes, Your Lordship.
Citation?
Your Lordship, paragraph 9, Your Lordship.
পুরাটা পড়ো। পুরাটা পড়লে if you read piecemeal, that the difficulty is that you miss the
Yes, Your Lordship.
କଣ ହେଲା? Leave granted to ପଢો।
Yes, Your Lordship.
ଆପଣଙ୍କ ବହି କପିଟା ଅଛି?
Yes, Your Lordship.
Yes.
Leave granted. And this appeal is directed against the order dated 19th of November 2020 in TRCMP number 473 of 2020, whereby the High Court of Judicature of...
This was cited earlier, right? I have considered this.
Yes, Your Lordship.
Yes, please.
At Madras has rejected the petition filed by the applicant.
তিনটা পড়ুଛନ୍ତି না ଏବେ?
2, Your Lordship. Point.
ସିଧା ତିନଟା ହଁ ଠିକ ଅଛି। Yes, ପଢો 2 ପଢો ଠିକ ଅଛି।
Your Lordship, from the third line from point 2, the appellant wife seeking transfer of a petition FCOP number 125 of 2020 filed by her respondent husband before Family Court Vellore to Family Court at Chennai. The marriage between the appellant and the respondent was arranged and solemnized on 5th of March 2020 in Kanna Mahal, Anna Salai, Vellore.
So the Vellore case has been filed by the wife seeking restitution.
Yes, Your Lordship.
Sorry, Chennai.
Chennai case, yes, Your Lordship, by the wife for restitution under Section 9 of Hindu Marriage Act. It's at point.
Chennai.
The appellant is resident of Chennai. She has filed 2 cases, which has been filed by her before Family Court at Chennai against her husband for restitution of conjugal
She
rights.
filed Section 9.
Yes, Your Lordship.
So that is
Section 9 and maintenance, Your Lordship.
125.
Yes, Your
So
Lordship.
here has she filed Section 9, your client?
No, Your Lordship.
So that I asked you.
Your Lordship, she has filed an FIR, Your Lordship, against the.
That's the problem.
Your Lordship,
So this is a decision which says that if you have filed a Section 9 application, I have already directed. You must. That is how, if you read in isolation paragraph 10, that leads to a wrong conclusion.
Your Lordship.
Your
Lordship, but
then kindly mark the para 3. You get the facts.
Yes, Your Lordship.
Who has filed an annulment of marriage at which place?
The husband has filed in Vellore.
Hello, Section 13.
Yes,
So wife files 9 at Chennai.
Yes, Your Lordship.
125 at Chennai.
Yes, Your Lordship.
So in your case,
Yes,
has the wife filed Section 9? Because I asked you,
Your
remember,
Lordship, yes.
what is the objective of the wife? She wants to continue the matrimony.
No, Your Lordship.
Now you just mark why the Chennai court. Have you read the High Court judgment?
Of this High Court, Your Lordship?
No.
In this case?
The judgment of High Court which was challenged before the Supreme Court.
No,
What was the reasoning?
No, Your Lordship.
Then only you can develop your argument. And your case is completely distinguishable because she doesn't file a Section 9. She files criminal cases. The question to you is that wherever the wife files criminal cases against the husband, is it the law that it has to be transferred to that place only?
No, Your Lordship.
Now since Section 9 and 13 have to be tried together. Section 9, restitution of conjugal rights, and Section 13, whoever may file, whoever may be the opposite party or petitioner,
Yes,
they have to be considered together. Because otherwise, that will lead to a situation where conflicting decisions can be passed.
Yes, Your Lordship. Your Lordship, but.
Then kindly mark 5. Para 5 you mark.
Yes, Your Lordship. The appellant in a petition filed under Section 9 of Hindu Marriage Act has contended, amongst others, that without any reasonable excuse, the respondent withdrew from her society and that the respondent is bound to live with the appellant and give her conjugal companionship.
So that was the question to you. You want to lodge FIR 498A 307 against the husband. Your case is not para 5.
Yes, Your Lordship.
So, but you start reading 6, not highlighted 1, 2, 3, 4, 5. Not a single highlighter mark in 1, 2, 3, 4, 5.
Yes, Your Lordship.
So if I rely on this, then I have to reject your application because this is a decision directly against the point what you are arguing.
Yes, Your Lordship. Your Lordship, but
So along with 6, you should have read 1, 2, 3, 4, 5.
yeah, understood, Your Lordship. Your Lordship, but she has filed a
Then kindly mark. So whenever that Queen versus Latham, that decision, Lord Halsbury's, this seat of philosophy. Yeah.
Which case, Your Lordship?
that what is a precedence? Lord Halsbury's 1900 volume 1 all Indian law reports or 1901. One 1902 appeal cases there.
Your Lordship, but she has filed.
So the law is yet to evolve that wherever the wife lodges a 307 and 498 case, criminal trial cases against the husband, the 13 and 9 applications have to be tried there.
No.
Because the question here, the division bench of the Honorable Apex Court is of the clear view that since the wife is filed section 9, and even you see what is the why the court has quoted the pleadings there in para 5. This can't be a pleading before the Supreme Court. Supreme Court doesn't have jurisdiction also to try a family court. I'm sorry, a matrimonial cause.
Yes, sir.
I mean, of course, the High Court also doesn't. It is only the family court who has jurisdiction to address that. So unless you read, unless you read the judgment with the context, and suppose you read without the context 1, 2, 3, 4, 5, then it gives a different conclusion.
Your Lordship, she's filed a maintenance case as well.
Exactly, 125 section 9. Why the court has highlighted section para 5 and section 9 application? Two very seasoned and wise persons. Why they have highlighted that? In fact, partly my understanding is that also. That is how when I ask you hear these matters, I am asking the lawyer that have you talked to your client? What is the ultimate objective? If she wants to injunction, then counseling is the earliest part is better because the feelings get frozen. The language used in some decision by Supreme Court, it gets frozen.
But Your Lordship, section 24 of CPC does not talk about presence of a different case in a different court, Your Lordship. It just says the transfer of any suit, appeal, or other proceeding pending before it for trial, Your Lordship. So,
It is your imagination. You have to give wings to your imagination, you have to have some case law. Even the Supreme Court has not said that. Then why notice is issued to the other side? Why other side is to be heard? Because your convenience you are pleading. Read 24 further.
transfer any suit, appeal, or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose the same, or withdraw any suit, appeal, or other proceeding pending in any court subordinate to it and try or dispose the same, or transfer the same for trial or disposal to any court subordinate to it or competent to try or dispose the same, or retransfer the same for trial or disposal to the court from which it was withdrawn.
Ignore that. So just go to the stage where it says notice.
Your Lordship, that's at the beginning on application of any of the parties and after notice to the parties and after hearing such of them as desired to the parties.
Why it is necessary?
Your Lordship,
because the party who is saying it is inconvenient, that's fine. That is, it is her inconvenience is to be good.
No, Your Lordship.
Why notice to be issued?
Your Lordship, to understand both the parties.
Exactly. The law is not that it is a choice. Then the word is not used. It's simply at the choice. And when the Supreme Court considers Section 9 application filed by the wife at Chennai, it should be tried at Vellore. It's at Chennai. Why at Below. Then you have also not highlighted 10.
10, Your Lordship, I read, but I didn't highlight it. Your Lordship, yes. Further, when two or more proceedings are pending in different courts between the same parties, which raise common question of fact and law, and when the decisions in the cases are interdependent, it is desirable that they should be tried together by the same judge so as to avoid multiplicity in trial and the same of the same issues and conflict of decisions.
Also read 11 and 12.
As noticed above, the appellant is a young lady aged about 21
Oh,
years.
just read that post because that is already there.
Yes, Your Lordship.
Further, next page. Further, it is also just and proper.
To club all the three cases together to avoid multiple.
So in this case, which cases have to be clubbed?
Your Lordship, Your Lordship, it's a criminal trial.
It cannot be clubbed. In fact, you have not also highlighted 11.
Yes, sir.
12 also you have not highlighted.
No, Your Lordship.
In fact, 125 is not triable by the magistrate only. Criminal trial, it can be a additional session judge. Now, assistant session judge is abolished, or the sessions court, and it's a family court. It can be clubbed also. While reading these things, we are missing these crucial points. By reading only one, it is the convenience of the party. You see, you have accused someone, he is facing trial. So that cannot be the ground for transferring his case. It has never evolved. This para 3, just read para 3. More than the augmentative science. Read para 3.
Yes. The reliance of additional government advocate on the decision of Apex Court in G. Ramagowda versus Special Land Acquisition Officer would not come to the aid of state in as much as the fact matters of that case are miles away from the appeal herein. It hardly needs to be stated that a decision is an authority for proposition laid down in a given fact matrix, and not for all that would logically follow.
So this is the mistake you have done actually. What could logically follow? That is your interpretation. Then you must read further. Read this further.
What has been so let down,
Right.
said Lord Halsbury, yes, more than a century ago in Queen versus Leatham. As we quote, now before discussing the case of Allen versus Flood and what was decided therein, there are two observations of a general character which I wish to make, and one is to repeat what I have very often said before, that every judgment must be read as applicable to the particular facts proved and assumed to be proved, since the generality of the expressions which may be found there are not intended to be expositions of the whole law, but governed and qualified by the particular facts of the case in which such expressions are to be found. The other is that a case is only an authority for what it actually decides. I entirely deny that it can be quoted for a proposition that may seem to follow logically from it. Such a mode of reasoning assumes that the law is necessarily a logical code, whereas every lawyer must acknowledge the law is not always logical at all. Appeal dismissed.
So this is a division bench judgment by Justice Krishna Dixit and me.
Yes,
That
Lord.
is also binding on me. My senior told me to read Queen versus Latin very early when I joined not late. His library, he has appeal cases, volume 1, he has. I read it in original. All Indian law reports, it is also there. In our library, I have copy. I mean, Halsbury's Laws of England is the same Halsbury, not Halsbury. So it is very profound. Very briefly, he has in 2 lines, he has summarized, and still it is followed. And it is followed in India. My research shows it goes up to 67 judgments. Queen versus Latin has been cited, 67. One of the latest being 2025, volume 9, SEC 359. Only that principle. Because if by following Queen versus Latin, you can say, then we argue the method. NCB Aishwarya versus A.S. Sarvana Kartika can be interpreted that wherever the wife files FIRs against the husband, the cases should be transferred there. Then the problem is, there's another problem, lack of jurisdiction. Because section 9 and of CPC, 24 of CPC, Family Court Act section 17, 7 of Family Court Act section 5, 7.
Yes.
Hindu Marriage Act section 17. They have no such kind of a concept which has been introduced now. But here, if you read para 1, 2, 4, 5, 11 and 12 in Aishwarya, it's very clear the court has a purpose. Court has a purpose.
Your Lordship, but the fact remains that.
So in fact, thanks for your time, and actually you have worked on it. But of course, NCB Aishwarya has been already cited before. To be fair, because when I asked to read the facts, I could guess it that when you said Chennai and Vellore, I could guess it is the same decision. Because observing one line, that it. Now, can you read 9? The last 2 lines which you have highlighted, given the prevailing socioeconomic paradigm in the Indian society, generally it is the wife's convenience which must be looked at while considering transfer. You see, even the Supreme Court uses this kind of language, despite having the para 5, then 3, 4, and 11, 12. Simply, it can direct that let the 3 cases be tried together. Section 9, 13, and 125. Because 125 has to be tried because of Rajneesh versus Neha. Otherwise, 125 is to be tried by the magistrate, not the family court judge. Here, family judges in Odisha are senior most judges. They are senior to district judges. Here, we do not have a concept of principal district judge. In many places, you will find the person manning the family court is a senior judge compared to the district judge, head of the district. So Rajneesh versus Neha has made it that it will be tried by the family court because of maintenance multiplicity.
Yes.
So if you read only those 2 lines, given prevailing circumstances, socioeconomic paradigm, that is hit by Queen versus Latin. And in fact, I asked you that have you filed any application? You have only filed criminal cases against Hon'Ble. And there is yet to any, because it is impossible to try the criminal case together and it doesn't have jurisdiction.
Your Lordship, we're not asking for clubbing of the cases. Your
So
Lordship.
then you have to, but you have relied on a decision clubbing. So that is how I said that then applying Aishwarya versus Sarvana has to be rejected.
Your Lordship,
Because I can't justify.
Yes, Your Lordship.
Paragraphs 2, 3, 4, 5 and 11, 12. That will not come to my aid. ସେଟା ଏବେ ଦରକାର ଏନଫ୍ ତ ସେ ପାରାଗ୍ରାଫଟା କୋର୍ଟ ହେଇଛି ଆଉ ଆପଣ କିନ୍ତୁ ଅଲ୍ ଇଂଲଣ୍ଡ ଲ ରିପୋର୍ଟ ଏଠି ଥୁଆ ହେଇଥିଲା ତାକୁ ଫେରେଇଲେ ନା କ'ଣ ହଜିଲା ସେ ବହୁତ ଦିନ ଯାଏଁ ଥୁଆ ହେଇଥିଲା ମୁଁ ଏଠି ଦେଖିଛି ଏଇଠି ଥିଲା ସେଇଟା ଦିଅନ୍ତୁ ସେଇଥିରେ ଅଛି ସାଇଟେସନ୍ ଅଲ୍ ଇଂଲଣ୍ଡ ଲ ରିପୋର୍ଟ ନାଇଁ ଏଥିରେ ସବୁଗୁଡାକ ଅଛି want the citation you can read it footnote ରେ ଅଛି ନୋଟ କରିକି ଦେଇଦିଅ
Your Lordship, then
ସେଟା ତଳଟା ଯୋଉ ଅଛି ସେଟା ଖାଲି
yes, Your
ସେଟା because both appeal cases one photo level is new to know, no difficulty because nowadays scanning and ଏଇଟାକୁ ପ୍ରିଣ୍ଟ ବାହାର କରିଦେବି ଏଇଟାକୁ ପ୍ରିଣ୍ଟ କାଢ ପେପର ନଷ୍ଟ ଦେଖିଛୁ it is available in the software
in that case, Your Lordship may give us short adjournment.
no you
Satisfied.
when you are doing good work you should be satisfied the approach is very correct whatever you have done in the proper direction but always because what I have found that many times but after even 10 years of practice I used to brief seniors they were I just left it to themselves which decisions are to be cited all entire research is mine but the interpretation and argument because they are doing I have worked with very good seniors prolific they used to decide what point they will argue and which decision they may cite or may not cite so your work is very quality I mean quality wise and I mean if you say relevance is really good you should I mean you should be encouraged actually you should feel encouraged appearance selection
Your Lordship, a short date, Your Lordship.
yes because possibly ultimately the court may arrive at a conclusion that the whatever the wife wants that should be granted possibly but for that we require that kind of research that helps me I have no difficulty in saying that but to say that I require some material because it goes to the extreme actually there is nowhere in the any provision is there and Supreme Court decisions are not directly as you have cited if you read that it has a context the learned counsel for the petitioner is had at some length she relies on the decision of the Honorable Apex Court rendered in Aishwarya versus Sarvada additionally Aishwarya versus Sarvada to support her submissions that the petition should be transferred the CP should be transferred from the Learned Judge Family Court Barampur Nanjam to the Court of Learned Judge Family Court Bhubaneswar she relies on paragraph 10 is that's 10
9, Your Lordship.
9 paragraph 9 of the said decision into bracket libel print stop she is also apprised of the paragraphs 1 to 5 11 and 12 of the said decision where the section 9 application the application filed by the wife under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights as well as application filed under section 125 of CRPC were filed and pending at Chennai whereas section 13 of application, whereas section application filed by the husband under section 13 of the Hindu Marriage Act seeking dissolution of marriage was filed and pending at Vellore. So, in the said context, the apex court, the Honorable Supreme Court has observed that all the three cases should be tried together to avoid multiplicity of proceedings. But in the case at hand, the wife has lost criminal cases against the husband, which are pending at Bhubaneswar. And those cases cannot be tried simultaneously along with the application filed by the husband. Under section 13(1), 13 into bracket 1A of the Hindu Marriage Act, the wife being the respondent seeking grant of divorce, grant of decree of divorce, and dissolution of marriage. Stop. The learned counsel has adjournment. The matter shall be listed for fresh admission in the week commencing on 30/6.
29
হব চলিব 29/6 ଆପଣ 29/6 କେତେଟା ରଖିଛନ୍ତି 92 29/6 2026 IA 137 of 2026. The learned counsel, the hard learned counsel for the petitioner, she reiterates her submissions as noted above, as noted in the order dated 5/5/2026 and as well as noted today. Stop. In the interim, it is directed that upon a prayer being made before the learned judge, family court, Berhampur, upon a prayer being made seeking adjournment in CP number 84 of 2026 before the learned court in session of the matter, the same shall be adjourned to a date beyond 6/7/2026 as would be convenient to the learned court in session of the matter.
Carefully, Raj.
Object certified copy as per. In fact, you deserved this order that day, but somehow I was, or maybe you thought that since I am not issuing notice, so you thought, but I was a little bit overburdened maybe. So yes, keep it up.
Carefully, Raj.
item 8,
May I please, madam?
Mr. Ranjit Das for the petitioner.
Pardon?
Sir, you are Mr. Das.
I am R.R. Mohanty, my lord.
Mr. R.R. Mohanty, I'm sorry. Mr. R.R. Mohanty for the petitioner.
My lord.
Yes, please.
Husband filed divorce, my lord. Before the family court, Jajpur, my lord.
Yes.
Wife filed this petition, present petition, my lord.
Yes.
For transfer. On the ground, my lord. Wife is.
How many cases she has filed against the husband?
Pardon?
You have had your very young
Yes,
friend.
yes, my lord.
So how many cases she has filed against the husband? 498, 307 domestic violence.
She has filed.
302 be filed attempt 304. Attempt I'm just it's file korna.
No, nothing.
So what is your objective, sir? She wants to continue the matrimony or she wants divorce? Did you ask her these questions?
No, my lord, I have not.
You should have. With your age and experience, you should be a counselor also. Because somehow you find that matrimonial matters, it is being done
Compromise.
almost aimless. Knee-jerk reflex. Se case kale mu bhi karibi. Se kale setire case eta karauchandi seta out a factor. Lawyers did not complain. But apna ei jo jinsa ta you should be counseling them. Se jodi chahunchandi separation pai, you should think that 13 bhi hei paribo ki nahi. Amount agree karibe ki nahi. So that the litigation, the length of litigation and what you call attrition, घसी ही कि जिनसटा जो सेटा हबनी In many cases, you will find, sir, when the High Court issues notice, they are not at all responding. The reason being, it is not a claim. It is only a status. It all guy ki rohuchanti, High Court ki asi ki kahingi se kharcha tame bhabuchanti. But eguda pacharan. So husband file kale divorce.
Yes.
Notice niyantu and please ask these questions. Tar out reason achi je apanakara in High Court it is not possible to go for counselling. There is no provision.
Not in High Court.
Family Court Acts mandates it. High Court appoints family court counsellors. They are engaged and employed at family courts. Counselling is a different concept than mediation.
That is something different.
Completely different. Mediation will not work. Counselling will work. And many times you find that the parties are traumatized, irrespective of he or she being husband or wife. They are traumatized. They have a traumatic experience, personal experience. Lot of grief, lot of what you call
agony, all those things. Right?
Sorry,
agony, all those things. Man.
I mean, lot of agony. So, setire bhi apanakara counselling will help, and they can have a clarity in thought. If they want to continue the matrimony, suppose she wants, let her register 13(1). Just say chahu nahanti 13(b).
Take instruction, my lord.
Yes. Apan aji notice nebe na pore notice nebe.
Aji notice.
Hard nodded counsel for the petitioner. Mr. Mohanty, Mr. R.R. Mohanty. Mr. R.R. Mohanty for the petitioner, opposite party black. The petitioner before this court is the wife in the marriage. She seeks transfer of CP number 185 of 2025. The 185 of 2025 pending before the learned judge Family Court Jajpur to the court at
Family Judge Bhubaneswar.
To the court of Family Judge Bhubaneswar jauchanti. Kotagre korunanti so that you can advise her.
Residing at Bhubaneswar.
But apan jibe Bhubaneswar kare ପାଇଁ case. You should assist her. Render her legal advice.
Okay.
To the court at Family Judge Bhubaneswar. बहुत जोड़ा आपनकर मझिया मझी प्लेस हेले कटक ए भलिया जगह रे भद्रक जाजपुर केंद्रापड़ा भुवनेश्वर हेले कोचनी कटक रे हो so you can talk to her only just family court भुवनेश्वर the खुर्दा भुवनेश्वर से खुर्दा he submitted that the petitioner wife after her marriage has run into rough weather stays with her parents at Bhubaneswar. She finds it difficult to attend the case at Jajpur, which is at about Jajpur mane aparakara Jajpur town.
Which is about 300
about a distance of 70 kilometers. Yes. Vara. Issue notice along with this order. Issue notice to the opposite party along with this order. The requisites for issuance of notice by speed post with registration and proof of delivery. We filed within a period of 5 working days. Within a period of 5 working days. Returnable date be fixed to returnable date be fixed to 10/7/2026. The matter shall be listed for orders in the week commencing 20/7/2026. Stop. IA 145 of 2026. At noted counsel for the petitioner, he reiterates his submissions as noted above. Stop. Issue notice as above. Accept one set of. Accept one set of process fee as well as postal requisites along with the petition. In the interim, it is directed that the CP number so and so, pending before so and so, shall be adjourned to a date beyond 27/7/2026, as would be convenient to the learned court in season of the matter, upon a prayer being made for the said purpose. Urgent certificate copy as purpose. Yes, please.
Item 9.
So Manoj Kumar Naik for the petitioner.
May I please?
Yes.
The application for transfer of civil suit pending for the disposal before the civil judge, senior division, Barampur to senior division.
21 suits are transfer kari hobani. It will be status diyantu hela. Status aଣିବାକୁ ପଡିବ. We are telling the family court to dispose of. But 21 matter I will transfer in 26. Must understand. After I get down, I'll speak to them, dispose of the matter, pending matter. We are having the statistics also. We are saying that how many cases are pending. Because we are in a system actually where every day, I mean, everything is being, what you call is being monitored. It is not like exactly administrative work. I think that this kind of monitoring is not there. Who stage is
Cross examination.
Keep the transfer over.
My lord, opposite party, there's a petitioner now. The petitioner is a kidney patient and orthopedic.
Sir, जोठी भी होबो सेटा तो आपनकर क्रॉस एग्जामिनेशन ऑफ किडनी डिजीज रे किछि नाही सीकेडी रे क्रोनिक किडनी डिजीज रे क्रॉस एग्जामिनेशन होबोनी जदी आपण एग्जामिनेशन फाइल करिवे ना ट्रांसफर केमती होबो अदर आपण कहया कथा जे बरहमपुर एटा बरहमपुर रे अछि बरहमपुर रे तो सब डिपार्टमेंट ऑफ यूरोलॉजी अछि डायलिसिस अछि से कोठी अछंती कोठी भुवनेश्वर हेले केमती कोर्ट जिवे
सेटा से जाई पारनाती
जाई परिबेन तो
गोटे थरा
घर पर हेले भी जाई परिबेन
ट्रांसफर कर देले पाखरे एते दूर 200 किलोमीटर ट्रांसफर जीवा आसेटे
अछि बरहमपुर भुवनेश्वर रो बरहमपुर 200 किलोमीटर कहउचंती
माइलर मोर निज घर बरहमपुर
को बाटे जाउछंती
मो ट्रेन रे जाए
ट्रेन रे 200 किलोमीटर बरहमपुर
भुवनेश्वर 160 कटक रो 200 किलोमीटर
आज्ञा से तो रहउचंती भुवनेश्वर रे कहउचंती कटक रो 200 किलोमीटर नो नुआ रास्ता है
भुवनेश्वर 166 गोटे रास्ता अछि आ गोटे रास्ता अछि 185
I have been traveling much before you.
My lord.
The road has reduced now. किडनी पेशेंट करा आपनकर करी होबनी कोठी आपण जदी कोन अन्य मेथड करिवे होबो से जो कमिश्नर विटनेस करिवे तो आपनकर 20 क्रॉस एग्जामिनेशन स्टेज रे ट्रांसफर करी होबनी
My lord, one time this honorable court is pass order to appear through the VC.
सेटा अलगा कथा आईसीटी फैसिलिटेट आपण करिवे आपनकर क्रॉस एग्जामिनेशन ना एटा कोर्ट केमिति करिवे सेटा ताको कथा मु बतै परिबिन बुझपरछन
My lord.
जदि कोर्ट चाहिए जे डिमेनर ऑफ द आपण डिमेनर टा केमिति देखिबे एथिरे बीसी रे लुकिंग एट द डिमेनर ऑफ द I mean for person deposing before the court is an important aspect of any cross examination or examination in chief. Transfer हे परिबन
notice issue करंतु my lord.
होबन सर
There is a
I have already decided that notice issue करि होबनी बोली I am bound by that. Go through have you gone through any decision? एठी आसला माने notice issue होबो
my lord decision is a territorial jurisdiction रे गोटे citation अछि सुप्रीम कोर्ट I will
notice issue होबो all right
section 24 it says
24
that
notice issue होबो आसला माने एठी
then
did you mark how well prepared your learned young she would have passed out 2-3 years back
my lord
have you read C Lalita court is not to issue notice को provision CPC रे अछि अपील करिया पे ऑर्डर केते
24 this is transfer
आपनकर मो अपील पचर छै आपन CPC रे प्रोविजन अपील ऑर्डर 41 रूल 10
my lord
कहि पन दिल भावतुन जे अपन जानने आंती बोले दैट्स नॉट माय पॉइंट इज डिफरेंट the CPC has been amended even without calling for the records the appeal has to be dismissed can be dismissed 11 order 41 rule 11 आपण आर्ग्यू करछन नोटिस इशू करन आपण किडनी आपण आवडे जिंस प्रॉब्लम भी अछि किडनी डिजीज रो सडन ऑनसेट वेन
जति पाखरे थिबे पळे जाई परिबे कार रे
आज्ञा से जोठी की भी जिवे ताकर प्रॉब्लम आपनकर एटा 5 वर्ष 10 वर्ष हला थिबो ताकर आपनकर केस आरंभ हला दिन तो एटा अछि the application has been filed by the wife लिखिसे दिखि लिखाई आजरा लिखले मनोज कुमार नायक the petitioner before this court is the wife in the marriage she seeks transfer of
Not a marriage matter. Civil.
Sorry, continue. To the petitioner seeks transfer of the civil suit number 329 of 2021, where she is the opposite party number 1. So, where she is the defendant number 1.
Defendant number 1 is petitioner number 1 is the defendant number 1.
ଯେତେବେଳେ interject କରିବେ କୋର୍ଟ କୁ be confident that ଆପଣ ଶୁଣୁଛନ୍ତି ଏବଂ ଧ୍ୟାନ ଦଉଛନ୍ତି. ପଢନ୍ତୁ. Defendant number 1. ଆପଣ କଣ କହିଲେ? ପଢ ଯାକୁ ମୁଁ ତ ସେୟା କହିଲି. କାଇଁ interrupt କରୁଛନ୍ତି? Where she is the defendant number, ଆପଣ आज कर देते. She is defendant number 1. Before considering the application for seeking transfer, this court directs the learned judge, learned court in session of the matter, that is Civil Judge Senior Division Berhampur, to furnish a report regarding status of the matter, on how many dates the dependent number 1 is required to be to appear, and whether she can appear by exercise by using the ICT facility. Stop. Such direction is issued considering the submission of the learned counsel for the petitioner that the petitioner suffers from kidney disease. तापर कोन हला रिलीज होला पर कोन हला तागा
Orthopedics. एबे गोड़ हाथ टिके बेड रिटर्न हो गोड़ हाथ चालू नहीं. आंठू दर्द.
किडनी डिजीज हेले गोड़ हाथ कहीं चलीबनी.
किडनी थिला आगुरु एबे पुणी आउथरे आंठू ऑर्थोपेडिक्स आरंभ.
मु भूल बुझतिली ताले मु अधिया भाबी देबी. जेतले कहिबे फैक्ट कोर्ट रे डोंट थिंक दैट कोर्ट विल नॉट थिंक. आपण मु सेते एक्जेक्टली क्रॉस एग्जामिन करतिली. किडनी डिजीज हेले आपण मूव कहीं करि परिबेनी.
किडनी रे सेते बेले मूव करि पारथिले एबे ऑर्थोपेडिक रे गेला.
छाड़ दे. एथि जो it is submitted that the report shall be furnished by the next date. आपन सेठी नेक्स्ट डेट केबे अछि?
18 तारिख अछि.
18
माइनर.
The report shall be furnished on by 18/5 रे अछि.
18/5 रे अछि.
Shall be furnished by 20 आज पठै देबे हैला. By 19 by 19/5/2026 registry shall communicate the order to the learned judge civil judge senior division by tomorrow. आज होची 15 नहीं 14 by tomorrow by 15/5 and report be obtained by 19/5 हैला. The matter shall be listed to be mentioned on 20/5 हैला. In the meanwhile, सिदिन कोन अछि आपनकर
क्रॉस एग्जामिनेशन
कार अछि
ऑपोजिट पिटिशनर.
आपण आए तो फाइल करना है किसी लिखिना है.
आई फाइल करछि माइलर.
द टीआरपीसी केते की मो भूल फाइल करछि
172 आई नंबर.
नहीं
सेटा आजि फाइल करले तो आसी
कहले हबन
नंबर हे जाइछ.
Is submitted by the learned counsel for the petitioner that the petitioner is to appear and depose on 18/5/2026 before as direct as per the next date fixed by the learned court in session of the matter. On 18/5/2026, if the matter is taken up, it shall be adjourned to 22/5/2026 by the learned court. The communicate है ना? Yes.
Obligation.
The prioritize करते हैं. इसको तापुर लाइन लिखो तो this court takes note of the fact that the suit is of the year 2021. Therefore, it requires expeditious disposal. And apparently, the learned court is proceeding in the matter diligently and has fixed for examination of witnesses, examination of the cross-examination of witnesses. Yes, next.
Item 10,
So Sangram Mishra for the petitioner. Yes, Mr. Mishra.
In this petition, the petitioner challenging the impugned order dated 27 passed by the Honorable Judge of Family Court Kotak, denying interim maintenance in
24 रे.
Yeah.
24 interim maintenance. 24 application.
Again, without assigning any reason. Say, हमें assess
24 रे आपनकर रीट हो because it is a interim application. Otherwise 13 रा तो हवा कथा division bench.
review.
Hard noted counsel for the petitioner. Appearance देख ले. Yes. Opposite party, Mr. Sangram Mishra. Opposite party blank. Hard noted counsel for the petitioner. The petitioner before this court is the wife in the marriage. She challenges the order passed by the Honorable Judge Family Court dated 27/1/2026 in IA number 86 of 2025. So the IA arises out of CP number 940 of 2024. The CP has been filed by the husband in the marriage.
Wife.
Upon CP file करछन.
आगे.
Copy टा नहीं. अच्छी.
अच्छी.
The CP has been filed by the petitioner under section 13(1) of the Indian Marriage Act. The husband in the marriage being the opposite party for dissolution of marriage solemnized between the parties on 9/2/2023 and grant of decree of divorce. So reason कौन देले सर? कहीं वो मना कर ले. Anyway, अपन पाइन हाथी तो नियत notice. It is submitted by the Honorable Counsel for the petitioner that the order rejecting the prayer for pendental light maintenance under section 24 of the Indian Marriage Act is contrary to law and is not based upon proper appreciation of materials on record. Stop. Issue notice along with issue notice to the opposite party along with this order. Stop. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within how many days, sir?
7.
Within 7 working days. List the matters shall be returnable date be fixed to. Typical posting करेगा क्या?
27.
Matters shall be listed in the week commencing 27/7/2024. Returnable date टा लिखी दियो तू. Returnable date fixed to 14/7. Order will be listed in the week commencing 13/7. Returnable date be fixed to 6/7.
Right.
Yes. Yes. Next text.
12,
Next. You want to pass through the other document? Yes, Mr. Sahoo.
Please, Your Lordship. Lordship,
Mr.
in this,
Sahoo along with Mr. Amit Prasad Bose.
Lordship, here I,
Prasad Bose along with Mrs. T. Sahoo for the petitioner. Yes.
Lordship, kindly allow my leave petition, Your Lordship. That is IA number 7753 of 2026.
Yes.
I have filed this application seeking leave to allow me and my other brothers and sisters to proceed with this case, Your Lordship. As I have challenged this application, challenging the judgment and decree passed in civil suit number 50 of 2005, the Learned Senior Civil Junior Division Baleshwar, wherein basing on a compromise petition under Order 23 Rule 3 of CPC,
Yes.
the judgment and decree has been passed by the Lok Adalat, Your Lordship.
Yes. Grounds of challenge.
In that petition, I was not the party, as well as with the pro forma opposite parties whom I have implicated in this petition. They were also not the parties. The suit was filed by my
How do you say that you are a necessary party?
because I am the son of defendant, Your Lordship, in the suit, Your Lordship. And that the suit was decreed by my
You are son of.
Mumtaz Ali Khan, Your Lordship.
So and what was the
My-
suit about?
Suit about partition, Your Lordship. One of my younger brother who has filed the suit against my father, and the suit was decreed in the Lok Adalat, Your Lordship, by filing a compromise decree, Your Lordship.
So partition, you have not got any say?
No, no, Your Lordship. Neither me nor my other opposite parties, pro forma opposite parties. They are also the brother and sisters of me, Your Lordship.
Hard learned counsel for the petitioner. By filing the writ application, the petitioner challenges the judgment and decree dictated. What a copy करना थी? Can object.
Lordship.
Yes, it is best. But somehow it doesn't open to that page. ମାନେ ଏତେ ଗୁଡେ ଡକ୍ୟୁମେଣ୍ଟ ଯଦି ଗୋଟେ ଆନେକ୍ସର ରେ ଦେବେ କେମିତି ହବ? Should have made it separate annexes.
Lordship, that was only the compromised petition, Your Lordship.
ମତେ ଆପଣ ଯଦି ଯୋଉଟା ଇମ୍ପ୍ରୁଭଡ ଜଜମେଣ୍ଟ ଟା ନଦେଲେ ତ କିଛି କରି ହବନି। ଇମ୍ପ୍ରୁଭଡ ଜଜମେଣ୍ଟ ଟା ପାଉନି ମୁଁ ବର୍ତ୍ତମାନ। ପ୍ଲେଣ୍ଟ ର କପି ଇମ୍ପ୍ରୁଭଡ ଜଜମେଣ୍ଟ ଟା କଲ by Monday ଦେବେ ନା କେବେ ଦେବେ?
Yes, Your Lordship, by tomorrow I will file.
The learned counsel for the petitioner. The matter is listed for fresh admission. The learned counsel for the petitioner submits that she shall file the copies of the plaint before the trial court as well as the judgment and the decree. The suit apparently being a suit seeking partition of family property.
May I pray one thing, Your Lordship? The petition plaint is there, Your Lordship. That is written in Oriya. That is under Annexure 1 series, Your Lordship. CS number 50 of 2005, Roman 1. आम्भे व्यक्ति निम्नोक्त मते आवेदन करूछु कि
मतलब 23 टा पड़ता है।
yes, no, Your Lordship. Lordship, kindly have a glance to page number 14, Your Lordship. That is there.
इंग्लिश ट्रांसलेशन भी दियंतु ହେଲା ନା କଣ କରିବେ ଆମର ଟ୍ରାନ୍ସଲେସନ ଡିଭିଜନ ଅଛି କଣ ଲେଖିବ ସେଟାକୁ କାଟି ଦିଅନ୍ତୁ ପୁରା hard learned counsel for the petitioner. The petitioner is before this court challenging the judgment and decree passed by the learned Lok Adalat. That is Civil Judge Balasur in CS number 50 of 2005-1. He submitted that the plaintiff before the Lord was one of his brothers. The partition suit was filed seeking partition of family property, which the present petitioner has a share. However, his father was made the only defendant as evident. Stop. IA mistake likhibe. IA 7753 of 2026 has been filed seeking leave to challenge. Apar seta 7 re korchonti. Seeking leave to proceed in the writ application as well as further leave to impeach other sons and daughters of the pro forma opposite party in the present petition. issue notice to the opposite parties, number 1 as well as pro forma opposite parties 2 to 7, along with this order in the IA as well as its petition. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 7 working days or 5
Yes.
working days.
5 working.
Within 5 working days. Returnable date be fixed to 13/7/2026. The matter shall be listed for orders in the week commencing 20/7/2026. Yes.
Great.
You wanted to mention. The rest of the matters after recess.
Right, my lord. This noting is that, my lord, 80.
25.
35, my lord.
35.
My lord. Here, my lord, the noting is that neither ready nor undelivered notices against sole of fees returned.
So let us awaiting sufficiency, it can be adjourned. So take a date. 35.
My lord, the interim order is there, my lord, adjournment.
Adjournment ଅଛି.
My lord.
এটা orders ପାଇଁ call କଲା ବେଳେ ଡାକିବେ The petitioner none. Mr. Anshuman Sethi for OP2. None appears for the petitioner elected. So quite over. To grant further opportunity to the petitioner, list for fresh admission in the week commencing. 29/6/2026. Yes.
Item 14,
The Gautam Charan Rao for the petitioner. Yes.
As against the interim maintenance, petition preferred this application matter. So far as the petition is concerned, marriage was solemnized in
No,
the
I
year
don't need the background.
Hello.
You have come against the order
interim maintenance matter.
passed by the
Family judge Barampur
Barampur.
matter.
In an application on the
24 of the Hindus.
24th of February. So who had filed the application? CP?
CP was filed by the wife mailer.
Okay. So what is your stand before the trial court for the denying maintenance?
Mailer. The petitioner is prosecuting his higher study at a high-tech medical college mailer in the branch of community medicine. And during her study career,
Sir, straight away come to the point. I did not ask you what the petitioner is doing. What was your stand before the trial court as revealed from your pleadings for denying interim maintenance? Have you checked? Have you ever bothered to read the pleadings?
Initially it was filed on the RPFM. Subsequently, it was...
Sir, question kon apno feri कहले High Court re. Have you bothered to read the pleadings, your client's pleadings before the trial court denying maintenance? What was your stand? The petitioner wife studying in high-tech medical college will be against, definitely, because if she is studying, she will require more money. Did you take that stand? That since she is studying in high-tech medical college, she is to be denied the maintenance.
The petitioner himself studying in the high-tech medical college. Present petitioner himself studying in the higher study.
Why did he marry then? Has he not read our scriptures? Children used to go to Gurukula at the age of 4 or 5. They return after achieving everything. He has got a donation.
75 lakhs.
So which case law that if you study paying 75 lakhs, you are not to maintain your wife? Did you take that plea first of all? Have you taken that plea?
No.
So, sir, sorry?
I have taken that plea not in the trial court.
Sir, don't do that, sir. Don't do that. Because High Court cannot go haywire or as you call, whenever whatever comes to my mind, I will start because I like you. So I'll dictate that order. That since the petitioner is studying in high-tech medical college, though the plea was not taken before the trial court, it very much appeals to me. What is the amount granted, sir?
20,000 per month.
What is your stand denying that liability, sir?
The petitioner,
ଆପଣଙ୍କର ଦେଖିଛନ୍ତି ସାର୍ ଦେଖନ୍ତୁ ଆମେ ଯଦି ବାରମ୍ବାର ମୁଁ ଆପଣଙ୍କୁ ପଚାରିବି ଆପଣ ପିଟିସନର ହାଇଟେକ୍ ରେ ପଡୁଛି କହିବେ ନହେଲେ କହିବେ RPFM ଫାଇଲ ହେଇଛି so that leads to nowhere. We are running short of time every day because of the nature of the proceeding. I have to hear. And my understanding, humble understanding, is that unless I hear, I have to. I mean, you will not be satisfied. I don't think you have examined the scope of revision, and 227 is still less. 227 power is much less also. Now, recent two decisions of the Honorable Supreme Court.
Wife has filed all the cases.
What was the evidence laid by the wife regarding your income?
She has
Mr. Raut, voluntary deduction will not be a ground to deny maintenance.
My lord.
Tomorrow you'll after while where do you stay? You stay in Bhubaneswar.
My lord.
So while traveling to High Tech Medical College, you have to travel in a BMW. Very well.
No, my lord.
Why no? Audi you will like or what?
No,
Mercedes.
No, my lord.
How do you know that, sir? I'm asking about your client.
My lord.
So he studies and he stays nearby and travels in a BMW. He takes a loan because BMW, Audi, all are available in finance scheme. He says that I have to repay the loan. Whether that will be a ground to deny maintenance by the court, that is the question, sir.
Yeah.
So voluntary deductions are not involuntary deduction like taxation and all that, except your expenses, your other legitimate because you like to stay in a 5-star hotel in Bhubaneswar.
My lord.
So every day the bill is 25,000. But can that be a ground for the court to not to grant maintenance?
What happened, my lord, in this case, the wife has filed the
ଆପଣ କାଉଣ୍ଟର ରେଡି ଫାଇଲ କରିନାହାନ୍ତି ପଢିଛନ୍ତି ବ୍ରିଫଟା ପଢିଛନ୍ତି ସାର୍ ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି ଆପଣ ମତେ କହିବାର ଥିଲା ମୁଁ ଯେତେବେଳେ ଆପଣଙ୍କୁ ପଚାରୁଥିଲି
The trial court he has not filed it.
It cannot be proved, sir. Whatever was there, that was the final. रे आपणकर ऑर्डर 9 रूल 13 फाइल करी हबो My understanding is cannot be.
No, ma'am.
Chakravarti?
No, ma'am.
कौन कहिबे ताले और यदि केस को खातिर करिवेनी केमते हो केस को खातिर न करिवार प्रोविजन कोठी नाही इच्छाले करिवे नहले करिवेनी इच्छाले फाइल करिवे इच्छाले एविडेंस देबे You have a difficult case, Mr. Raut. What can be done?
This is happening there, madam. This is happening there at Barampur, madam.
Not Barampur, sir.
Yes, ma'am.
माने Barampur लोग खाने को castigate करते हैं. अपन जा कर Barampur के written statement file करना नहीं. That is not a good thing to do. Vakala Narayan Swamy पढ़िଛନ୍ତି? Vakala Narayan Swamy evidence है. Leading decision. Trunk murder case जो it was confirmed by the then Supreme Court of Madras. That is from Barampur. That still remains the leading case. It is a very rich and endowed bar. ଆପଣ ଆଜ୍ଞା ଯିବେନି ଓକିଲଙ୍କୁ ଦେଖା କରିବେନି ରିଟେନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କରିବେନି ଏମିତି ଆଜ୍ଞା ହବନି you have to be sincere in prosecuting the matter. You talk to your wife. ସେ କିଛି କରିପାରିବେ ଆଜି ଏବେ କ'ଣ ଜଏଣ୍ଟ ପିଟିସନ ଦେବେ କ'ଣ କରିବେ? Yes, my understanding is also endorsed by the other members of the bar that Ordinance Rule 13 file kari hobani interlocutory application.
She has filed several cases against the petitioner. All the proceedings is going on.
ଆପଣ ତ ହାଇଟେକ୍ ରେ ପଢୁଛନ୍ତି ତାହେଲେ ଆପଣ ତ ଗୋଟିଏ ପ୍ଲି ଆଉ ମୋର କୋର୍ଟ ଯିବାର ନାହିଁ ମୁଁ ହାଇଟେକ୍ ରେ ପଢିବି. We are bound by all this. Court is not a place where everything will be given a go by. The law goes haywire. The logic and reasoning goes for a spin. Pleadings goes for nothing. Pleading to the karibar hi nahi hai. I had allotted counsel for the petitioner. The petitioner before this court is the husband in the marriage. He challenges the order passed by the learned Judge, Family Court, Ganjam, Family Court, Barampur and Ganjam, in CMC number 09 of 2024, arising out of CP number 196 of 2024. The CP has been filed by the opposite party wife in the marriage ମୁଁ ପିଟିସନ ଦ ହଜବେଣ୍ଡ ୱାଇଫ ଦେଖିବି ତାହେଲେ ଠିକ ଅଛି ତେବେ ମୋର ବି ଭୁଲ ଭାଲ ଆରମ୍ଭ ପିଟିସନର filed by the opposite party wife in the marriage seeking dissolution of CPR copy ଅଛି କି?
Restitution of conjugal rights.
Seeking restitution of conjugal rights under section 9 of the Hindu Marriage Act. And IA has been filed under section 24 of the Hindu Marriage Act, seeking maintenance pending act. Stop. It is submitted by the learned counsel for the petitioner that the petitioner studying PG, studying PG at PG. The petitioner husband is prosecuting, the present petitioner husband is prosecuting his PG studies in medicine, not surgery.
No, ma'am.
Orthopedics and anesthesia.
Community medicine.
In community medicine at High Tech Medical College. He has to pay his course fees and the college fees, which is a huge amount, and he finds it difficult to pay the maintenance pending at the rate of rupees 20,000 per month. The learned counsel for the petitioner was requested to refer to the pleadings before the learned judge family court in the CMC. He submits that the petitioner chose not to file any reply to the application before the learned judge family court. In such scenario, the petitioner, the learned counsel has adjournment to obtain instruction and address. Obtain instruction, stop. The matter shall be listed for fresh admission in the week commencing. After vacation. Afterwards. Fresh admission. After. 13/7/2026.
15. Stay of the further proceeding.
Take out further proceeding. CMC disposed of it. Pending CMC no.
Execution kare ta
execution file kale apno se kotha hebe to nal se apno pacharibe se apno ko bi high tech kar debe execution अछि बोली आगे वकील मानकर टिके वैल्यू अछि आपण मन भाउछन त वकील कहले रिटन स्टेटमेंट दियोनी बोली yes
I'm a PG lawyer. But so here is a case where I am for the wife of the party married. I have filed the application letter. IA number 190.
Other state ଆପଣ ହଉଛନ୍ତି opposite party sir.
ଆଜ୍ଞା
petitioner କାହାନ୍ତି?
ତ ଆସୁନା ଲାଷ୍ଟ ଅକେଜନରେ ଆସିନଥିଲେ ଏଥିରେ ବି ନାହାନ୍ତି କପି ନେବାକୁ ସାର୍ ମୁଁ ହ୍ୱାଟ୍ସଆପରେ ପଠେଇଲି କପି ମାନେ ଫିଜିକାଲି କପି ଆସିଲେନି ନେବା ପାଇଁ କପି ଦେଲି ଏବଂ କହିଲି ସେଠି ବି ପଇସା ସବୁ ଦେଉନାହାନ୍ତି କଥା ହଉଛି କ'ଣ ସେଠି February mass, January mass upon the HND. The Honorable Court has passed the order on 9/12. And in fact, as per the reason of the Honorable Court, no notice was served on me. Declared file notice golani. Setting certified copy the trial court. You also may kindly see, for a moment, I have attached the order of the London court below. That is right from page 4, my lords. That page 4, that is order dated.
1 lakh ଦେଇଛନ୍ତି?
ଆଜ୍ଞା ଦେଖନ୍ତୁ 1 ଲାખ ଦେଇଛନ୍ତି 7,500 ପ୍ରତି ମାସ ଦେବା କଥା 7,500 ନଭେମ୍ବର ମାସ ପାଇଁ ଦେଇଦେଲେ ଡିସେମ୍ବର ଦେଲେ ଜାନୁଆରୀ ଦେଲେ ଫେବୃଆରୀ ମାସ ଯୋଉଟା ଚେକ୍ ଦେଲେ
ଆପଣ ମୁଁ ତାଙ୍କର କଣ ମୁଁ ଫ୍ୟାମିଲି କୋର୍ଟ କୋର ଏକ୍ଜିକ୍ୟୁଟିଂ କୋର୍ଟ ନା ଶିରସ୍ତାଦାର
ନାଇଁ ସାର୍ ସେ ଅର୍ଡରଟା ଭେକେଟ୍ ହେଇଗଲେ ସେ କରିବ ନା ଏଇଟା ଯୋଉ
ଅର୍ଡର ପଢିବେନି
ନାଇଁ ସବଜେକ୍ଟ ଲେଖା
ପଢିଲେ 4
ଆଜ୍ଞା
4 କଣଟା ଆପଣ ସବୁ ଆପଣ ଯୋଉଟା ଫେଭରରେ ତାକୁ କହିବେ ଭେକେଟ୍ କରିବା ପାଇଁ
ନାଇଁ ସବଜେକ୍ଟ ଯୋଉ
ଆରେ ସିଏ ଯଦି ସେ ଆରେ ହି ହାଜ ଇନଭାଇଟେଡ ଦ ବେଲ୍ आ बेल मुझे बार हिंदी शुणिचंती एटा तो ताको अगेंस्ट ऑर्डर आपण के तांकर आपण तो तांकर मोस्ट वेल विशर अरे जदी कोर्ट गोटे कंडीशनल ऑर्डर करछि त पार्टी कंप्लाई करूनी आपण कष्ट होचन
से करूनी बले मु चढ़िया कष्ट होछ बता
हाउ कैन से आपण लाख टका नेले
आगे लाख टका से दिबे
उदिन नेले
से जो 22/12 रे
22 ଲକ୍ଷ ଟଙ୍କା ନେଲା ପରେ କଷ୍ଟ ଆରମ୍ଭ ହେଇଗଲା ନା ତା ପୂର୍ବରୁ କଷ୍ଟ ହଉଥିଲା?
ନାଇଁ କଷ୍ଟ
22 5 ବର୍ଷରେ ଆପଣ ଲକ୍ଷ ଟଙ୍କା ଉଡେଇ ଦେଲେ ସେଥିପାଇଁ କଷ୍ଟ ହେଲା ନା ଆଗରୁ କଷ୍ଟ ହେଇଥିଲା?
ନାଇଁ ସାର୍ ସେ କଷ୍ଟ
ଆରେ you are not looking at the court order even ପଢିଲେ ପାରା 4 ଟା
ଆଜ୍ଞା
where is the restraint ଭେକେଟ୍ କରିବାକୁ କୋଉଟା ଭେକେଟ୍ କରିବି ମୁଁ?
ସାର୍ ଏଇ ଯୋଉ ମାନେ ଯୋଉ ଅର୍ଡରଟା ସେ ଡିପୋଜିଟ୍ କରିଦେଇଛନ୍ତି
ଆରେ ଆପଣ ଓଡିଆରେ ଲେଖାନି ଇଂଲିଶରେ ଲେଖା
ଆଜ୍ଞା
ହେଇଛି
ମୁଁ ପଢି
ଆପଣ ଓଡିଆରେ କହୁଛନ୍ତି
ଦଉଛି lordship may can see matters that the as an interim
kindly see and read lordship has already seen para 4 ପଢନ୍ତୁ
as an interim measure right from that as an interim operation of the impugned order or judgment that is so and so passed in so and so by the so and so court of is stayed subject to the petitioner depositing
speed command ଆପଣ ତରବରେଇ ପଡିଲା ବେଳକୁ you are missing the point
ଆଜ୍ଞା is stayed
subject to the petitioner
subject to petitioner depositing an amount of rupees 1 lakh in shape of demand draft to be drawn in the case in the name of the opposite party wife before the learned judge family court Jajpur within 4 weeks hence so also going on paying rupees 7,500 every month by 10th of the succeeding months.
So ମୋଟା କୋଉଟା ଭେକେଟ୍ କରିଦେବି?
10th of the succeeding month
ଭେକେଟ୍ କରିଦେବି?
ଦଉନାହାନ୍ତି ବୋଲି ସେ
ଆରେ ସେଟା ମୁଁ କଣ କରିବି ସେଟା ଆଜ୍ଞା?
ସେ ଦଉନାହାନ୍ତି ବୋଲି ତୁମେ ଆସିଛି
7,500 କିଏ କରିଥିଲେ? ଆପଣ ଆଇଏ ଫାଇଲ୍ କରିଛନ୍ତି ଆପଣ କହିଲେ ଆର ସାଇଡ୍ ଆସୁନାହାନ୍ତି ମୋ ହ୍ୱାଟ୍ସଆପ୍ ରଖୁନାହାନ୍ତି ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ସିରିୟସ୍ ମୁଁ ଆଉ ଥରେ ଆପଣଠୁ ମେମୋ ନେବି ଅର୍ଡର ଭେକେଟ୍ କରିଦେବି without worrying about the consequence and I'll record that I have made you aware of the consequence of interim order binding the other side. ଆପଣ 7,500 ଏକ୍ଜିକ୍ୟୁସନ କରିବେ କି କଣ କରିବେ ସେଟା ଆପଣ ବୁଝିବେ ନା ମୁଁ ଏଟା ଭେକେଟ୍ କରିଦେବି ଗୋଟେ କୋର୍ଡିନେଟ୍ ବେଞ୍ଚ ଅର୍ଡରଟାକୁ which is well reasoned and it is a conditional order. ତାପରେ ଇଣ୍ଟରେଷ୍ଟିଂ ହଉଛି ଆପଣ ଲକ୍ଷ ଟଙ୍କା ନେଲା ଭେକେଟ୍ କରିଦେଲେନି ଲକ୍ଷ ଟଙ୍କା ପୂର୍ବରୁ କହିଲେ ମୁଁ ଲକ୍ଷ ଟଙ୍କା ନେବିନି
ନା ସାର୍ ସେଟା ସେ ବର୍ତ୍ତମାନ ସହ ପଇସା ଦଉନାହାନ୍ତି ଏଇଟା ହଉଛି କଥା
ଆରେ ଲକ୍ଷ ଟଙ୍କା ନେଇ କଣ କଲେ ଆପଣ ଲକ୍ଷ ଟଙ୍କା ପଇସା ନୁହଁ ଟଙ୍କା
ନାଇଁ ଲକ୍ଷ ଟଙ୍କା ନେଇଛି ତା
ଆଜ୍ଞା 7,500 ବି ଟଙ୍କା ଲକ୍ଷ ଟଙ୍କା ବି ଟଙ୍କା ଲକ୍ଷ ଟଙ୍କା ନେଲେ 7,500 ନେଲେ ତାପରେ କହିଲେ ଭେକେଟ୍ କରିଦିଅନ୍ତୁ ମୁଁ କଣଟା ଭେକେଟ୍ କରିବି ଏଥିରେ ଯଦି ଭେକେସନ ହବାର ହିଁ ନାହିଁ ଇଟ୍ସ ଏ କଣ୍ଡିସନାଲ ଅର୍ଡର ଆରେ ଆପଣ ବି କଣ ମାନେ
ଅନାପେଶ ହଉଛନ୍ତି
ଫିସ୍ ଭଲ ମିଳୁଛି ନା କଣ କାହିଁ ଏଗୁଡା କାହିଁ ଫାଇଲ୍ କରୁଛନ୍ତି ସିଏ ତାଙ୍କ କଥା ସିଏ ବୁଝୁଛନ୍ତି
ସେ
ଆସିଥିଲେ ସେ ତାକୁ ନେଇକି ମୁଣ୍ଡେଇକି ବୁଲୁଛନ୍ତି ବର୍ତ୍ତମାନ କଣ୍ଡିସନାଲ ଅର୍ଡର ନଦେଲେ ହଇରାଣ ହେବେ ବୋଲି
କିନ୍ତୁ ଦଉନାହାନ୍ତି
ନଦେଲେ ସେଟା କରିବେ କଣ ତାଙ୍କ ଘରକୁ ଯିବେ ଧମକେଇବେ ନା କଣ What is ମାନେ is it ADR alternative dispute redressal on the street
ସେ ଆଜ୍ଞା ଟ୍ରାଏଲ କୋର୍ଟରେ ପ୍ରୋସିଡ୍ କରିଦିଏ
ଟ୍ରାଏଲ କୋର୍ଟରେ କଣ
ୱାରେଣ୍ଟ କରିବେ
ସେ ଯାହା କରିବେ
ଆଜ୍ଞା
ମାନେ ଆପଣ ହଜବେଣ୍ଡ ପାଇଁ ନା ୱାଇଫ ପାଇଁ
ୱାଇଫ
ଠିକ ଅଛି ତ ତାହେଲେ ଆପଣ ମୁଁ ହେଲେ ଆପଣ ହଜବେଣ୍ଡ ପାଇଁ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଭୁଲ ୱାଇଫ ପାଇଁ କହିଲି ଆପଣ ସିଓର ତ ୱାଇଫ ପାଇଁ କରୁଛନ୍ତି ଯେ ଲକ୍ଷ ଟଙ୍କା ନେଉଛନ୍ତି ନେଇଛନ୍ତି ଏବଂ 7,500 ପାଉଛନ୍ତି
ପାଉନି ବୋଲି ତ କରୁଛି
ପାଉନଛନ୍ତି ବୋଲି ବର୍ତ୍ତମାନ ହାଇକୋର୍ଟ କଣ କରିବେ ଆଗ ଅର୍ଡର ପାସ୍ କରିବେ ତାପରେ ତାଙ୍କ ଘରକୁ ଯିବେ ନା ମିଷ୍ଟର ପ୍ରଭୁ ଆଣ୍ଡ ମିଷ୍ଟର ସେଠି ଟୁଗେଦର ଯାଇକି ସେ ଯୋଉ somebody joke with me ଦି ଜଣ ଅଟୋରେ ଯାଇକି ସେଠି ଓହ୍ଲେଇବେ କହିବେ ଏଟା ବନ୍ଦ କର what is this going on sir what observation I have to make I don't understand this. Sir you have made it really a matter of really funny Mr. No, you are a lively character, but not to this extent. You should not be funny. What is this going on, sir? आपको फेवर ऑर्डर अच्छे अपन तो वेकेशन पे फाइल करिवे.
In fact,
sir, first advice as a lawyer to you is that never go file this vacation application because it is staring at him. That is how he is not appearing also.
But yes, that is he is not.
So he is not appearing because now he is facing hit from both the side in High Court
as well
as trial court. କଣ କରିବେ
ଟ୍ରାଏଲ କୋର୍ଟ କହୁଛନ୍ତି ତମେ ଅର୍ଡର ଭ୍ୟାକେଟ କରିକି ଆଣ ମୁଁ କରିବି ନହେଲେ କରିବିନି କହୁଛନ୍ତି ଏ ଯାହା ଲୟର ତାଙ୍କ କହୁଛନ୍ତି ତାଙ୍କ ଲୟର ଯାହା
ଆଜ୍ଞା ଶୁଣନ୍ତୁ ସେଇ ଯୋଉ ଗୁଡାକ ଆମେ ବି ବାହାରୁ ଆସିଛୁ ଆଜ୍ଞା ସେ ଲୟର ଯଦି ସେଗୁଡା କହିବେ ଲୟର ଖାଇ କହୁଛନ୍ତି ସେଟା ବି ଜଣା ଅଛି ଲୟର କିଛି ପଢିବେନି କହିବେ ଭ୍ୟାକେଟ କିଛି ଷ୍ଟେ ଥିଲେ ତ ଜଣେ ଭ୍ୟାକେଟ କରିବ ଗୋଟେ କଣ୍ଡିସନାଲ ଅର୍ଡର ଆପଣଙ୍କର ଭ୍ୟାକେଟ କରିଦିଅନ୍ତୁ ଆପଣ ଯଦି କହିବେ ଆଇ ଭ୍ୟାକେଟ ଆଇ ଟୋଲ୍ଡ ୟୁ and I mean because I am serious in whatever deliberation I am making. If you say you file a memo, upon to a memo plus IA, order करते. The order is vacated.
Or else may I suggest only one thing that your lordship may
suggest करो तो legal submission करो. It is a suggestion now. I am not sitting here to take suggestions. Make legal submissions. Don't make absurd statements. What you are saying. वकील कहले से vacate करी आन. वकील कौन कहले vacate करी आन तो. नहीं आप कोर्ट कहले वकील शुणी कि आपन कहले दैट यू मीन सेमती कोर्ट कहंतनी
See, my lord, so Lakshmi can see that.
Don't underestimate a family court judge that he will say vacate kari anant. It is a conditional order. The order of the family judge court has been amplified by the High Court.
Subject to reducing the amount. That 10,000 was there, subject to pay 7,000.
Debeni tale city execute kari execution file kari.
Lakshmi can object that. I will say.
Observe kari mo kona assistant.
Say observe execution.
City by execution by kisi observation darkar nahi. Court provision na chije High Court observation nal execution nahi paribani. Sir, apna finally decide karantu kon karibe.
See again not pressed. Petitioner nahanti petitioner dismiss kar diya jo eta proceeding na.
Nahi seta. Seta besi he gala. Apna Supreme Court he gale.
Se bhi na.
ଆପଣ ଆଇଏ କଥା ହିଁ କୁହନ୍ତୁ ଆପଣ ଆଇଏ କଥା କୁହନ୍ତୁ
ଆଜ୍ଞା କିଛି କରିନାହାନ୍ତି କି ରହୁନାହାନ୍ତି ଲାଷ୍ଟ କେତେ ନଥିଲେ ଏଥିରେ ବି ଆଜି ନାହାନ୍ତି
ସେ ଆଜ୍ଞା ହେଲ୍ପଲେସ୍ ହାଫଲେସ୍ କେହି ନୁହନ୍ତି ସେ ବର୍ତ୍ତମାନ ତାଙ୍କ ଓକିଲକୁ ବିରକ୍ତ ହଉଥିବେ କହିଲେ ମୁଁ ଆଚ୍ଛା ହାଇକୋର୍ଟ ଗଲି ଆପଣ ମତେ ହଇରାଣ କଲେ
ନାଇଁ ସାର୍ ସେ କନସିକ୍ୱେନ୍ସ ଜାଣିଛି ସାର୍ କନସିକ୍ୱେନ୍ସ ଜାଣିଛି ଇଞ୍ଜିନିୟରଟା ପୁରା ଇଞ୍ଜିନିୟରଟା ପଇସା
ଯାହା ବି ହଉ ଆଜ୍ଞା ଆପଣ
ହଇରାଣ କରିବା ପାଇଁ ଚାହୁଁଛି କେବଳ ଆଉ କିଛି ନାହିଁ କେବଳ ହଇରାଣ କରିବା
ହଇରାଣ କଣ ଆପଣ ତ ହଇରାଣ କରିସାରିଲେଣି
ପଇସା ଦବନି
ଲକ୍ଷ ଟଙ୍କା ଆପଣ ଦେଇଥାନ୍ତେ ସେ
ଲକ୍ଷେ ଟଙ୍କା ଆଜ୍ଞା
ଲକ୍ଷେ ଟଙ୍କା ତାଙ୍କ ପଇସା ନୁହଁ ବୋଧେ
କୋର୍ଟଙ୍କ ଅର୍ଡରଟା ଆଜ୍ଞା
ସେ ଇଞ୍ଜିନିୟର ସେଟା ତାଙ୍କ ପଇସା
ଇଞ୍ଜିନିୟରଙ୍କର ତ ଯାହା
ଡୋଣ୍ଟ ଷ୍ଟ୍ରେଚ୍ ୟୁର ଇମାଜିନେସନ ଲାଇକ୍ ଦ୍ୟାଟ୍ ଆରେ ଆପଣ ସେ ବାଧ୍ୟ ହେଇକି ଲକ୍ଷ ଟଙ୍କା ଦେଲେ ହାଇକୋର୍ଟ ଆସିଲେ କିଏ ଆସେ ହାଇକୋର୍ଟ କୁ ଆସିକି ତାପରେ କହିବ ମୁଁ ଲକ୍ଷ ଟଙ୍କା ଦିଏ ସଫର ଦ୍ୟାଟ୍
ନ ଆସିଲେ ଜେଲ ଯିବେ ନା
କଣ ଜେଲ ଯିବେ 7,500 କାହିଁ ଜେଲ ଯିବେ
ନାଇଁ ଏଇ ଯୋଉ
7,500 ଆପଣ ଯଦି ହାଇକୋର୍ଟ ଆସିଲେ ଭେକେଟ୍ କରନ୍ତୁ ମାନେ ପ୍ରକୃତରେ this matrimonial litigation has become really strange, funny and aimless. This is a classic example.
Yes. So my resolution.
Mr. Bhavani Shankar Mishra for the petitioner, Mr. Subhash Chandra Acharya for the opposite party. None appears for the petitioner when the matter is called. The petitioner is also absent on repeated calls. IA 194 of 2026 has been filed by the learned counsel for the filed by the opposite party wife seeking vacation of language with the following prayer. Therefore, it is most fervently prayed that Honorable Court may gracious enough to lekhi this. The learned counsel was heard at some length. Counsel for the opposite party was heard at some length regarding the IA filed by the opposite party. He is apprised of the fact that the interim order dated 9/12/2025, paragraph 4, is four and 6. The order dated 9/12/2025, particularly paragraph 4 and 6, is in favor of the opposite party. And there should be no reason for the opposite parties to seek vacation of the order, interim order, when the order is itself conditional. Stop. The learned counsel for the opposite party also submits that the opposite party has received 1 lakh as directed by this court, but however, she is not receiving the rupees 7,500 per month. So the opposite party shall have the legal remedy for enforcement of the direction of the family court, for direction of this court as well as the family court, for payment of rupees 7,500 as monthly maintenance by the husband. Stop. The IA is disposed of. Memo file koleni. IA disposed of. Yes, next.
16.
Yes.
For adjournment.
16. Mr. Palta Singh.
Yes, ma'am.
Yes, Mrs. Rana.
Yes.
Adjournment. Upon the adjournment.
Yes, ma'am.
16, Mr. S. Parta Singh for the petitioner, Mrs. S. Rana for the opposite party. The learned counsel for the party seek adjournment. The matter shall be listed for orders for orders in the week commencing.
Yes, ma'am.
6-7. In the meanwhile, the learned counsel shall make effort for arriving at an amicable settlement between the parties acceptable to both. Chesta karo. Yes.
17.
17 टा पर mention करथिले से 17 टा mention इन नथिला.
No, my lord. Mr. Learned Senior Mr. Jenna is there. He had a word with me, my lord, regarding the same order will be passed here. As per my lord, the similar matter has gone.
40 of 2000 कितने 24.
40 of 2024.
काली लिस्ट हितला. ते नंबर टा दे देबे से ऑर्डर टा रेप्लिकेट
My lord, that LA 4024 was not listed.
काली जोटा हितला similar
My
order.
lord, I'll give it to.
Serial number कितने काली थिला?
Serial number I am giving it.
अच्छा ठीक अछि मिस्टर किशोर कुमार जेना फॉर द पिटिशनर 17 लेख आपण पाखे अछि हो. This shall be listed with हमको लिखा है मिस्टर प्रभु प्रसन्न बेहरा
Respond number 1.
council এটা appellant বুঝলে কি appellant Mr. प्रभु प्रसन्न बेहरा for appellant R1
Respond number 1.
for R1 Mr. Senior Mr. S. Das SK Das Senior Counsel along with Mr. Praveen Das for R2.
My lord. Lord, item number 16 of the yesterday list.
That's
Item number 16.
marginal लिख दें तो yesterday item 16.
लाभ 4225.
4225.
My lord.
एथिरे नोटिस कोन सफिशिएंट हेलानी ते कोन लेने allowing notice against अच्छा dispensing from 3 to 53 ठीक अछि आइए 50 of 2026 has been filed by the appellant seeking leave for dispensing notice against OP number 3 to 53 3 to 53 and allowing notice only against OP number 1 and 2 today. Today stop the IAS are lie over. However, in view of appearance of the R1 and R2, upon copy दिया है. Upon copy पाइचन Mr.
Yes.
Yeah.
Yes.
Appearance of the matter shall be listed for orders in the week commencing.
Lord, 13-7.
13-7 पुड़िए 26. When similar matters, the similar.
My lord, it is
Similar matters have been directed to be listed. The lead matter being
LA 40 of 2024.
LA 40 40 of 2024.
Shabbos.
Yes. Almost. कॉल करो तुम
18.
May I please? Beloved, I am filing the IA 5570 to amendment the writ petition to insert there is a WBC number 1259 of 2011 disposed on 13/12/2021 be replaced in page number
amendment copy टा ଦେଇଛନ୍ତି
Hello?
amendment application टा copy serve କରିଛନ୍ତି
Yes, Beloved, there was sir.
5-7. No, that was not. I would have.
ନା ନା ସେଟା ହଉଛି 5571 ଟା step ପାଇଁ ଆପଣ amendment ଟା କୋଟା 5570
Beloved, 557.
5570.
What do you serve an extra copy?
Sir, I will serve it.
Mr. Dologovinda Mahapatra for the petitioner, Mr. Prabhu Prasanna Behera. For the opposite party number 1, 3, additional standing counsel for opposite party number 1, 3 and 4. Hello. OP2. ଏଇଟା ଆପଣଙ୍କର ଆଗରୁ ଫ୍ରେଶ ମ୍ୟାଟରରେ ନୋଟିସ୍ ଇସ୍ୟୁ ହେଇଛି?
No notice was not issued.
or এটা Jagatsinghpur.
Bilal, Jagatsinghpur.
Mahapatra, Lord Counsel for the petitioner, being present at the virtual court, High Court of Orissa, Jagatsinghpur, addresses arguments. ଏଇଟା ଆପଣଙ୍କର ଅଲରେଡି ନୋଟିସ୍ ଇସ୍ୟୁ ହେଇଛି, ଏଥିରେ କ'ଣ ଆମେଣ୍ଡମେଣ୍ଟ ହବ? ଆମେଣ୍ଡମେଣ୍ଟ ହେଇପାରିବନି। ଆପଣ କ'ଣ ପଢୁନାହାନ୍ତି କି? କ'ଣ ସେଟା ମ୍ୟାଟ୍ରିମୋନିଆଲ କେସ୍ କଲେ କିଛି ପଢିବେନି, ଏଥିରେ ନ ପଢିବାରେ କ'ଣ ଅଛି? ତ ରିଟ୍ ପିଟିସନ। ଆପଣ CMAPL ଫାଇଲ କରିଥିଲେ ରେଷ୍ଟୋରେସନ ପାଇଁ, CMAPL ରେ କ'ଣ ହେଲା?
Limitation part notice ଦେଇଛି, limitation part notice issue ହେଇଛି।
ଆଉ ଏଥିରେ ଆମେଣ୍ଡମେଣ୍ଟ ଟା କ'ଣ ହବ?
ସେ ଯୋଉ WPC ନମ୍ବର ଟା ମୁଁ ପକେଇ ନଥିଲି,
ଆମେଣ୍ଡମେଣ୍ଟ ଦରକାର ପରେ ଅର୍ଡରରେ ରିଫ୍ଲେକ୍ଟ ହେଇଯାଇଛି। In paragraph 5 of the petition, it has been mentioned that WPC ଏତେ ଆପଣ ପେନସନ ଫେରେଇଲେ? ପେନସନ ଫେରେଇଲେ?
gathered money to return.
କେତେ ଦିନ ଗ୍ୟାଦର କରିବେ? ନା ଆପଣଙ୍କର ମାନେ ଆପଣଙ୍କୁ ବି ସାହାଯ୍ୟ କରିବାକୁ ପଡିବ ମନି ଗ୍ୟାଦର କରିବାରେ। ଆମେଣ୍ଡମେଣ୍ଟ କିଛି ଆଜ୍ଞା ଆବଶ୍ୟକତା ନାହିଁ। ଆପଣଙ୍କର ସେଥିରେ ଆପଣଙ୍କର ଯୋଉ ଡିସମିସାଲ ହେଇଛି CMAPL ରେଷ୍ଟୋରେସନ ହବ, ସେ ହବ, ସେଟା that is another proceeding. That is not before this court also.
Not press, I want to not press that item.
ଆପଣ ଖାଲି ସେତିକି ଆମେଣ୍ଡମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ତ? ଦରକାର ନାହିଁ। IA 55702026. The IA has been filed seeking amendment to mention the writ application number WPC number 1259 of 2011 in the writ application, in the present writ application. The order dated 12/5/2025 already records that earlier WPC number 1259 of 2011 was filed, which was dismissed for non-prosecution, and CMAPL number 14245 of 2025 has been filed for restoration. So, therefore, in considered view of this court, no further amendment is necessary to indicate the name of the details of the writ application. Stop. It is submitted by the Lord Counsel for the petitioner that in the CMAPL notices have been issued on the question of condonation of delay, and the same is pending adjudication. Stop. Accordingly, the matter shall be listed for orders in the week commencing 13/7/2026. Yes, next.
19.
Please.
Yes, please.
This and IA has different to 7.
Yes.
7 to 20. Dear my lord.
ଆପଣଙ୍କ ପଛରେ ଯୋଉ ଆଲୁଅଟା ଜଳୁଛି ସେଟା ଦେଖା ଯାଉନି, ଆଲୁଅଟା ଲିଭେଇ ଦିଅନ୍ତୁ। ଯୋଉଟା କ'ଣ ପ୍ରୋବ୍ଲେମ ହେଇନି, ଆମ ଅଡିଓ ପ୍ରୋବ୍ଲେମ ନା ତାଙ୍କର ଅଡିଓ ପ୍ରୋବ୍ଲେମ? ସେପଟେ
more, sir. Now I am audible, my lords.
Yes. ମାନେ ସେଟା ସେଣ୍ଟେନ୍ସଟା ବ୍ରେକ୍ ହେଇଯାଉଛି। Yes, please speak. Please speak.
My lord, what has happened in this case, my lord? I challenge the demand of the ESI corporation, my lords. Then, my lord, while the matter was pending, they floated this in that amnesty scheme, my lords, and they wrote a letter to us, and accordingly, I filed an IA 1/2020 this court and this court allow mayor and we did to the
Now, in fact, the sentences are not.
then may I pray, my lords, to take up on Tuesday, Monday, Tuesday, any day, because here, my lord, the money has to be returned, my lords.
They have taken the money.
What happened despite a stay order entered by this own court on 12 my lord, at 12/9. Your lordship may kindly mark the date 12/9.
12/9/2025.
Yeah, this on court passed order. My lords, on 12/9, I informed the bank, but the ESI corporation, OSD bank manager, draft 3 lakhs, my lords. That is there. Now, my lord, and fourth were holidays.
IA number ta kete?
7272 by 26.
They took the draft, my lords, and the draft has been expired in the meantime, my lords, so that 3 months' time has gone. They could not encash the draft, so that is idle with the corpse.
ये कॉपी टा नहीं चलती मैडम अपन की जानना है
No, a copy has been not served. And physical copy.
Yesterday, I saw the copy to by the WhatsApp. Okay, Mr. Rupla.
Rupla requested here, sir, my lord. He requested
this you want order on this DD only?
Yes, ma'am. That is on the 8th or 9th.
So I filed the object. As per the instruction, a time may be given to file the objection.
Yeah, objection. आपण तो बैंक पे आपण बैंक पे अपियर करजो ना सुविधा.
Sir.
सीए तो अपियर करजो ESIC पे. The interim order is between the bank and the petitioner.
Yes.
So, sorry, DD. बर्तमान DD टा आपणकर जो रहिला सेतरे आपण बैंक पे अपियर करना. रुपलाल अपियर करू ESIC पे आपण बैंक पे. जड़े लोक केमती दीटा मैटर पे अपियर करिवे दीटा लोक अपना ओपीपी आईए लिखंतु 72 of 2026. The IA has been filed with the following prayers. By order dated 12/9/2025, the coordinate bench had passed the following order. Para 8 quote करते हैं. It is stated in the interim application in the interim application, the developments after the interim order was passed by the coordinate bench has been indicated. Para 4. Para 4 and 5. Para 4 and 5. Copy of the IA has been served on the Lord Counsel, Mr. Rupal, who is appearing on behalf of the opposite party corporation. Through WhatsApp, as submitted by Mr. Mohanty, Lord Counsel for the petitioner. Appearance elected Mr. Somnath Mishra, along with Mr. Joseph Mohanty for the petitioner. Mr. Ms. Singh. कितने नंबर आइटम? What about the power 9 Singh?
No, on behalf of.
Miss S. Singh on behalf
R.
of.
Singh.
I'm sorry, Rita. R. Singh on behalf of S.K. Rupla. of the stuff. Submitted by MS Singh that another copy may be served. Stuff. What a copy did you? Bank notice issue है ना थला?
हाँ सर बैंक को है बैंक को है ना बैंक बैंक में somebody is appearing.
So what वाले?
But bank has no role play.
नहीं draft का बैंक रखते दिया अपन पूछन्ती?
नहीं बैंक नहीं draft has kept by
demand draft is instrument. The money is deposited with the bank.
Yes. Money, my lord, from my account, draft has been sent to the ESI corporation. Now the draft is with
draft is not sent. Draft is drawn in favor of ESI corporation, which has since expired due to 3 months. So the money is with the bank where you have prepared the draft. If the draft is presented before the drawee bank, then only they can draw, and that has to be from the parent, the issuing branch. So the money is with the issuing branch. Draft encashed, if it has been encashed, then the money is with the ESI. If it is not encashed,
draft has not been encashed.
So that is the reason that it is with the bank.
No, it is with the that bank sent draft. They sent it to the ESI corporation. That they are with the ESI corporation. That they have to send to the bank so that I can get the money. Some charge. Nice sir.
Draft दे दीजिए दूसरे lecture.
Again, हाँ. Your lordship में कहेंगे it is directed the OP number 2 to return the D to the number 10. DD is ESI corporation. They could not cash it. So they are to.
ଆପଣ bank of people serve करेंगे?
DH copy.
Copy दीजिए ना कौन?
I'll be present if my lords may call the letter next my lord. Needed convenient to your lords. That will be better.
नहीं बैंक रो वकील को एटलीस्ट कॉपी टा दियो
सेदा आज नहीं दबो
नहीं देइछन्ती बोली कहउछन्ती मिस्टर महांती
ताले मु that part I don't know. He might have served my lords. I do not know my lords. Anyway, I'll serve a copy.
Copy of the it is back में appearance के अच्छी देखिले अपन मिस्टर बारिक ये देखो तो ब्रीफ देखो तो
bank objection is lordship direct. Bank has no role to play. Bank is give the pay to my account minus draft charges. That's all.
Set up the bank ro that is bank.
आगे अब तार कोई बात नहीं. এটা ESI नहीं है ESI खाली certificate ballot neither signing purpose the surplus. It will help me in my business all that 3,53,000. So it will be returned. Bank has no nothing.
मनोज कुमार राउतराय पर सर कुछ मनोज राउतराय दो the name of Mr. Manoj Kumar Rautray
I am not sir
appears on again
I am not sir
the name of Mr. Manoj Kumar Rautray is mentioned in the cause list appearing for the bank. No one appears for the OP number 3 bank. Mr. Mahanti, Lord and Counsel for the petitioners, shall serve an extra copy of the IA of Mr. Manoj Kumar Rautray for the bank along with the copy of the today's order. Stop. In the interim, it is directed that the demand draft stated to have, as stated in paragraph 5 of the paragraph 4 and 5 of the application, shall not be further utilized, public dealt with without leave of this court. Demand draft prepared by OP number 3 bank rupees 3,53,618 shall not be shall not be dealt with in any manner. Till the next date of hearing, is the next date of hearing. After vacation or before vacation?
If your lordship takes before vacation, be bless my lord, sir.
Matters shall be listed for orders in the week commencing. ଆପଣଙ୍କର ଆର ମ୍ୟାଟରଟା କେବେକୁ ରହିଲା? ଆପଣଙ୍କର ଆଉ କିଛି ମ୍ୟାଟର ନାହିଁ? ନେକ୍ସଟ ୱିକ୍ କଣ କୋଉ ଦିନ ହେଲେ ଆସିବ?
ସାର୍ 20
20 ଆସୁ। listed on 20 after vacation ଗଲେ କଣ ହବ?
10 days ଲାଗେ ତମ ଘରେ କିଏ ଚାଲି ଯାଇଛନ୍ତି ତ 10 days at least 10 days ବି give
ଅନ୍ୟ ଓକିଲଙ୍କୁ ଆଣିବେ ନା ଆଉ କିଏ କି ପ୍ରକାର ସମିଛନ୍ତି ସିପିସି ହେରିକା ପଢନ୍ତୁ ଆପଣଙ୍କର କେସ୍ କଲେ ଅନ୍ୟଠି ଗଲେ ସେଠି that cannot be a ground for adjournment also. Can you record that ଯେ ଆପଣଙ୍କର interim prayer ହବ ମୁଁ କହିବି ତାଙ୍କ ଘରେ ଚାଲିଗଲେଣି ଆପଣ ଘରକୁ ଯାଇ ଆଟେଣ୍ଡ କରନ୍ତୁ ତାପରେ ଏଥିରେ ଆପଣଙ୍କର କିଛି ଷ୍ଟେକ୍ ନାହିଁ ବି ଆପଣ ଯଦି ନେବେ ଫାଇନାଲି ରିଟ୍ ଆଲାଉ ହବ ଆପଣ କଣ ବର୍ତ୍ତମାନ ଡିଡିଟା ଯୋଉଟା ଆପଣ ହାଇକୋର୍ଟ ଇଣ୍ଟରିମ୍ ଅର୍ଡର କଲେ କୋର୍ଡିନେଟ୍ ବେଞ୍ଚ ଇଣ୍ଟରିମ୍ ଅର୍ଡର କଲା ପରେ ଆପଣ ଡିଡି ଇସ୍ୟୁ କରାହେଇଛି that is the point he is raising.
A DD has expired.
ଆପଣଙ୍କର ସୁବିଧା ହେଉଛି ଯେ ଆପଣ ପଇସା ପାଇନାହାନ୍ତି ବ୍ୟାଙ୍କର ସୁବିଧା ହେଉଛି ଯେ ଅବଶ୍ୟ ବ୍ୟାଙ୍କ ବୋଧେ ସୁଧ ପାଇବନି କିନ୍ତୁ ବ୍ୟାଙ୍କ ପଇସାଟା ନେଇକି ଡିଡି କରିଦେଲା yes next
item 20 limitation first IA is minors the court fees during pendency the court fees already filed by it
file କଲେଣି
already filed
already filed okay.
Yes the court fees in the meantime the same has been filed
Uriya Mr. Ajay Kumar Rai, Senior Panel Counsel for the appellate. Mr. Prabhu Prasanna Behra, Additional Standing Counsel for the Proforma R7. 6 members. କଟାକଟି ହେଇକି ସେଟା ଫାଇନାଲି ଗୋଟେ କୁହନ୍ତୁ
7
ଆପଣ ଏପଟେ ଦେଖୁନାହାନ୍ତି କଟା ହେଇକି 5 ନରୋତ୍ତମ 5 ହେଇଗଲେ କିରଣବାଳା 6 ଆପଣ 7 ହେଇଗଲେ ସେ ଯୋଉ ଧଳା କାଗଜରେ ଜାଗା ଅଛି ବୋଲି ସେ ଉପରେ କାଟି ଦେଇଛନ୍ତି actually that is ingenuity of us ଯୋଉଠି ଜାଗା ଅଛି ସେଠି ଗୋଟେ ଇନସର୍ଟ କରିଦେଲେ I'll note 7 the IA लिखिबे IA 148 of 2026 आगे लिखंतु IA 48 of 2026 the with LAA 65 the appeal has been filed by the appellant East Coast Railway आपण एक्चुअली सबले appellant की respondent रे एम्प्लॉय मानक पार्टी करिवे नाही प्रिंसिपल को पार्टी करिवे एम्प्लॉयर को रिप्रेजेंटेड थ्रू हमको करिवे स्टेट ऑफ ओडिशा
represent through
simply East Coast Railway represented through
minors
that creates lot of basic raises fundamental issues actually
yes
the East Coast Railway with the appellant is the appellant before this court through the deputy chief engineer into bracket construction -1 comma East Coast Railway Bhubaneswar challenging the
judgment dated
so and so passed by judgment dated 21/8/2024 passed by the presiding officer LAR A into bracket Northern Division bracket close comma Sambalpur in LA case number 339 of 20222. The appeal has been filed under the provision under section 74 of the RFC LAR and R Act, 2013. Stop. The LA case before the Lara coaching actually, but not exactly Lara. The LA case before the LARRA authority was pursuant to a reference on the section 64 of the Act 2013 made by the Special Land Acquisition Officer Salegaon - Budhapong - Talche - Joropada. Third and fourth line project Dhenkanal. In view of the objection raised by the respondent land house regarding the quantum of compensation. Stop. The IA number 65 has IA number 145-48 has been filed for extension of time to deposit the court fees. Court fees pura na deficit hai?
Deficit court fees.
For deficit court fees. Stop. In the meanwhile,
February 10th April 2026.
in the meanwhile, during in the after filing of the appeal on 10/4/2026, the deficit court fee of rupees 40,335 has been paid as noted by the staff reporter in the staff report dated 20/4/2026. The staff report date nahi. Date पकंदुनी. Date तो किसी लिखा ही नहीं थे. तले से डाकोर staff report date. दीनबंधु रथ. ठीक है. अपन तब जान चल. कौन काली कोले रिटायर्ड करियोले बोली तारणी नहीं. नहीं सर. ये अछंतु. The stamp report 20/4/2026. Stop. In view of deposit of the court fee, IA number 148 of 2026 has been rendered infructuous and is disposed of. IA number 149 of 2026 lekhuntu. Along with LAA paucity. Kete din delay, Mr. Ray?
292 days.
Amro hisab kurchen 414, Dinabandhu Rathang hisab 414. That will prevail. The IA has been filed seeking condonation of delay of 414 days in filing the appeal. Under Section 5 of the Limitation Act. I had Senior Panel Counsel for the appellant. Issue notice. Requisites for issuance of notice to the opposite parties 1, 2, 2, 6. Had noted counsel for this. Appellant as petitioner. Here is a petitioner. Issue notice to the respondents as opposite parties 1, 2, 2, 6 by speed post with registration and proof of delivery. The requisites for issuance of notice be filed within 7 working days. Within 7 working days. Returnable date we fix to. केबे आनिबे आपण?
एटा 13/7 connected file माने fix ହେଇଛି.
Fix ହେଇଛି. Interval date be fixed to A के साथ है 2026 list in the week commencing 13/7/2026. Copy of the appeal memo and IA served. Copy of the appeal memo and IA has been served on the learned additional standing counsel. No further notice be issued in the IA to the OP number pro forma respondent OP 7. Respondent dash OP 7. Yes.
Item 21.
Mr. Prabin Das.
But we see the IA number 173 of 26.
Yes.
At flag A.
Yes.
That I have, my lord, filed because I have already made the requisitioning authority as respondent number 2. But there was an objection from the SR that if he was not the party before the court below, so you have to file an IA. My lord,
Technical correct.
Technically correct, my lord. That is why I have already, and lordship may see the prayer, I have only submitted as reflected in the
IA 173 of 2026. Hard Learned Counsel for the petitioner, appellant, or appellant petitioner. The IA has been filed seeking impletion under section 74 of the IA has been filed seeking impletion of the project proponent, public requisitioning authority, as
respondent number 2.
As a necessary party in the appeal as well as the connected IS stuff.
My lord.
The learned counsel for the appellant refers to the staff report dated which at para 6 indicates that title not order R2 respondent 2 was not a party in the trial court. Stop. The stamp report may be correct in the context that in the LA case number 4 of 2019, decided by judgment dated 30/3/2026 by the presiding officer, LAR and RA, Northern Division, Sambalpur, the project proponent, who is sought to be made, who has been implemented in the present appeal as R2, and which has been pointed as a defect by the SR, was not a party, but in view of the judgment of the Honorable Apex Court in EP Awas and Apex Court Constitution Bench of Apex Court. Situ Tinidaj. Awas এবং বিকাশ
as reflected in para 3. In para 3.
Para 3 লিখি
Para 4 of
পেশ করে দেবে
Para 4 of
Para 4
para 4
Para 4 of the IA.
Say the project proponent is a necessary party in any adjudication seeking enhancement of compensation. Stop.
As also apportionment, my lord. This is a
And
case
also,
of
and also apportionment. And also apportionment of compensation awarded. Stop. Accordingly, it is directed that impletion of R2 in the present appeal is held to be regular. The objection in the stamp report regarding R2 not being a party before the Lorette so and so Lara before the Lara Northern Division has to be ignored. Stop. The matter shall be like on defective age and numbering age.
my lord, number has been
Number age.
already.
The matter shall be listed for fresh admission
My lord,
delay ଅଛି କି?
no, my lord, no delay is there. That is my predicament is, my lord, I have filed one stay application also because this is a case of apportionment. So if there will be a disbursement, my appeal will be infructuous.
Though the matter is listed, तापर लिखो तो LAA 682026. जो IA टा तापर कंप्लीट हेड नहीं गिरे. The IA is favored and disposed of. तापर LAA लिखो. LAA 68 of 2026. Though the matter is listed, the appeal is listed along with the IA for orders. The learned counsel for the appellant, let's say, submits that the matter may be taken up for fresh admission stuff. Accordingly, the matter is heard for fresh admission. ଆପଣ ନଥିଲେ ଆପଣ ପାର୍ଟି ଥିଲେ.
My lord, I
The
have,
appellant before this court was petitioner number 4 before the LAR and RA into bracket ND Sambalpur in LA case number 04 of 2019. ଆପଣ ଖାଲି quantum ନା ନାହିଁ apportionment ନା both challenge କରୁଛନ୍ତି.
my lord, apportionment in the award as also enhancement for the tree. So apportionment, basically the court has dealt with the matter only under section 76 for apportionment.
Quantum को अन्य मैंने challenge करना है.
No, my lord, no.
ଆପଣ challenge କରୁଛନ୍ତି.
Award has been settled already.
You also agree.
I also agree. Only to the apportionment.
The petitioner case number 8, he challenges the apportionment of the amount of award pursuant to the acquisition of land for power plant by NTPC Gajamara Limited, Thenkana, for which gazette notification under section 4(1) of the Land Act LA Act was published by Government of Orissa by notification dated 27/6/2012. The LAO land acquisition officer made an award of rupees 7,73,343. Detail टा देखिए लिखे पड़ेगा भूलवा लीजिए. এটা ଅଛି para 2 ର last line. खाता नंबर एते प्लॉट नंबर एते पूरा लिखिबे. The said award was the said award into bracket small s was challenged before in the LA case number 4 of 2019. And the LA Lara authority has no after adjudication has passed the following order. The reference is allowed on contest against so and so. Okay? Had learned counsel for the appellant to notice to the so and so respondents by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 5 working days. Returnable date be fixed to 1/7/2026. The matter shall be listed for orders in the week commencing 13/7. Date केबे पहुंचे थे आपने?
13/7.
Orders in the week commencing 13/7/2026. आइए टा कितने?
Method 165.
आइए 165 of 2026. और जोटा स्टे डिस्बर्समेंट स्टे चाहूँगी.
My lord,
पूरा टा केमती हम?
my lord, nobody else has contested the case only. I am the only one who contested the case.
And
my lord, I have no objection against respondent number 5 because that money I am not challenging. Only against 1A to 3. That money because they were the strangers.
Clearly
my lord, that has been clearly. My lord, lordship may kindly see
the amount of
paragraph 8.3.
Have done a counsel for the petitioner. Issue notice as above. Accept one set of process fee as well as total requisites. The returnable date and next date of listing shall be as directed above. In the interim, it is directed that সেটা দেখাতো কোট লেকচারটা
My lord, paragraph 8.3 at page 20
of the appeal memo
of the judgment, my lord.
judgment. Okay.
And in the ordering portion also, my lord. At page 22, it is reflected.
So দেখাতো
My lord, ordering portion, my lord, the reference is allowed on contest against opposite party but without any cost. Further, the OP is directed to disburse the compensation amount awarded against the acquired land in favor of the petitioner number 1A, 2 and 3 to the extent of their share for area 62 decimal.
ଆପଣଙ୍କ କହିବା ଅନୁସାରେ
My lord.
1A23 କିଛି ପାଇବେନି?
No, my lord. I have no case against respondent number 5.
quantified ହେଲାନି ଏଥିରେ?
My lord, that has been quantified, my lord. 62 decimal.
Then interim measure, it is directed that the award compensation awarded for the acquired land in favor of the present semane 1A 1 କେତେ ହେଲା?
No, my lord. Respondent number 3 to 5.
The present respondents number 3, 4 and 5 who were petitioners number 1A, 2 and 3 before the LARA. That is an amount of rupees.
My lord, the amount has not been determined.
Okay. Amount, that is an amount of rupees কাটি দেবে. Shall not be disbursed. Without leave of this court. The returnable, the liberty to match. On the returnable data, liberty to match.
Well,
yes.
Obliged.
Item 23 may please you.
Yes.
The husband is the revision petitioner before your petition against the order passed by the Learned Judge Family Court Jashpur.
Yes.
What happened in the meantime? Judgment is under Annexure 3. Criminal proceeding number 167 of 2009.
Yes.
What happened in the meantime? Filed order dated 28 March 2024.
You take your seat, listen to him.
Though this honorable court has passed an order in IA number 65 of 2024, Para 3, as an interim measure, it is directed that if the petitioner goes on paying 10,000 to the opposite party as maintenance, no coercive action should be taken. What happened? Though I am paying 10,000 rupees till May 26, but the Learned Judge Family Court has issued warrant against me, in spite of this order.
ସେ ତାଙ୍କର ଅର୍ଡରଟା ଏଥିରେ ଇନକ୍ଲୁଜ ହେଇଛି କପି ଅଫ ଦ ଅର୍ଡର ଅଫ ଦ ଲର୍ଡ ଜଜ୍ ଫ୍ୟାମିଲି କୋର୍ଟ ଅଛି ଏଥିରେ
ନା ମୋ ପାଖରେ ସେ ପଠେଇଛି ପୋଲିସ ଷ୍ଟେସନ ୱାରେଣ୍ଟଟା ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ପ୍ରୋସିଡିଂ ନମ୍ବର 26/2024
ଆପଣ ଏଥିରେ ୱାରେଣ୍ଟଟା ଇଏ କରିଛନ୍ତି
ସେଟା ନଥିଲା ସେତେବେଳେ ୱାରେଣ୍ଟଟା ଏବେ ଇସ୍ୟୁ ହେଇଛି ଏଇ ରିସେଣ୍ଟଲି ମତେ କ୍ଲାଏଣ୍ଟ କହିଲା 26/2024 ମୋ ପାଖରେ ପେମେଣ୍ଟ ଲିଷ୍ଟ ବି ସେ ପଠଉଛି ଆଗରୁ ବି ପଠେଇଥିଲା ରେଗୁଲାରଲି ହି ଇଜ ପେଇଂ and the order is not to take any coercive action.
ଏଇଟା ଆପଣ ନୂଆ ଆଇରେ ଫାଇଲ କରିଛନ୍ତି ନା
ସେତେବେଳେ ହେଇଥିଲା ସେତିକିବେଳେ ଅର୍ଡର ହେଇଥିଲା
ନାଇଁ ନାଇଁ ଏବେ ଯୋଉଟା ଯୋଉ ବ୍ରିଙ୍ଗିଂ ଅନ୍ ଦିସ୍ ରେକର୍ଡ ଫାଇଲ ୱିଥ୍ ଏ ମେମୋ ଆଟ୍ ଲିଷ୍ଟ ବଟ୍ ହାଉ ଦିସ୍ ୱିଲ୍ କମ୍ ଅନ୍ ରେକର୍ଡ ଦିସ୍ ସବସିକ୍ୱେଣ୍ଟ ଡେଭଲପମେଣ୍ଟ ହାଜ୍ ଟୁ ବି ଅନ୍ ରେକର୍ଡ
ମୁଁ ଗୋଟେ ମେମୋ ଦେଇଦେଇଛି ଭାଇ ଏଜୁକେସନ ପ୍ରୋସିଡିଂ ନମ୍ବର କୋର୍ଟ ଅର୍ଡର ଥାଇକି ବି ଯଦି ଏହା କରିବେ
and you have paper ଆପଣ ଏଟାକୁ ପଠେଇଛନ୍ତି ମାନେ ତାକୁ ଆପଣ କ୍ଲାଏଣ୍ଟ ଏଟା ଦେଖେଇଛନ୍ତି
ଆଜ୍ଞା
ଆପଣଙ୍କ ଏଇ ଯୋଉ ଅର୍ଡରର ସାର୍ଟିଫାଇଡ୍ କପିଟା ନେଇକି ସେଠି ପ୍ରେଜେଣ୍ଟ କରାହେଇଛି
ୱେବସାଇଟ୍ କପିଟା ଥିଲା
ୱେବସାଇଟ୍ କପି yes Mr. what you say sir ଏଥିରେ ଆପଣ ବି କଣ କହିବେ ଆପଣ ତ କିଛି କରି ହିଁ ନାହାନ୍ତି ଯଦି ପାଉନାହାନ୍ତି ବୋଲି କହିବେ ହଁ ତାହେଲେ ଗୋଟେ କଥା ଆପଣ ପାଉଛନ୍ତି
15,000, but 10,000 was awarded to the mother and 5,000 to the daughter. But the OP number 1 is receiving only 10,000.
সেটা তো ঠিক আছে স্যার, সেটা আপনার সামনে দেখে দিলে অর্ডার আপনার অর্ডর কপি হচ্ছে হাইকোর্ট অর্ডারটা।
হাইকোর্ট অর্ডর হচ্ছে 10,000 পেয়েছি।
ଆଜ୍ଞା 15,000 ବଢାଟା ବିଚାର୍ଯ୍ୟ ବର୍ତ୍ତମାନ। 15,000 ଯେପର୍ଯ୍ୟନ୍ତ ହେଇନି 10,000 ଦେବା ପାଇଁ ହାଇକୋର୍ଟ କହିଲେ, ସେ ମାନିକି ଦେଲେ। ଆଜି କଣ ଏଇଭଳିଆ ସବୁ କେସ୍ ଆଉ ଜଣେ ତାଙ୍କର ₹1,00,000 ନେଲା ପରେ କହୁଛନ୍ତି ଯେ ସେଟା ଭେକେଟ୍ କରିଦେବି।
ସିଏ ଇନସିଷ୍ଟ କରୁଛନ୍ତି ୱାରେଣ୍ଟ ପଠେଇବା ପାଇଁ। ଆଜି ପଠେଇଛନ୍ତି, ମୁଁ ତ ତାଙ୍କ ବିଷୟରେ ଆଗରୁ କହିଥିଲି।
ଇନସିଷ୍ଟ କଲେ ମୁଁ କହିଲା ଆପଣ ଯଦି ଇନସିଷ୍ଟ କରିବେ ମୁଁ ପଠେଇଦେବି, ଏଟା ଗୋଟେ
ଇଏ ପଠେଇଲେ ମୁଁ ଆଗରୁ କହିଛି ଆଜ୍ଞା।
ନାଇଁ ସେଇଟା ମୁଁ
I have complained before your lordship. ସେ କଣ କରୁଥିଲେ ସେଠି, now he is not there. ଯାଜପୁରରେ ଯାହା ହଉଥିଲା ତାଙ୍କ ଟାଇମରେ ଆପଣ ବିଶ୍ୱାସ ବି କରିପାରିବେ। ମୁଁ ଆପଣ ଡିଭିଜନ ବେଞ୍ଚରେ ବସିଥିଲେ, ମୁଁ କମ୍ପ୍ଲେନ ବି
ନାଇଁ ଆପଣ ଯେତେବେଳେ ଆରମ୍ଭ କଲେ ମୁଁ ବୁଝିଗଲି।
ଆଜ୍ଞା
ଆପଣ ଆଜ୍ଞା ଗୋଟେ ହାଇକୋର୍ଟ ଅର୍ଡରଟାରେ ଯଦି 10,000 ଟଙ୍କା ତ ଦିଆହେଲା, ଇଟ୍ସ ଇକ୍ୱିଟେବଲ ଅର୍ଡର ଆଜ୍ଞା। 5,000 ଆପଣ ବଢା ହବ କି ନାହିଁ ସେଟା ବିଚାର୍ଯ୍ୟ ବୋଲି ହାଇକୋର୍ଟ କହିଲେ, ପେଣ୍ଡିଂ ଅଛି। ସେ ଯଦି ଦେବେନି ତାହେଲେ then you have a case. ମାନେ you can say that okay, like I was telling that why you are not for 7,500 ସେ ଦଉନାହାନ୍ତି। I don't know whether you are present.
I have no knowledge.
Letter he says that 7,500 is not being paid. Then court can issue a
ପ୍ରତ୍ୟେକ ମାସରେ ଦଉଛି।
I have no
Even document
regarding issuance of
right.
10,000 ଏବେ ମାନୁଥିଲେ।
ମିଷ୍ଟର ଆପଣ ଯୋଉଟାକ ଯୋଉଟା ମେମୋରେ ପେମେଣ୍ଟ ଯୋଉଟାକ ଡିଟେଲ୍ସଟା ବି ଲେଖିକି ଦେଇଦିଅ, ମୁଁ ଦଉଛୁ।
ବହୁତ ଗୁଡା ହେଇଯିବ, ଖାତା ହେଇଯିବ ପୁରା।
ନା ସେଇ ଦିନଠୁ
24 ଦିବସରେ ହେଲେ ଗୋଟେ ଖାତା ହେଇଯିବ, ପ୍ରତି ମାସରେ ହେଲା ବେଳକୁ।
ଠିକ ଅଛି, ପରେ ଫାଇଲ କରିଦେବେ।
ମୁଁ ଅଡିଟିଂ ଦଉଛି ଯେ ସେ ଫାଇଲ କରୁଛି।
ଆପଣ ଲେଖିଦେବେ, ଲେଖିଦେବେ ମିଷ୍ଟର S. Chakraborty for the petitioner. You are Mr. P.C. Das.
PC Das.
Mr. P.C. Das for the opposite party. Lord, counsel for the petitioner refers to the order dated 28/3/2024 passed by the coordinate bench in the revision application as well as the IA number 65 of 2024. He refers to paragraph 3 of the order passed in IA number 65 of 2024, which is reproduced here. Introduction here. It is submitted that in compliance of the said interim order, the petitioner goes on paying ₹10,000 from the date of passing of the order, that is 28/3/2024 till May 2026. But for no plausible reason, distress warrant has been issued.
DW and NBW
both available as well as NBW has been issued, which is sought to be executed against the petitioner for non-payment of the amount directed. The Lord Counsel for the petitioner expresses grave concern that even interim order of this court passed in a pending proceeding is not honored. Stop. Definitely the expression of concern is correct. Expression of concern by the Lord Counsel for the petitioner is correct. And this court takes note of the unusual situation. Stop. A report be called for from the learned judge family, learned district judge, Jajpur.
Judge family court.
Is it Jajpur? Is it
Judge family court? nije ତାଙ୍କର ସବୁ କିଛି।
Actually, she is independent. She head of the office.
ତାଙ୍କର ସେଇ report
the report be called for from the learned judge family court, Jajpur, in the circumstances in which such order directing issuance of BW and NBW against the petitioner
in criminal proceeding number 26/24
in
execution
in execution criminal proceeding number
26 of
2024 was passed. So, in view of the interim order passed by the coordinate bench is reiterated. Coordinate bench dated 2324 passed in IA number 65 of 2044 is reiterated. Though it is not necessary to do so, inasmuch as once an order is passed, once a judicial order is passed, the same shall continue without being modified. Stop. The learned counsel for the opposite party barely submits that he is not aware of any coercive action having been taken against the petitioner. And as per his instruction, the petitioner has complied with the order of paying 10,000 rupees per month to the opposite party. Stop. The report,
warrant of recall.
the court shall, the learned judge, family court shall take all steps to amend the situation, to amend the unsavory situation that has happened. Copy of this order shall be forwarded to the learned judge, family court by the registry by तो by 15 कर दियो क्यों क्या कौन के आगे दे देते by 15 5 2026 the further report from the learned judge family court shall be received by this court by 21 5 2026 तो लिखले submitted लिखले किताब पर लिखले the memo of date is filed by the learned counsel for the petitioner indicating that the petitioner goes on paying the amount directed by the order dated and the fact of issuance of VW and NBW. The memo shall be taken on record. The memo states thus. Memo shall be taken on record, scanned copy be updated.
What has that?
से कर देवे
ये अमेंड कला भी पुलिस बंद हो
नहीं से करिबेनी आज पढेबो जेसु आज
जति कि आदमी लोक हैरान कले मो पर्सनल नॉलेज रे सोचु
एते दिन तो गलानी काली जाय तानु चांस दियो
पुलिस बंद हो ना जाजपुर गलानी पुलिस अलग थाना
आपण ताकू पुलिस के कॉपी रो ऑर्डर ता दे दे परियो एटा एबे आगो करते
हां तो पुलिस दे
हां तो पठि दियो
हां पठि वेबसाइट कॉपी टा को यूटिलाइज कर
हां यस यस द पार्टी shall have the liberty to act upon the website copy of this order.
ये लाइट था पुलिस की मुद्दे पुलिस
हां the learned counsel as well as the petitioner shall have the parties to act upon the लिखि देलियो
ना पुलिस कहबो हम तो कोइ ना हाई कोर्ट को कोइ हम केनु
नहीं सेटा से करंतु तापरे तक्षक योग्य रे से माने पडिबे
बांधी देइ तो जदि लोकटा मो ऊपर वर्षा
नहीं सत कथा
बांधी देले मो वर्षा
योर कंसर्न इज राइट
ना से बांधी देबे मो वर्षा मो गुड लोक को वर्षा तुर जाओ से जाजपुर लोक को तेनु पुलिस की दवा पे गोटे कॉपी कर पड़ता
the learned counsel shall have the liberty to produce as well as the learned counsel as well as the petitioner. The petitioner as well as his learned counsel shall have the liberty to produce the copy of this order obtained from the official website of this court as and when necessary before the authority.
डेट ता फिक्स
এটা 21 রে রাখি দিছি
21 রে তো রিপোর্ট আছে डेट ता
আপন the matter shall be আপন রিপোর্ট করন্ত 20 और matter shall be listed on 21 5 20
21 রাসो
listed for orders or liberty to mention. Yes.
24 matter taken up to vacation matter.
In fact, whatever time is left, I think opening up a brief and completing hearing would not be a very easy situation. No, if there is no urgency, let us not open any further briefs for hearing. 25 time. 24 ta update कर दियो. आपन बता मिस्टर युवन मिस्टर
अबनिरंजन दास मेलट on behalf of SK Bhanjadeo.
So Amarendra Das.
Abaniranjan Das.
So Mr. Abaniranjan Das on behalf of SK Bhanjadeo for the petitioner, opposite party, black. The learned counsel for the petitioner seeks adjournment to address arguments. the matter is listed for admission for hearing in the under the heading admission for admission. From they can type it out of
My lord, may kindly turn to page 8 for a moment of the brief.
Medicine fail ही गला.
हाँ, सर टिक्के पेज 8 तक खाली सर टिके देखो.
Yes.
The section 13 application for divorce was filed by the husband. The address, your lordship may see. Jitendra Kumar Sahu such and such, at present residing Vedanta Township, quarter number such and such, Jharsuguda. The wife at present residing in such and such, teacher in Jharsuguda, working at Jharsuguda. She is from Sambalpur, working at Jharsuguda. The case was filed in Family Court, Jajpur. I filed an application. I am filing this application for seeking transfer from Jajpur to Jharsuguda because both husband and wife being residing in Jharsuguda as per the own admission of the husband. My lord, there is no harm in transferring to Jharsuguda because both are residing in Jharsuguda.
So, Parija Jharsuguda jam.
No, that is difficulty. Either it will come to Hon'Ble or Dhagara. Because Jharsuguda several Bunda no Bunda.
कहीं गोटे एफआईआर सर फाइल कर छथि
एफआईआर कोन
माने एफआईआर कोन माने
नहीं सब बात जो
कोन माने
दैट मस्ट बी मिडिल प्लेस और से कहू झारसुगुड़ा का गुंडा न कहू मु केमति कोन करी
ये गोटे जदी एफआईआर सर देखै देबे
एफआईआर कोन
जोटा कोन
ना नो एफआईआर को सब थे दिया होय
और एफआईआर दिया हुए खाली मुंह मिछ गुड़ा कह दिया हुए दिस वर्किंग देयर इन झारसुगुड़ा जहाँ सर हमें पाइबो हमें ता कोर्ट
जहाँ नहीं हमें
जहाँ पाइबो
हमें सेटिंग ही पाइबो बेल
आगे बस्सी सब सुनिया तो कोर्ट तो बस्सी सब सुनिया तो
माने you did not join the party yesterday posted by Mr. Parija.
No I am Manad, I have highest regard for him,
so the party
but
did
in
not
case we cannot have that.
Mr. Chakravarti left the court that we are having party now, so I am going to leave. Because yesterday was special bench, so.
My lord, I am showing his own admission. I am not showing anything. It is their document.
अगर झारसुगुड़ा से गुंडा न कहे मते अपन जो भी करंतु एक्सेप्ट झारसुगुड़ा म आउ जोटी करन
सर गोटे
सर सुनंतु मिस्टर परिजा I cannot countenance that आपण जदी प्रकृतरे कोर्ट नोटिस को आइछन जे मते गुंडा डरोचंती because I can't be the थानेदार करचंती स्टेशन
ऑब्जेक्शन लिखिची
सेटा सेठी कहिबा को कंटेम्पोरेनियस डॉक्यूमेंट दबार थिला जो दिन आपण को गुंडा लगेई देले करा ए प्रकार भूल एडवाइस के देबेनी एटलीस्ट आपण तो देबेनी कि से भी देबे
ना मु
बोथ ऑफ यू अब जदी भी कहिबे आगे मोर इच्छा होची गुंडा लगे दे आपण को जमा सेटा करंती न हरान नै पड़िबे आपण मना करिवे से भी मना करिवे आपण जदी कहउचंती जे से गुंडा लगेले यू शुड हैव टेकन रिकोर्स ऑफ लॉ by stating something happened which is
how difficult
अनुकूल पे राजी जो ना
दी जण सर she is a teacher और सर family court रे both parties presence is mandatory. The lawyer is an amicus curiae there.
Correct.
Lawyer is not the counsel there. He is an amicus curiae appointed by the party.
नहीं सर तो जाजपुर राज को मना करना है ना मना कर देबे
सर तांकर एड्रेस टा टिके देखुन
आया
अनुकूल आउट गोटा
अनुकूल डाउन देखा ना हुआ
सर
हां जो आई एग्री
सर झारसुगुड़ा अनुकूल आसीबे आपण जे जाजपुर को जाउचंते अनुकूल ठीक
हां आ जाए
सर मु जाजपुर नहीं
अरे केस जाजपुर रे अछि आगे
हां सर आपण ताकर एड्रेस टा देखंतु सी जदी न लिखो
अनुकूल पे राजी जाय
सर
आपनकर वेमेंट ऑब्जेक्शन ताकर थ्रेट टू लाइफ है कि आपण अनुकूल राजी जाय
सर अनुकूल केमिते हबो सर
अनुकूल इज वेरी डेंजरस आल्सो
अनुकूल इज मोर सीरियस देन
नहीं जाजपुर जदी झारसुगुड़ा डेंजरस अनुकूल इज आल्सो डेंजरस तो आपण डेंजरस थ्योरी को विथड्रॉ कर दियंतु राजी जायंतु अनुकूल पे कोर्ट कहले अनुकूल
हां अनुकूल हां
आपण इंस्ट्रक्शन नेबे अनुकूल
आ गया
सर एटा सर संबलपुर कर दियो
नहीं संबलपुर दूर है
सर मोर घर सर
झारसुगुड़ा संबलपुर इन वन प्लेस
सर 50 किलोमीटर डिफरेंस
ଆପଣ ଅନୁଗୁଳ ଭଲ ଅନୁଗୁଳ ହେଲେ କଣ କି ମିଷ୍ଟର ବୋସ ଯାଇପାରିବେ ମିଷ୍ଟର ପରିଜା ଯାଇପାରିବେ
Kindly see, sir.
both of them can go
Sir, kindly.
ସମ୍ବଲପୁର ହେଲେ ଯିବାକୁ ଅସୁବିଧା ହବ
ନା ସାର୍ ଆମେ କେହି ଯିବୁନି ମୁଁ ଜାଣିଛି ପରିଜା ସାର୍ ଯିବେନି ସାର୍ ଟିକେ ଦେଖନ୍ତୁ ସାର୍ ପେଜ 8 ଟା ଟିକେ ଦେଖନ୍ତୁ ହି ଇଜ ୱାର୍କିଂ ହି ଇଜ ରିଜାଇଡିଂ ଇନ ଝାରସୁଗୁଡା ମାଇ ପ୍ୟାରେଣ୍ଟାଲ ହୋମ ଇଜ ଇନ ସମ୍ବଲପୁର
I have already expressed that depending on the choice I cannot direct but ଆପଣ ଯେହେତୁ ରାଜି ହଉଛନ୍ତି in that way I will not record your both of your submission but I will say that let it be at ଅନୁଗୁଳ
ଆଜ୍ଞା let you hope sir ସୁନ୍ଦରଗଡ଼
at least ସୁନ୍ଦରଗଡ଼ ବହୁତ ସୁନ୍ଦରଗଡ଼ Sahoo is advising you wrongly
ମଧ୍ୟପ୍ରଦେଶରେ ଯୋଉ
Mr. DJ Sahoo
ସେମିତି କଣ ଆପଣ କଣ କହୁଛନ୍ତି ସେଇଟା କହନ୍ତୁ ଯେ
କାହିଁ ଛୋଟ କରୁଥିଲେ
statement sir high court high court we are not in trial court
ଏ ଯୋଉ
ଯାହା ପାଇବେ ତାହା କହିବେ
matrimonial jurisprudence has become really very funny and unusual ସମସ୍ତେ ଏପର୍ଯ୍ୟନ୍ତ ସମସ୍ତେ କହୁଛନ୍ତି ଲାଇଫ ଥ୍ରେଟ୍ ସ୍ପେଶିଆଲି ହଜବେଣ୍ଡଙ୍କର ବେଶୀ ଲାଇଫ ଥ୍ରେଟ୍
ସାର୍ ମୁଁ ଗୋଟିଏ ଜିନିଷ କହିବି ଆପଣ ଯୋଉଟା ଠିକ ଭାବେ କରିବେ ସାର୍ ସାର୍ ଟିକେ ପେଜ 8 ଟା ଦେଖିଲେ ତ ସାର୍
ସେଟା ମୁଁ
ସାର୍ ଝାରସୁଗୁଡାରେ ସେ ରିଜାଇଡ୍ କରୁଛନ୍ତି ସାର୍ ଝାରସୁଗୁଡାରେ ମତେ ଯଦି ତାଙ୍କର ଗୁଣ୍ଡା ଲଗେଇବାର ଅଛି ସାର୍ ସାର୍ ମୁଁ ତ ଆଜି ଯାଏ ଯୋଉ ଟ୍ରାନ୍ସଫର ମାଗିବେ ଆଗରୁ ତ ଲଗେଇ ଦେଇଥାନ୍ତି
ନାଇଁ ସେଟା ନୁହଁ ଇନଫ୍ୟାକ୍ଟ ଆଇ ହାଭ୍ ଅବଜର୍ଭ ଦ୍ୟାଟ୍ there is a contemporaneous document କିଛି ନାହିଁ
ସାର୍
even I this court ମୁଁ କଣ କହିବି FIR ଦିଅନ୍ତୁ ବୋଲି I cannot because ଆପଣ SP ପାଖକୁ ଯିବେ କଣ କରିବେ
ସାର୍ ସମ୍ବଲପୁର
ଆପଣ ଇନସିଷ୍ଟ କରନ୍ତୁ ନାହିଁ
ସାର୍ ସମ୍ବଲପୁର କିମ୍ବା ସୁନ୍ଦରଗଡ଼ ଅନୁଗୁଳଟା ସାର୍ ହେଇପାରିବନି ସାର୍ it will be difficult
not difficult ଝାରସୁଗୁଡା ଅନୁଗୁଳ is not at all difficult if you are ready for ସମ୍ବଲପୁର ଆପଣଙ୍କ ଘର କଣ ସମ୍ବଲପୁର
ମୋର ଘର ସମ୍ବଲପୁର
ନା ସାଉଙ୍କ ଘର ନା ତାହେଲେ ସମ୍ବଲପୁରରେ କଣ ମିଳିବ ସାର୍ ସେଠି ଆପଣ ମାନେ ତାହେଲେ କେହି ଯିବେ
ସାର୍ ଡିଷ୍ଟାନ୍ସ ଟା କମ ସାର୍ ଆପଣ ଡିଷ୍ଟାନ୍ସ ଟା ମାପ
ଦେଖିଲେ
50 kilometer and Sundargarh is only 30 kilometers.
30 kilometers
ଆପଣଙ୍କର I have already rejected the nearest theory nearest place to the wife or nearest place to the husband I have not accepted ଆଜି ତ ସେ ଯୋଉ
both are residing in Jharsuguda
that Sarvana case was again cited so I have said ki nahi
sir both are residing in Jharsuguda sir seta bhi to dekhibe sir both are residing in Jharsuguda
ଶୁଣନ୍ତୁ ସେଇଟା ସେ ତାଙ୍କର ଯଦି ସେ ଝାରସୁଗୁଡାରେ ଥାଇକି ସେ ଅନୁଗୁଳରେ କରିବେ they are sacrificing that is different ଆପଣ କହୁଛନ୍ତି ମାନେ ଯାଜପୁରରୁ ଅନୁଗୁଳ କେତେ ହଁ
sir ଝାରସୁଗୁଡାରୁ ଅନୁଗୁଳଟା ହବ ନା
ନାଇଁ present place of prosecution na from Jharsuguda Anugul 208
sir to Sundargarh is only 30 kilometers from Jharsuguda let it go to a neutral place
Sundargarh और ये sir Sundargarh
how Sundargarh
हाँ sir
how let us not
I think will be nearer also
my lord nearer no Sundargarh how
Sundargarh Jharsuguda
how हाँ sir Sundargarh how
ଆପଣଙ୍କ ଲୋକ ଆପଣ ହଉଛନ୍ତି sir ଆପଣ ହଜବେଣ୍ଡ ପାଇଁ ହଜବେଣ୍ଡ କୋଉଠି ରହୁଛନ୍ତି
ଝାରସୁଗୁଡା
ଝାରସୁଗୁଡାରୁ ସୁନ୍ଦରଗଡ଼ ହଉଛି
33 kilometers ମୁଁ ସୁନ୍ଦରଗଡ଼
ଆଜ୍ଞା ସୁନ୍ଦରଗଡ଼ ସେ ଯୋଉ କହୁଛନ୍ତି
Mr. Parijay sir the party still continues yesterday's party yes
and I only pray your lordship may only direct the to expedite the proceeding I'm not asking for a target
that the Supreme Court has threatened me what the High Court
my lord will be threatened by any court I don't think so
अरे सेटा कहलेनी माने मीन हो
it may be the good joke with the ending day
से जो सेक्टर लिखा है जे the high court what the high court should not do justice work actually it has happened
sir I am only praying that your
parties will cooperate that
yes that paragraph
that Mr. Parijay is happy
how yate kahingi ete
yes
amit kharab
Mr. Amit Prasad Bose
your lordship may not record our concession
no never I said that the fiery exchanges as I'll record.
My lord, I respect him like my father. But when we fight for parties, it is part of the game.
Mr. Amit Prasad Bose for the petitioner. Mr. Narayan Prasad Parija for the opposite party. The petitioner wife. The petitioner before this court is the wife in the marriage.
Nanda, Bosantu.
Both of you take your seat. I'll just dictate.
My lord, can I take a leave?
Yes, yes.
Arbitration proceedings.
Yes, yes.
My friend will be there.
Yes.
Great.
So Amit Prasad Bose along with PJ Sahoo and Mrs. D Sahoo for the petitioner. The petitioner for this court is the wife in the marriage. C6 transfer of CP number 302 of 2024 pending before the Learned Judge Family Court, Jaspur, to the Court of Learned Judge Family Court, Jharsuguda. Stuff. To support the contention of to support the prayer for seeking transfer, the Learned Counsel for the petitioner refers to the cause title page of CP number 302 of 2024 pending before the Learned Judge Family Court, Jajpur. Particularly, the address given therein, that is the petitioner husband. CP was filed with the party. The CP was insert karibe. The CP was filed. The CP has been filed by the husband in the marriage under section 13 into bracket 1 dash I dash small a of the Hindu Marriage Act, seeking dissolution of marriage recognized between the parties on 8/3/2021 and grant of decree of divorce. Stop. Refers to the address of the petitioner's address being Vedanta Township, Jharsuguda, and the opposite party's address given as PGT teacher Hanosyama Hemalata Vidya Mandira at Balijodi, Jharsuguda. It is submitted that both the parties staying at Jharsuguda Jharsuguda Jajpur distance एवढा सब हिसाब करे अगर मेंटेनेंस हिसाब होता बर्तमान डिस्टेंस हिसाब करो staying at Jharsuguda, the initiation of the proceeding at Jajpur at dash kilometers away, 378 kilometers, causes immense hardship to the opposite party, to the respondent before the Learned Civil Court, and also causes hardship to the and also would not be convenient to the petitioner husband. Stop. The Learned Counsel for the opposite party, Mr. Parija, opposes the prayer for transfer, stating several difficulties faced and apprehensions felt by the husband, for which he has chosen to file the petition at a distant place at Jajpur. Stop. But having heard the Learned Counsel for the parties, this court is of the considered view that the parties may have their reservations to prosecute the matter at Jajpur or at Jharsuguda, but that can be at a place which can be termed to be neutral. That is Sundargarh, which is about 33 kilometers away from Jharsuguda. So, the learned counsel for the parties are also apprised that instead of getting the matter stalled in the process, they should cooperate in prosecuting the matter at Sundargarh. Stop. Accordingly, it is directed the CP number 302 of 2024 pending before the learned judge family court Jaspur shall be transferred to the learned judge family court Sundargarh. Maybe appear karibe Mr. Parijat again July re. July re appear karibe Sundargarh. The parties are directed to appear before the learned judge family court Sundargarh on 1/7/2026. On the said date, the learned court shall fix the further proceeding. The parties are also directed to cooperate in expeditious disposal of the matter. Stop. तापर ICT paragraph टा देइले. Progress the personal appearance अछि. ICT थिबो तने देबे. Video conferencing sir.
Sundargarh टा appear करिवो.
Sir.
Aye.
Sundargarh Mrs. Sahoo.
Yes, sir.
Sir, it add kariyo sir. To prove their respective points, there were fiery exchanges between the parties, learned counsel. Yes, please.
46. May I please yours.
Best part is that ଆପଣଙ୍କର ପଖାଳ ପାଟିରେ High Court ରୁ ଆମେ ଯିବୁ ସେଠିକି ଯାଇ ତାପରେ ଆମର 3 ଦିନ ଚାଲେ ସେଠି. Yes. Mr. Mishra,
It is a bill.
other side କୁଆଡେ ଗଲେ Mr. Mahanti କାହାନ୍ତି? ତା କିଏ appear କରୁଛନ୍ତି? ସେନାପତି?
May Mahadev. Vishwacharan Mahadev.
ଏଇଟା କଣ ଆପଣ appeal against custody ନା contact?
No, it is a appointment of guardians
Appointment of guardian.
under Mohammedan.
Acha. Mr. Tushar Kumar Mishra for the petitioner. Opposite party now. The matter is listed for hearing under the heading for admission. Stop. Non-appeals for the opposite party. The matter shall be listed for admission in the week commencing. Kebe Mr. Mishra?
Last week,
Last week ଆସିବେ କେତେ? 29/6.
July 1st.
July 1st, okay. The week commencing 6/7/2024. Yes. Mr.
27.
Mr. Rabindra Kumar Pushti for the petitioner. Mr. Sahoo, you are so who? So Mr. Bahal is not there.
No, my lords. Perhaps nobody.
Say substituted service of darkar nahi to appear karigale.
Appear curriculum. For that reason, I want to withdraw that IA flag fee.
Okay. IA 346 of 2025. Rabindra Kumar Pushti, opposite party none. IA 346 of 2025. The IA has been filed for seeking direction for substituted service. In view of appearance of the opposite party, the opposite party through learned counsel, Mr. Biplab P.B. Bahali, the IA is not pressed and is disposed of. Stuff. Memo of date filed by the learned counsel for the petitioner is taken on record. Scan copy be updated.
May I pray, my lord?
Yes.
Initially, the maintenance for the wife was refused by the learned trial court.
Yes.
Only granted so far the daughter is concerned. I have not challenged that order. But the mother challenged that order before the Hon'Ble court. The Hon'Ble court remitted back to for fresh up consideration.
Maintenance 125 rate.
125. My submission is that wife is suffering from a decree
under section 9 of the HM Act. She is not entitled to get any maintenance under section 125(4), which is a bar.
ନାଇଁ ସେଟା ଦେଖନ୍ତୁ ସୋନାଲି ଦେବୀ is that direct Supreme Court decision on this point?
That is correct. I have gone through that decision. Basing upon
Sonali.
Because basing upon that decision, the matter was remitted back with a liberty that the wife will establish.
The world has become so small. Every day, same point. এটা কালি হইতলা আজ আউতরে আপন আর্গুই করেনি. So that is how this is charming. Every day you learn something. Yes.
Now the question is, de novo trial.
Last সেটা প্রসিডিউর সাইড করতে হবে.
De novo trial was commenced, but the wife miserable.
Of course, ଆପଣଙ୍କର de novo trial ରେ ବି ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରି ପାରିବେ. Right. Obviously, I mean, it can't be argued that since it was once remanded, there can't be any appeal further.
So regularly now I am paying so far 7,000 rupees is concerned to my daughter.
Because 125 ରେ ଆପଣଙ୍କର divorce type ର ଅଛି. ଆପଣ ଯୋଉ argument ଟା କରୁଛନ୍ତି ଯେ even if she suffers a decree of section 9 and she doesn't honor that, there is a point. Of course, if somebody is not willing to resume conjugal life, then why should we grant it? But
that is the question.
It has been interpreted that if she is distressed, because the 125(3) philosophy is that 125, the lady should not be driven to destitution and vagrancy.
100% correct. But
No,
the
I
wife
am
miserable
appearing for the opposite party herein. Copy has not been solved, and even if your lordship is posing section 9, if section 9 application, there is Supreme Court judgment. If she has been debarred to join because of the criminal case,
Supreme Court court decision.
Two decisions are there. I will cite in 2025 that even if section 9 is not a bar to get the 125.
সেটা আপন নথিলে তা মানে আপন you are truly not in the biz. So we have discussed that. In fact, your learned friend is also knows, is aware of that. But anyway, ঠিক আছে আসো.
Copy not solved. He has not sought a copy of the RPF.
I shall solve it.
ଆପଣ କହୁଛନ୍ତି ଯେ substituted ଆଗରୁ ଯୋଉ ଆପଣଙ୍କର ଏଠି କପି ନାହିଁ ଅନସର୍ଭ ନୋଟିସ କୁଆଡେ ଗଲା?
ମୁଁ ଦେଇଦେବି ଆଜ୍ଞା, କାଲି ସର୍ଭିସ କରିଦେବି।
ନାଇଁ ନାଇଁ ଅନସର୍ଭ ନୋଟିସ ଏଠି ନଷ୍ଟ କାହିଁ ହବ? ଆପଣ ଯୋଉଟାକ ଫେରିକି ଆସୁଛି ଏଠି ତ ରେଜିଷ୍ଟ୍ରି ରଖା ହଉଛି।
Because that has been returned, that is in the before the registry.
ସେଇଟା the learned counsel for the petitioner shall receive the copy of it is submitted by the learned counsel for the Biplab P.B. Bahari appearance लिखिदेला for opposite party. आइए जो dispose of ହେଇଗଲା आइए तापर लिखिबे the unserved copy returned to the registry shall be served on shall be received by the learned counsel for the opposite party. He is not pressing that आइए copy not served जो कोनांती सेटा से substituted service ପାଇଁ କହିଥିଲେ in view of your appearance that has lost significance.
And in the meantime, there is 2 lakh area of maintenance, and he is not paying.
Let us see.
And doctor is studying in class 10, and she is a brilliant student.
Doctor ର ପଇସା ଦଉଛନ୍ତି ବୋଲି କହୁଛନ୍ତି ଆପଣ ଏଥିରେ stay ନାହିଁ, you can proceed for execution or you can impress upon your learned friend that let him pay the daughter's fees and all these things.
I am paying my lord.
No, doctor ro area ଅଛି, doctor ro area 2 lakh ଅଛି.
He must have been instructed. You obtain instruction.
File one affidavit.
No, I am not recording anything, sir. Neither I am recording your submission or his submission, but you check and prevail that at least the child should not be
100% correct. I am paying. I shall go on pay.
Date केबे करूँ? After vacation for admission, non-appearance से काटी नहीं थी
After vacation.
Date 27. Week commencing matter shall be listed for admission. The week commencing 27. Yes, Miss Mahanti.
28.
My lord, I took instruction from opposite party counsel. He said that let it be transfer the
କୁଆଡେ ଗଲେ କି ରେକର୍ଡ ରେ କି ନାହାନ୍ତି?
ଆଜ୍ଞା
ଯୋଉ ଅପୋଜିଟ ପାର୍ଟି ରେକର୍ଡ ରେ କି କାଉନସିଲ ନାହାନ୍ତି?
ନାଇଁ କଲ୍ କରିଥିଲି, ସେ କହିଲେ ହଁ ଟ୍ରାନ୍ସଫର ହେଇଯାଉ ଆମର।
କାଲି ଆସୁ ତାହେଲେ ତାକୁ ଆଣନ୍ତୁ, ତାକୁ ଯେମିତି ଆମେ ଯେମିତି ଆଲୋଚନା କଲେ ବଢିବ ଆସିଗଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ ସେମିତି ହେଇଯିବ। ଏବେ ବି ଆପଣ ଆଣିପାରିବେ ତାକୁ। ସେ ତ କହିପାରିଲେନି ଡିସିସନଟା କହିଲେ ଅଛି 25 ମସିହାରେ ଅଛି ବଟ୍ ଏନିୱେ ଆପଣ କାଲି ଆସୁ ତାହେଲେ ଟୁମୋରୋ ଫର ଅର୍ଡର୍ସ
ତୁମର ନେକ୍ସଟ ୱିକରେ ଆସ
ସୋମବାର
ମଙ୍ଗଳବାର
ମଙ୍ଗଳବାର ଫୋନ କଲେ ଟିକେ ବେସିକରେ ଆସନ୍ତୁ ବୋଲି କହିଥାନ୍ତେ whenever you are getting an opportunity for disposal of a matrimonial matter ଯୋଉଥିରେ କି ଟ୍ରାଏଲ ହେରିକା ଇନଭଲ୍ଭ ଷ୍ଟେ ହେଇକି ଅଛି କି ଷ୍ଟେ ନହେଲେ ପଡିକି ରହୁଛି ତ ତାକୁ ଆପଣ ଚେଷ୍ଟା କରନ୍ତୁ ସାରିବା ପାଇଁ
5ଟା 7ଟା ଡେଟ୍ ହେଲାଣି ସେ ଆପିୟର କରୁନାହାନ୍ତି ସେ ଜାଣୁଛନ୍ତି କିନ୍ତୁ ହଇରାଣ କରୁଛନ୍ତି ଇଣ୍ଟେନସନାଲି ଆଜ୍ଞା ହଇରାଣ କରୁଛନ୍ତି
ତାଙ୍କ ନାଁ ବାହାରୁନି କାହିଁ ଓକାଲତନାମା ନାହିଁ ନା କଣ
ନା ସେ ଆପିୟର କରୁନାହାନ୍ତି ଆଜ୍ଞା
ଆପିୟର କରୁନାହାନ୍ତି
ଅପୋଜିଟ ପାର୍ଟି ଆଡଭୋକେଟ ଆପିୟର କରିନାହାନ୍ତି
ଆପଣ କହିଲେ ନା ଯେ କଥା ହେଲେ ତାଙ୍କ ସାଙ୍ଗରେ
ଇଣ୍ଟିମେଟ କରିଥିଲି ଯୋଉ ଆଜ୍ଞା ଆଜ୍ଞା ଆଜ୍ଞା
ଆଜ୍ଞା ସିଏ ତ ଆପଣଙ୍କର ଏଇଟା କରାହେଲା କାହିଁକି ଯେ ରିମୋଟ ଲୋକେସନରେ ବି ଆପିୟର କରିପାରିବେ ଆଇ ଗଟ୍ ୟୁର ପଏଣ୍ଟ ଆପଣ କହିବା କଥା ଯେ ସେଠିକାର ଯିଏ କରୁଛନ୍ତି ଏଠି କେହି ନାହାନ୍ତି ଆପଣ ତାଙ୍କୁ କୁହନ୍ତୁ ସେଇଠି ଆପିୟର କରିବେ ରିସିଭ ହେଇଯିବ
ଡେଟଟା ଗୋଟେ
କୋଉ ଦିନ କହୁନାହାନ୍ତି ଆପଣ ଯାହା କହିବେ
19 ତାରିଖରେ
ଠିକ ଅଛି 28ଟାକୁ appearance ଦେଖିଲେ is submitted by Lord Counsel for the petitioner appearance देखले it is submitted by the Lord Counsel for the petitioner that she had an interaction with the Lord Counsel who is appearing for the opposite party in the trial court in view of the fact that no one is appearing on behalf of the opposite party despite the notice being sufficient. Stop. Office note indicates that the copy of this court's order as directed by order dated Bharati Kandha Dura. Directed by order dated 12/11/2025 as well as notice to appear before this court in the present proceeding has been served. Stop. The matter shall be listed for orders on 19/5/2026 on the said date. It is submitted by the Lord Counsel for the petitioner that she will request the Lord Counsel who is appearing for the petitioner before the Lord Family Court Sundargarh, na?
Family Court
before the
ବରଗଡ଼ ଟୁ ଟ୍ରାନ୍ସଫର ବଲାଙ୍ଗୀର କି ହବ
before the Bargad MAT case number
MAT case number 16
2025
ଆଜ୍ଞା
shall appear in VC to represent the opposite party. Let us see.
29
29, my lord, I'm praying for an adjournment as Mr. Dhara is not well.
ଆପଣଙ୍କର ନା madam?
Shruti Lekha Dhal.
You are Miss S Dhara.
Yes, my lordship.
ଆପଣଙ୍କ power ଅଛି S Dhara.
Yes.
Miss S Dhara for the petitioner. ଆପଣଙ୍କ ନା?
Your lordship, I am for the opposite party. Pratik Das.
Mr. P. Das for the opposite party. The matter is listed for admission for hearing under the heading for admission. Paucity of time intervenes. The matter shall be listed for admission in the week commencing 27/4/2026.
May I prefer one thing, your lordship? Copy may be served, and there is a high chance.
ଆପଣ notice sufficient ହେଲା କପି ପାଇଲେ ଦିଥର କେମିତି ଗୋଟେ କୋର୍ଟ କହିବେ ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ତାକୁ ରିକ୍ୱେଷ୍ଟ କଲେ ସେ ଦେବେ ନା ସଫ୍ଟ କପି ନେବେ ନା କଣ
ହାର୍ଡ କପି ହେଲେ
ସଫ୍ଟ କପି କୋର୍ଟରୁ ନେଇପାରିବେ ଆପଣଙ୍କ ଲର୍ନେଡ ଫ୍ରେଣ୍ଡକୁ ରିକ୍ୱେଷ୍ଟ କଲେ ସେ ଆପଣଙ୍କୁ ଆଉ ଗୋଟେ କପି ଦେବେ
My lord, I'm praying for the interim order may continue.
ଇବର କଣ ଥିଲା
For the stay of custody.
the interim order dated 18/11/2025 ଏମିତି କରନ୍ତୁ in the interim it is directed that upon a prayer being made before the allotted court in session of the matter, the CP number 350/2025 before the learned, pending before the learned Judge Family Court Jajpur shall be adjourned to a date beyond 31/7/2026 as would be convenient to the learned court in season of the matter.
Your Lordship,
And a prayer being made for the state purpose.
Your Lordship, as per the instructions, there is a high chance of settlement. Your Lordship,
Submitted by the learned
refer-
counsel for the opposite party that the parties are very much inclined to settle the matter to arrive at a amicable settlement acceptable to both. Both the learned counsel are requested to make their endeavor for arriving at an amicable settlement.
Lordship,
Yes.
The matter may be transferred, referred to mediation center.
Mediation रे कौन हो?
Mediation
ताकर
center.
कौन 24 power अच्छी की? Must understand transfer power is with the High Court. ଆପଣ ଯଦି ସେ ଲେଭେଲରେ ମିଡିଏଟ କରିପାରିବେ ଆପଣ ଆଗ କରାନ୍ତୁ ତାହେଲେ ଏଠି ହେଇଯିବ ମିଡିଏଟର ବୁଝେଇକି କରେଇ ପାରିବେନି ବୁଝିପାରୁଛନ୍ତି କାଉନସିଲିଂ ମେଡିଏସନ at different level different courts different stages is different. Yes. Yes, next.
Obliged.
Yes, please.
Item 33.
At 33 compliance affidavit has been received.
No, Your Honor.
Mr. Sarat Chandra Samal for the petitioner. Mr. Ansuman Sethi. You are appearing? Your Lordship. Mr. Ansuman Sethi, additional standing counsel for the opposite party. The learned counsel for the petitioner refers to the earlier orders passed by this court directing filing of compliance affidavit. Stop. The learned counsel for the learned additional standing counsel seeks further time. Stop. According to the matter shall be listed for admission in the week commencing.
My lord, how did the earlier question?
Yes, next.
Sir, मुझे कॉपीटा आजी पाइली जस्ट तो आजी पाइली कॉपीटा आईएटा जोटा फाइल करथले जस्ट
I provided the copy.
आजी पाइली.
Okay, okay. No issue.
May it please your Lordship.
Yes.
Lordship, I am for the husband.
Hey, hearing
I know, my lords. Paucity of time is there. Lordship, I have it on any day if you are.
तो 34 तक डेट कर दियो
Who comes in 13
13/7 second.
It's been listed, your Lordship, like for 5 times, but it's not.
The 25 matter.
My lords.
Just understand, we are starting after
Lordship,
notice.
the only reason is the child's health is, and the mother has not seen the child for the last 5-6 years. My
Yeah,
lords.
for vegetation and contact rate पे file करथिले की.
No, my lords.
କରିଥାନ୍ତେ ନା.
My lords.
The difficulty is that the original petition should be there for vegetation and contact rights. Let both the parties have their say, have their evidence or whatever. Let the court adjudicate. सेटा फाइल କରିବା କଥା ଆପଣ.
My lords.
Yes. Mr. Boral.
My lord.
Vegetation पे allow କରନ୍ତୁ. ଆପଣ ଏଟା prevail କରିବାକୁ ପଡିବ. Because natural guardian cannot be prevented from vegetation and contact. Custody ପାଇଁ battle କରନ୍ତୁ.
ସେଟା ସେ ମାନେ ଟ୍ରାଏଲ କୋର୍ଟ ହେଇଥିଲା କି ମୁଁ
ବର୍ତ୍ତମାନ ଯେହେତୁ appeal stage ରେ ଅଛି, you talk to your client. You can do it.
କଥା ହେଇଯିବି ମାନେ divorce ହେଇସାରିଛି.
Clear in your statement that no parent can be deprived of vegetation.
That's not right. My lord.
Ultimately, custody ପାଇଁ ତ definitely it is heavily loaded.
My lord.
Up to a particular age in favor of the mother or otherwise. Yes.
Gratefully, Lordship.
Yes, please.
35 may I please, your Lordship?
You are appearing.
My lord, we are filing the wakalatnama today on behalf of the opposite party.
Okay, Mr. Abhilash Misra for the petitioner. Miss
P. Patnaik.
Sorry, I'm so sorry. I forgot again. Your name?
Prakriti Patnaik.
Miss P. Patnaik, along with?
Satyasmuti Mahanti.
Along with Mr. Satyasmuti Mahanti, along with Miss Prakriti Patnaik for the opposite party. The office note, it is submitted by the learned counsel, Ms. Patnaik, that they have instructions to appear on behalf of the opposite party Wakalatnama shall be filed.
Yes, my lord. It has
So
been.
Wakalatnama has been filed in the
Today.
registry today.
Yes.
The Wakalatnama shall be taken on record, scanned copy be updated. The office note regarding regarding appearance of the allotted counsel for the opposite party shall be treated to be complied with.
Madam.
Yes. এটা কেবেকু ডেট করছেন আমরা?
ডেট ହେଇନଥିଲା ସେ ଇସ୍ୟୁ ନୋଟିସ୍ କହୁଥିଲେ କରିବା
আচ্ছা কেবে চাହୁଁଛନ୍ତି মিস পটনায়ক?
Anytime after the vacation, my lord.
The matter shall be listed for admission in the week commencing
27
27. Name of Mr. S.S. Mahanti and Ms. Patnaik, learned counsel for the opposite party, shall be mentioned in the cause list as well as the case file.
Obliged.
Yes. Next.
37
Yes, please go.
My lord, this matter is filed for transfer of CP 65/2025
Yes.
from Sambalpur to Devagad. In between, my lord, this petition
you are
has been
Mr.
dismissed.
You are Mr. Nath.
Nath, yes.
Mr. S.K. Nath for the petitioner. Other side kore gale.
They have not, my lord, 65/2025 has been dismissed for non-appearance.
Acha, already.
Yes, already it has been dismissed.
Kebe.
On as per their petition, that is dated.
Record re achi.
ନା ସେଟା ହଉଛି ସେ ଆଉ ଗୋଟେ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି ଡିଭୋର୍ସ ପିଟିସନ ଆଫ୍ଟର 1 year ସେଟା ଡିସମିସ ହେଇଗଲା ପରେ ତାକୁ ରେଷ୍ଟୋରେସନ କଲେନି
ଆପଣ ସେ ଅର୍ଡର ଟାକୁ ଫାଇଲ କରି ଦଉନାହାନ୍ତି କାହିଁକି ସିପି ଟା ଆପଣ କାଲି ଫାଇଲ କରିପାରିବେ
ଅଛି ଏବେ ଏଠି
ଦିଅନ୍ତୁ
ସିପି ଅର୍ଡରଟା ଅଛି
ଅର୍ଡର କପିଟା ଆପଣ ଫାଇଲ କରୁନାହାନ୍ତି ମେମୋରେ ସେମିତି ପଢାନ୍ତୁନି ଆପଣ କଣ ମତେ ଦେଖାନ୍ତୁ ମୁଁ କହୁଛି ଦିଅନ୍ତୁ ଏଇଟା ହଉଛି 61
ଏଇଟା ହଉଛି 61 ଏବେ ଫାଇଲ କରିଛନ୍ତି ସେ ଆଉ ଗୋଟେ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି ସେଟା ଡିସମିସ ହେଇଗଲା ସେଥିରେ ଆପିୟର କଲେନି ସେଥିରେ ଆମେ ଏଣ୍ଟ୍ରି
ଯୋଉଟା ଡିସମିସଲ ହେଇଛି ସେ ଅର୍ଡର ଟାକୁ ଆପଣ ମୋର କହିବା କଥା ଯେ ଗେଟ୍ ଦ୍ୟାଟ୍ ଅର୍ଡର 43 କହୁଛନ୍ତି ତ
ନା ସେଇ ଅର୍ଡର ଏଇ ପିଟିସନ ରେ ତାଙ୍କ ପିଟିସନ ରେ ସିଏ ଲେଖିଛନ୍ତି ଇଟ୍ ହାଜ ବିନ୍ ଡିସମିସ୍ଡ
କରେକ୍ଟ ସେଥିରେ ସେଇଟାକୁ ଏଥିରେ ସେମିତି ରିଫ୍ଲେକ୍ଟ କରି ହବନି ଆପଣ ଷ୍ଟ୍ରେଟ ଆୱେ ପ୍ରାଇମରୀ ଡକ୍ୟୁମେଣ୍ଟ ଟାକୁ ଆଣନ୍ତୁ
No, actually,
get it over even.
Well, I want to amendment this petition by CP 61 2026 instead of 65 2025.
ସେମିତି କଣ ହବ it's a separate cause of action.
ତାହେଲେ ଆଉ ଗୋଟେ ଫାଇଲ କରିବା
ହଁ ଆପଣ ସେଟା ଭାବନ୍ତୁ କାଲି କହିବେ ଯଦି କାଲି ଆସିବେ
ମାନେ ସେ ଟିକେ ଇନଷ୍ଟ୍ରକ୍ସନ ମିଳିପାରୁନି ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲୟର କୁ ଏନଗେଜ କରିଛନ୍ତି ଦେବଗଡରେ ଅଛନ୍ତି ସେ ଏଇ ଯୋଉ ଆମର
ଏଟା ଫେରେଇ ଦେବେ ଏଟା କେବେ ଆସିବ ତାହେଲେ
ଏଟା ଟିକେ ଗୋଟେ ୱିକ୍ ପରେ ଲାଷ୍ଟ
ନା ଆଫ୍ଟର ଭେକେସନ
ଆଫ୍ଟର ଭେକେସନ ରଖିଲେ ଚଳିବ ଆମେ
ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ
ଆଜ୍ଞା ସେଇଟା ଆଣିକି ଡିସମିସ୍ କି ଏଟା ଗୋଟେ ଫାଇଲ କରିଦେବୁ
ମିଷ୍ଟର ଏବେ ଶକୁନ୍ତଳା ଘୋଷ and S.K. Nath for the petitioner opposite party blank none appears for the petitioner for the opposite party when the matter is called it is submitted by the learned counsel for the petitioner that the CP that is sought to be transferred as in the meanwhile being dismissed due to non-prosecution.
Yes, ma'am.
CP dash like this. CP dash before the CP so and so before so and so has been dismissed due to non-prosecution. He submits that the matter may be adjourned to obtain further instruction. The matter shall be listed for orders in the week commencing. But I think you should file that application afresh because you
got to file again.
Juxtapose the cause of action. Yes. Next.
38.
Ms. Satabdi Samantraya for the petitioner. On other side nahanti?
Nahanti appear କରିଛନ୍ତି lordship.
Manoj Bihari Das ଅଛନ୍ତି ତ?
ଆଜ୍ଞା.
ସେ ଗୋଟେ agree କରୁଛନ୍ତି କିଛି any instruction କୋଉଠି ଗୋଟେ particular ଜାଗାକୁ?
ଆମେ ତ ପ୍ରେ କରିଛୁ କଟକ କୋର୍ଟ ଏଥିପାଇଁ କାରଣ ଆମେ ଯୋଉ ଡିଭୋର୍ସ ପିଟିସନ ଫାଇଲ କରିଥିଲେ ପ୍ରୋସିଡିଂ ଫାଇଲ କରିଥିଲେ ସେଥିରେ ଅଲରେଡି ସେ appear ଏଣ୍ଟର କରିସାରିଛନ୍ତି appearance
ମୋର କୋର୍ଟ ଟାଇମ କେତେ 8:15 ନା 4:30 after vacation
interim order may be continued lordship.
But the thing is that ଆପଣ ଯଦି ସେଟାକୁ କରିପାରନ୍ତେ agree କରିପାରନ୍ତେ for any third place also where both of you will agree like you have seen that 30 they agreed for Sundargarh
ऑलरेडी आमे जो फाइल करछु डिवोर्स प्रोसीडिंग फाइल करछु फैमिली कोर्ट बिफोर लॉर्ड जज फैमिली कोर्ट कटक सेथरे ऑलरेडी अपोजिट पार्टी अपीयर करि सारिछंती तो एटा किछि प्रॉब्लम होबो जदि ट्रांसफर हे जाउची
Hey, in their absence, I cannot pass that order.
then your lordship kindly adjourn the matter.
Put the none appears for the opposite party as the matter. When the matter is called, almost at the end of the day's proceeding, stop. The learned counsel for the petitioner is present. She seeks extension of the interim order dated 8/4/2026. Accordingly, it is directed CP number 36 of 2026 pending before the learned judge family court Jagatsinghpur shall be adjourned to a date. केबे कोटा रखिबे?
नेक्स्ट डेट सीडी फैमिली कोर्ट रे तो अछि 25
To a date beyond 27/7/2026. As it be convenient to the learned court in session of the matter, the matter shall be listed for orders in the week commencing 27/2026. Yes.
Sorry. I think that was-
Yes. Order.